committee for a while this morning. So good morning. This is, and welcome to the Friday morning meeting of the Criminal Justice and Public Safety Committee. My name is Charlotte Warren, and I'm going to start having folks introduce themselves, and I'll start with Senator Searway.
Good morning. I'm Senator Scott Searway and represent District 16, which covers Waterville, Winslow, Fairfield, Benton, Albion, Clinton, and Unity Township.
Thank you, Senator. Next up, we have Senator Mark Lawrence.
Good morning. I'm Mark Lawrence, State Senator from Southern New York County along the New Hampshire border. I represent the towns of Kittery, York, Ogunquit, Elliott, South Berwick, and half of Berwick.
Thank you. Next up, I see Representative Morales.
Good morning, everyone. My name is Victoria Morales, and I represent House District 33 in South Portland.
Thank you, Representative. And now Representative Rudnicki.
Good morning. I'm Representative Shelley Rudnicki. I represent House District 108, which is Fairfield, Mercer, and Smithfield. And I am live at the Capitol, and I am still here under protest because we adjourned a couple of months ago. Thank you.
Thank you, Representative. And now Representative Costain.
Morning, Madam Chair. Dan Costain. I represent District 100, which is part of Etna, Dixmont, Newport, Plymouth, and Corunna.
Thank you. Representative Pluker.
Thank you, Madam Chair. I'm Bill Pluker from House District 95, which is Warren, Hope, Appleton, and part of Union.
And Representative Pickett.
Morning, Madam Chair. My name is Dick Pickett. I represent House District 116, the towns of Canton, Pittsfield, Hartford, Mexico, and Peru.
Thank you, Representative. And Representative Newman.
Thank you. Good morning. I'm Dan Newman, District 76, which is Belgrade, Rome, Mount Vernon, Fayette, Vienna, and Wayne.
Thank you. And we also have the brains of the operation, Deb Fay, our clerk, and Jane Orbiton, our analyst. Thank you both. So let me start. And I'm Charlotte Warren, and I represent the city of Hollowell and the towns of Manchester and West Gardner. We have a day filled with public hearings. Let me start. I failed to give Deb this information ahead of time, although I meant to. Let me give everybody the order that we'll take the bills. We are going to start off with Senator Lawrence with LD 1351. And then we're going to go in numerical order, which means we'll go 1478, 1588, 1593, 1674, and finally 1675. So I will start right off by welcoming Senator Lawrence to present his bill.
Thank you very much. And it's my pleasure to present LD 1351, an act to amend certain provisions of the Maine Criminal Code and the Maine Bail Code. And it's also my pleasure to make your lives much, much simpler. This was a bill that the district attorneys, two of the district attorneys asked me to put in on their behalf. I did put it in, and they've now decided not to go forward with it. So I'm going to respectfully request that the committee give this bill and ought not to pass.
Thank you,
I'd be happy to
Senator.
answer any questions.
Wonderful. Thank you, Senator. I think we have our first question or statement or motion by Representative Pickett.
Thank you, Senator, for those wonderful words of encouragement this morning on a long day. I will make a motion ought not to pass at your request.
And I'll second it.
Representative, would you make a motion that we suspend the rules and go directly into work session?
Yeah, that's right. We're going to do that.
Yes, I will make a motion that we suspend the rules and move to work session.
Second.
Great. So we have a motion on the floor to suspend the rules and go into work session, and we have a second. All of those in agreement, please just raise your either electronic or real hand. And it looks like we all agree. Beautiful. And now I'll go back to Representative Pickett.
And now I'll make my motion ought not to pass.
Thank you, Representative.
And I'll second it.
Seconded by Senator Searway. And now we'll do an official roll call of an ought not to pass motion.
I think I hear a cat trying to vote.
It's
I don't know if
mine.
that's allowed.
It's my 18-year-old cat Mojo.
Video on, and please unmute for a roll call vote. Representative Warren,
Yes.
Representative Morales,
Yes.
Representative Sharp is absent, Representative Lookner is absent, Representative Pickett,
Yes,
Representative Costain,
Yes.
Representative Rudnicki,
Yes.
Representative Newman,
Yes.
Representative Pluker,
Yes.
Representative Reckett is absent, Senator Lawrence,
Yes.
Senator Searway,
Yes.
and Senator DeChambeau is absent. So that's 9 yes or ought not to pass LD 1351.
Wonderful. Thank you, Deb. Thank you, Senator Lawrence. And I'll just report to the committee that 15 minutes in and we've already completed 1/6 of our work today. So we're pretty awesome. Thank you, Senator.
You're welcome.
Next up, we have LD 1478, and this is Representative Morales.
Thank you, Madam Chair. Representative Warren, my friends on the Criminal Justice and Public Safety Committee, my name is Victoria Morales. I represent House District 33 in South Portland, and it is my honor to sponsor LD 1478, an act to decriminalize homelessness. I'd like to start out today by talking about values. Most of us have been taught all our lives that if you work hard, you will make it. In our society, we value making it and those lives that achieve that status. We value those who, as the saying goes, pull themselves up by their bootstraps, despite the fact that it is physically impossible to actually pull oneself up by their bootstraps. The underlying assumptions we form from this value construct is that those who aren't making it in life are personally and solely to blame for their situation and are somehow less worthy and therefore less valuable. But on this committee, we in fact know the opposite is true. We have heard from experts, persons with lived experiences, and from our own Commissioner of Corrections and many Maine sheriffs that this value construct is wrong. In fact, the majority of the people who enter the doors of Maine jails and prisons today are there because they have experienced trauma, violence, poverty, addiction, disease, oftentimes starting from the day of their birth, all of which form insurmountable hurdles that no matter how long and strong their hypothetical bootstraps are, they'll never be able to get over the hurdles. Because we know this, we must reject the old value construct that places less value on certain people and instead maintain that all people have value. What I am asking you all to think deeply about today is how this value system, which has been in place for a very long time, is how we justify incarcerating those who suffer greatly from larger societal failures in the name of public safety. This committee knows better than anyone else how to create public safety. You may all remember when Peter Lehman from the Maine Prisoner Advocacy Coalition testified about this issue, and I haven't been able to get it out of my head. I'm sure you all remember, and I'll paraphrase. He said that we create public safety by reducing recidivism, because when we reduce recidivism, that means we reduce the number of victims. And the less victims we have, the less we need to send people to jail, and the more safe our communities are. We have heard over and over from our sheriffs for years that their jails are really glorified emergency rooms, but without doctors or nurses, and that jail is ill-equipped for this role. I'm going to state the truth that we know that jailing those who are experiencing homelessness and suffering from unmet physical and mental health needs doesn't solve homelessness. Jailing those who are experiencing homelessness and suffering from unmet physical and mental health needs does not make our communities safer. It is simply an endless revolving door with the same people being jailed every Friday and Saturday night and then return to the streets in the same condition, or oftentimes worse, on Monday. So before I go any further, I want to ask you all a question. If you believe that arresting and jailing our most vulnerable Maine people, and I think we agree that some of our most vulnerable are the 200 or so chronically homeless individuals in Maine, if you believe that arresting and jailing those who have unmet physical and mental health needs and often suffer from severe and persistent mental illness and substance use disorder is in fact the solution to homelessness, then you should probably vote against this bill or any version of this bill that we can work on together. However, if you believe, as I do, that there are other ways to address homelessness and public safety and to save lives, like, for example, providing people with homes and treatment, then stick with me for a few more minutes. In Maine, we are talking about a small group of people who are chronically homeless. Approximately 200 Maine people are the longest stayers in homelessness, the most difficult to house, the ones who ricochet through the most expensive systems we have, our shelters, being policed on the streets and prosecuted in courts, ending up in our jails and emergency room. And in Maine, our homeless providers know each of these people by name. In addition to the failed human results of our current homeless system that allows this ricochet game to happen day after day, each of these systems come at a tremendous cost. It is estimated that it costs at least $1 to $3 million per person caught in the homelessness and the criminal justice systems, depending on how young they were when they entered. Multiply the lowest amount, 1 million, by 200 people, and you get $200 million that we spend to keep people homeless in Maine. The alternatives have better financial and human outcomes. They save lives. Housing costs approximately $7,500 per year per household, according to Maine Housing. Add on to that $3,000 to $5,000 in treatment and supportive services, where studies show that 95% of those in the very deep end of homelessness will be successful and never fall back into homelessness. Based on housing first models in Maine and the investment the federal government makes to rapidly rehouse veterans who are experiencing homelessness, we know that these models work. Just imagine if we were to use the money we spend to keep these folks homeless in the criminal justice system, we could house over 13,000 people in Maine. Knowing what works, I ask this question: do you want to work together to actually solve homelessness? If the answer is yes, I ask the next question. Since we know what works and what doesn't work, what is holding us back? Our duty as policymakers, and we do this day in and day out, is to recognize when the tools we are using to solve a problem do not work, and to work on finding solutions that do work. This, in fact, is our only duty as lawmakers. It is important to note that there are over 5,000 adults and children in Maine who are transitionally homeless, in addition to the 200 chronically homeless. Because our inefficiencies in operating the current homelessness system results in spending the majority of our resources on those in the deepest end of crisis, we have very little left over to help those who need just a little bit of help to get back on their feet. But because we exhaust all of our resources inefficiently with the criminal justice system, primarily on the 200 of the most chronically homeless, we fail everyone else too. We must, in Maine, set a goal to end homelessness in this state and to follow best practices and data to do it. And we must start by acknowledging that using the criminal justice system to address the unmet physical and mental health needs of houseless people in crisis is wrong. It doesn't change behavior. It doesn't provide accountability. It makes it more likely that a person will never get housed because now they have a criminal record, and it doesn't create public safety. The intent of this bill is to create a public health evidence-based response to the symptoms of homelessness as follows. A homelessness crisis protocol, instead of arrest and prosecution, created by the Attorney General and adopted by every law enforcement agency in the state, will be followed for those experiencing homelessness who are engaging in unlawful, nonviolent behaviors such as loitering, being loud and engaging in public disruptions, urinating and using drugs and alcohol in public places. The protocol must include a response by mental health and substance use disorder professionals trained in crisis response to be able to de-escalate situations and provide resources and referrals to crisis services, emergency and transitional housing, healthcare services, treatment, and case management. I thank you so much for the opportunity to bring this policy to you today, and I look forward to working on it together and with all of the stakeholders and the many folks coming after me to testify as we move from today to work session. And I'd be happy to answer any questions.
Thank you, Representative Morales. Any questions? Yes, Representative Pickett.
Yes, thank you, Madam Chair. Thank you, Representative Morales. The only question I have at this point is, I've read through the bill. I've seen what the bill proposes to do. Now, I would ask you if you have considered, or what is your thoughts on where's the funding going to come from to accomplish this mission? Because there's a lot of different people involved here, rightfully so, but we're talking a lot of money. I'm not trying to put money as the focus point here, but we got to have a way to fund it. So have you given any thought to that?
Absolutely, Representative, and thank you for the question. What I really was trying to highlight, not only in this bill that the current practice and the current strategy isn't working, is that it's also very expensive. And so we're utilizing resources that don't work. And so if there is a way, and I think this committee is uniquely positioned to really understand these issues and understand how best we can resource the solutions that work and work with all of our departments together to get there. I believe that there is the funding available. We are not using it appropriately. And you may know a piece of legislation that I've been working on, and I don't know if I'm able to talk about it at this juncture, and I won't name it, but it talks about bringing together prosecutors and shelters and emergency rooms and sheriffs to think about how are we using our resources that's costing what I told you was between $1 million and $3 million per lifetime of each person caught in this system. How can we better use those taxpayer dollars so that those people get out of the system and they never go back into the system, and we move those resources into a housing and treatment model that's based on public health and science.
Thank you. Follow up?
Yes, please.
Thank you, Madam Chair. And I hear exactly what you're saying, Representative, but I think we have to be very careful as we look at the overall picture here. We have a lot of other really important things within the state and other important people on wait lists, people that are suffering from disabilities that of other kinds, that is not addiction, is not homelessness. So I understand what you're saying, and I wish there was a magic wand we could wave to take care of all of them at one time, but we have to really take a look and have to really prioritize. And I think we've been put in a bad situation, in my opinion, with the recent budget that we passed, because we don't know what the underlying expenses are going to be moving forward, which kind of puts us behind the 8 ball. I think you're right on one thing. You said we all are on the same page. We all want to do this. We all want to help people. But I think we're going to have to really take a real hard look of how this is going to be funded and how this is going to work. And again, we're putting more and more job descriptions and on our law enforcement through this bill as well. And public safety is not the enemy. Public safety is the one we're asking to be the savior, but yet we're not doing a whole lot of things to support them either. Thank you very much.
If I may provide a quick response to that, Madam Chair.
Yes, please.
I will just add, and I agree with you, Representative Pickett, it is a financial conundrum that is our duty to solve. I would submit that we have an opportunity that we've never had before, where there are crisis services funding mechanisms that are coming to the state of Maine through the American Rescue Plan. And we've never seen this kind of money before. We have money coming in from the federal government to address housing of our most vulnerable folks, As you well know, we have 25,000 households on the waiting list for Section 8 vouchers in Maine. Those are families, those are children, those are folks with disabilities, those are folks experiencing homelessness. So we have an opportunity that if we put our heads together, I think we can come to a solution where we can prioritize our most vulnerable Mainers. Thank you.
Senator Searway.
Thank you, Madam Chair. Thank you, Representative Morales, for bringing this forward. I was on Veterans and Legal Affairs Committee, and we had a similar situation or bill like yours. And they had 113 homeless veterans, and they've reduced it down to like 13 or 14 now. And so I would say if you could get with the director or General Farnham, or they will direct you who's in charge of that, and probably come up with a similar model. And I think that it would really be something that maybe you might want to just carry this bill over for next session, but in the meantime, get that model figured out. And I think it would really work well. Just that's my recommendation, because it did work. So, and it takes away, I mean, there are crimes made and they have to be held accountable, but this might be the way to get them into this, to get them from homeless to something. And I think I wouldn't change what we're doing, but I think we could come up with a model of how we can get them into there. So it would really work. Thanks.
Thank you,
Thank you
Senator.
so much for that question and that comment. And you hit the nail on the head, Senator. We know how to solve homelessness. And in fact, the way we solve homelessness with our veterans is the model that works. And that's the rapid rehousing model. In Maine, we rehouse veterans within 60 days. And you're right, we have brought those numbers down. And that is exactly what this bill is based on. And that's exactly, as you know, in my day job, I work in housing. Actually, it's more like my night and weekend job now at this juncture in the session, but I work on housing. And what we know is that when we house folks with supports, just like we do for our veterans, 95% of them stay housed. So I thank you for that. And I would just add that I think if we were to design all of our programs for our most vulnerable folks the way we do and fund our veterans programs, we would solve so many problems. So thank you for that suggestion, and I will absolutely do that.
Seeing no more questions for Representative Morales. Thank you, Representative Morales. Any other sponsors or legislators here to testify on LD 1478? Please raise your hand if you are. Seeing none, I'm going to now take general testimony from folks who are here in support of 1478. Please raise your hand and Deb will bring you over.
I'm bringing over the first three. Lots of hands up.
Thank you. Deb, could you bring over Mr. Skinner?
Yes.
Thank you. Good morning, everyone. I know we have a special expert here to share some information, so I'm going to start with you, Mr. Skinner. Thank you for being here, and then I'm going to go to Jocelyn Davis, Michael Cabetta. We'll start with that order.
Thank you for having me. I'm Patrick Skinner from Savannah, Georgia.
Welcome. Take it away.
Thank you. So I'm a police officer in Savannah, Georgia. I'm speaking for myself, not my department. And so over the last 4 years, I've been kind of deeply immersed in the issues that you're talking about. And I'm from the beat cop side. And so I'll quickly explain what I see almost every day. So 70%, 75% of the calls that we go to are not crime. They're not. They're usually homeless or substance abuse or mental illness or just variations of disturbance of the peace, which actually aren't even disturbances of the peace. They're just 911 calls based on this person makes me uncomfortable. And so because we're a 911 nation, when you call 911, the police come. Unless your house is on fire, it's going to be the police. And so even though it's not a police matter or a criminal matter, at least at that point, it is a police matter because you called the police and the police are we have to show up. And so I hear a lot of talk about how the police do all these things that they're not trained to do or that aren't part of their job. And that's not an excuse. It's true, but it's not an excuse. And it always stops there. The argument always stops there. Like, well, police aren't social workers. Well, police aren't mental health clinicians. Well, police aren't homeless advocates or, homeless resources. They're not. And then they just stop. And so the conversation always stops there. And then we get, okay, we're heroes because we do. But then the answer is, how about fund every single thing else that leads to that 911 call? And so, because what we're doing right now is broken. And so Savannah has a very, very large homeless population. It's warm. It's relatively accommodating city. We try to embrace a neighbor concept of law enforcement, which is the opposite of a warrior, us versus them concept. But even with us, we still struggle every day. And we're in a situation, and other police officers, I believe, are in the Senate, former police officers, and they have done the same thing, where you're in a situation where the best thing is to arrest somebody. That's insane. And so the best thing, and it happens a lot of times, is to get this person help by arresting them. And I'll say that again. Yeah, there might be, of course, it's a legal arrest because there's some technical violation of a law. That's not the point. The point is the best thing for the person is arresting them. No, it's the easiest thing. It's the only thing usually because shelters are full. There are no resources. Behavioral health units aren't set up. And so I see this every single day. And it's, you could not devise a more expensive, counterproductive, ineffective way. And I'm increasingly motivated that I see this. Well, there's only two options: either keep doing it wrong or do nothing at all. And I reject that. I reject that in everything because nothing is like that. But it's particularly in this issue of homelessness, where, well, the criminalization of homelessness, we, the police, are telling people to move along who have nowhere to move along to. And that starts generating some friction. And friction is what we're supposed to avoid. We're supposed to, smooth these rough edges. The incarceration of people, the criminalization of being poor, heaven forbid somebody's not spending money at a place. These are all massive issues. Now, businesses have real concerns. There are real concerns. Someone driving away business is a problem. Somebody, doing illegal drugs is a problem. Those, of real loud disturbance is an issue. You'd have to work on that.
Thank you, Officer Skinner. I'm going to ask you to wrap up your testimony and then we'll go to questions. We do have a 3-minute clock.
Oh, sorry. I don't even know what time it is. Okay. Yeah. So I support this because I support anything that tries to change what we're doing, because what we're doing does not work. And tinkering around the edges, and it's just, this is the most ineffective, unjust, and expensive way to do this. Thank you.
Thank you, Officer Skinner. I'm going to take questions now for you, and we're going to start with Representative Pluker.
Thank you, Madam Chair. Officer Skinner, could you just talk about this idea of having a protocol around how you're handling homelessness and folks who are homeless, and how that helps just improve your situation as you, I think you referred to yourself as a beat cop, put in this situation, and it gives you the tools to move forward?
Sure. So right now it's kind of like we're trying to move towards it. So it still involves the police heavily. We've been instituted a behavioral health unit, which are, they're still sworn police officers wearing basically non-police outfits. but they're accompanied with a clinician or a doctor or a social worker. The beat cop goes to a call. They can quickly assess, okay, this is a mental health crisis. This is a behavioral health issue. This is a homeless, whatever the issue is, which is part of the 75%, which is not crime. And so they call for that unit. That unit right now, we have, I don't know, 650 sworn officers. It's a pretty big department. We only have 2. We have 1 unit for this. And then they go and handle that. And then because they have the resources, they can put people into shelters. They can put them into, stabilization units. I mean, we can do that too, but it's a 1013, commitment issue. And the whole point is to keep them out of the system. And so right now it still involves the police. And so it saves us time on the street, I guess, because we're not, transporting, we're not making arrests, we're not doing all that. It saves a lot of money for the taxpayers. It just needs to be expanded because at some point you're going to want to, that 911 call, it shouldn't be involving the police at all. Right now it hasn't been a year. It's really effective, and they're overworked because every beat cop, you hear them call, hey, can I get the BHU? Because it is so refreshing to have some kind of options other than do nothing or do it wrong.
Thank you.
Other questions for Officer Skinner? Seeing none, thank you very much for joining us this morning.
Thank you for the opportunity.
Up next, I have Joe Davis. Welcome.
Hi. All right, thank you. I'm Joe Davis. I'm a resident in Portland, Maine. I'm here today because there are people that I care about that are homeless and are currently being negatively affected by the lack of resources available to them. So I'm testifying in favor of LD 1478. People experience homelessness for a variety of reasons, including but not limited to lack of resources, domestic abuse, discrimination, gentrification, a criminal record, and being paid non-living wages. None of those reasons involve them as the reason they are homeless because it's not their fault. Adopting the homelessness crisis protocol would start to focus resources on harm reduction strategies on the current housing crisis rather than police intervention. It is important to find out what people need to make those resources available and accessible to them. That is what harm reduction is all about, meeting an individual where they are at. If an individual is seeking shelter in a public space, they need a home and resources, not police. That just makes sense. Alternatively, we are also asking police to facilitate a public health and social service issue. I have heard an account of 2 individuals in Portland, Maine, that were approached by police multiple times. The police would ask them to leave over and over again in places that they were seeking shelter in a public space. Their substance abuse recovery, search to find jobs, and stable housing was put on hold as they had to move around after being asked by police to do so. Adopting the homelessness crisis protocol could have been an opportunity to connect these individuals to resources to actively help them. Instead, it only exacerbated homelessness and the recovery from substance abuse. It additionally would remove police out of the equation. Connecting unhoused people to resources and housing should be our #1 priority. It is time to shift our efforts and resources from police reinforcement and intervention to harm reduction strategies. I encourage everyone to vote in favor of LD 1478. Thank you for your time.
Thank you for your testimony. Any questions for Joe Davis? Seeing none, thank you again. And good morning, Michael Cabetta. Welcome.
Thank you, Representative Warren and members of the committee. Good morning. My name is Michael Cabetta. I'm Policy Counsel for the ACLU of Maine. And on behalf of our members, we urge you to vote that this bill ought to pass. This bill is an entirely appropriate response to our intertwined crises in healthcare, policing, housing, and racial inequity. Indeed, similar programs in other states have proved to be both fiscally and socially responsible. Much of this committee's recent work has been profoundly influenced by the past year's increased attention on police killings of civilians. it has come to light that a large share of the civilians who die or are injured at the hands of police had a mental illness or were experiencing a mental health crisis. Here in Maine, according to data provided to the Press Herald by the Maine Attorney General, 42% of people shot by police since the year 2000, and 58% of those who died from their injuries were experiencing a mental health crisis. Consider these data, along with the fact that more than 1 in 5 people experiencing homelessness also identified as having a mental illness, according to Maine Housing. This committee has also debated and analyzed youth justice in Maine, an issue deeply linked with homelessness. According to the Bangor Daily News, between 2015 and 2017, the number of homeless or displaced youth jumped from less than 2,000 to more than 2,500, an approximately 30% increase. Due to the coronavirus and record unemployment in Maine, we can expect this year to be even worse. Moreover, unhoused people are disproportionately people of color and people with disabilities. In 2019, for example, Black and African American people made up less than 2% of Maine's population, but a staggering 26% of Maine's unhoused population. And finally, intimate partner violence is a key driver of homelessness. And intimate partner violence often leaves psychological scars, which a mental health professional is better poised to respond to than a police officer. Now, I've heard members of this committee comment on how awful it is that we have so few applicants to police departments throughout Maine and throughout the country. Part of the reason for that will be solved by this bill. This bill will save civilian lives. It will make Maine more humane, especially to its most powerful residents, and it will make law enforcement a more attractive profession to prospective applicants. We urge you to vote ought to pass, and I'm happy to try to answer questions.
Thank you, Mr. Cabetta. Questions for Mr. Cabetta? I spent some time yesterday speaking with a couple of our Maine sheriffs, and what we spent most of our time talking about was what they are dealing with mostly, which is just their frustration around mental health and the, just the overpopulation that they're dealing with. So my question for you, Michael, is wouldn't you suggest that all of my amazing colleagues on this committee talk to their sheriffs before we work this bill about what they're dealing with around mental health services in their county jails?
Representative Warren, I couldn't agree more. That's one thing I would suggest, but I would suggest another thing, which is to call the police chief of the city of Denver in Colorado. His name is Paul Pazin. And even before the events of the last year, the Denver Police Department decided to institute a very, very similar program. They called it the STAR program. And the police chief in that city had agreed to do this long before the protests of the last year. And that program has saved the police department and the city of Denver money and has made policing a safer profession for everyone involved, and has made policing a more attractive profession as a result. So I would suggest the members of this committee actually just call the city of Denver and find out why the police chief there decided to go this way, and whether it would be a good idea for Maine.
Thank you. Senator Searway.
Thank you, Madam Chair. I'm glad you mentioned the STAR program, because I've heard that about that, and it seems like it is a good avenue. I do think that we've been very successful with the VA model, and I think that that they have a person that's in charge of finding these homeless people and working with them and trying to get them housed. And I do think that there's always been a big problem ever since I've been in law enforcement of mental health, and I was on the committee for TOGUS, the VA, TOGUS and AMHI, and we tried to work together, and but then when they took AMHI away, that really hurt us a lot. And so I don't know, the resource is gone. So that's a big issue and we have to find that resource. And I guess that's where a big gap is. So what's your thoughts on that?
Well, I think the closest alternative we have to MHI now is Riverview. And it's just not doing what it could be. And prisons and jails are stepping in to fill the gap. I think it's just that simple.
Wow.
When such a staggering number of the people who are jailed and the people who are arrested and the people who die from police involved shootings have a mental health challenge or are facing a mental health crisis, the answer is clear. Just invest in your system for housing and healthcare. And this bill is a step in that direction. It won't solve all the problems, but it's a step in that direction.
Yeah.
I think it deserves the enthusiastic support of the entire committee.
Thank you.
Absolutely. Thank you, Senator.
Any other questions for Michael Cabetta? Seeing none, thank you. Next, I'm going to go to Mickey Rice, and then Tina Neto, and then Anthony Lombardi, I think it is. I can't see the end of the name. Good morning, Mickey.
Good morning. Thank you. So I'm not going to read my written testimony that I put through. I'm going to tell you a quick story. So I'm Mickey Rice. I live in Freeman Township. I used to work as a resident services coordinator for Eagle Point Management. And what that was is Eagle Point owned about 6 buildings that were Section 8 or tax credit approved. Most of them were elderly disabled designated. So I was the resident services coordinator, so I was pretty much a case manager for anybody that lives in the building. It's something that's funded through the state of Maine, and it's to keep people in their housing and to keep them from experiencing homelessness. Well, we had this one resident one woman that lived in our buildings, and she had a diagnosis of schizophrenia. Well, she started, when she first moved in, we had some issues with housekeeping. I was able to work with her and we got that taken care of. And she was an awesome tenant when she wasn't going through one of her relapses. So she started going through a relapse, and she started going outside in the middle of the night and yelling at somebody. She thought it was a sibling or something like that. And she'd be yelling in the middle of the street, in the middle of a city. And it disturbed a lot of people. So the cops got called. They'd come, they'd ask her to calm down. By the grace of God, get her back into her apartment. And they'd no sooner leave again, and she'd go outside and she'd start screaming again. So they had to end up coming back like 4 or 5 times. And because I'm only 9 to 5 in that position, it was only a 9 to 5 job. I didn't carry an on-call cell phone or anything. I found out the next morning. So I was ultimately able to work with this woman, get her into her doctor, who she hadn't gone and seen for like 4 or 5 months because she was getting to the point she was scared to leave the house. And I was able to get her into her doctor, go to the doctor with her and get her the services that she needed to get her schizophrenia back under control. This is also a woman that had experienced chronic homelessness before moving into our building. There's many reasons why people become homeless, and if they're a person that experiences chronic homelessness, going to jail isn't going to help. They need services that help them with that core reason on why they keep getting evicted from places and why they keep experiencing that chronic homelessness. We cannot not pass this because you don't think we have the services. I mean, it could take years to build up the housing that we need and everything else. It's not a reason not to pass it. Maybe it will show people that we actually need these services more than you think. And for that reason, I urge you to support this bill. Thank you. And I'm willing to answer any questions you may have.
Thank you very much for your testimony. We're going to start with a question from Representative Pickett.
Yes, thank you, Mickey, for being here. Just wanted to say I did get your call last night. I'm sorry I didn't get a chance to answer it, but thank you very much for the call. The information was very helpful. Thank you.
Awesome. Thank you.
Any questions for Mickey Rice? Seeing none, thank you very much for providing testimony. Up
Thank you.
next,
Have a good rest of your day.
you too. Up next, we have Tina Neto. Welcome.
Thank you, Representative Warren, and thank you, Representative Morales, for bringing forth this bill. My name is Tina Nato, and I am the Executive Director of the Maine Association of Criminal Defense Lawyers, and I'm testifying wholeheartedly in support of this bill. Decriminalization of low-level victimless crimes that our unhoused clients are charged with time and time and time again could make a huge difference in our clients' lives. Re-inject some humanity and sense into how we treat our fellow human beings, and take the burden off law enforcement and county jails to arrest and house the homeless as their cases wind through the criminal legal system. Criminal trespass is one crime that our clients face constantly. One of the biggest reasons clients are arrested for this crime is because they have been trespassed from local shelters and resource centers and have no other place to go. Disorderly conduct, which includes being loud or fighting, is a great charge to arrest people in the streets and lock them up for the night. That does nothing to help ensure that the incident won't happen again. People urinate in alleyways and on the street because they have no public restrooms available to them. There is some issue, I think, in the bill regarding the use of drugs, which is not a crime, but that's a small detail. Drinking in public is used almost exclusively as a tool to arrest and move along unhoused people who are drinking alcohol in public for the simple reason that they have no private place to go. Pay $12 for a glass of wine at David's and you can sit on Monument Square and have a lovely evening. Sit at the Monument Square monument and drink out of a paper bag and you're going to jail. In Portland, Bangor, and Lewiston in particular, severe policing of these homeless crimes has done nothing to improve public safety or connect unhoused people with the services, primarily housing, that they need to ensure that they get onto a better and healthier path. You want to cure homelessness, keep our neighborhoods safe, quiet, and clean, and improve quality of life for everyone in our community. If you want to do that, you don't keep locking people up. You fix the problems that need to be fixing. You need to ensure that people have safe homes, warm beds, good shoes, hot meals, and medical care. You provide the stability and support needed to get people on their feet again. Or you can keep paying police, corrections officers, prosecutors, judges, and yes, even defense attorneys to continue this macabre dance of despair indefinitely, improving nothing, spending money, wasting time, and wasting lives. Which do you support? I'd be happy to answer any questions.
Thank you, Ms. Neto. Any questions? Seeing none, thank you very much for your testimony.
Thank you.
Up next, I have Anthony Lombardi. Good morning.
Good morning, Representative Warren, and great work on remembering my last name. Apologies, it's the Sicilian extra letters. Representative Warren, honorable members of the Committee on Criminal Justice and Public Safety, good morning. My name is Anthony Lombardi, and I'm a legal fellow at GLBTQ, Legal Advocates and Defenders, New England's leading legal advocacy organization for the rights of LGBTQ people. And I'm also a lobbyist associate of Mary Bonato, who lives in Portland. Glad to support LD 1478. And before I could submit the testimony, afterwards actually, I heard back from Equality Maine, the state's statewide civil rights organization for LGBTQ people, that they also want to support. Criminalizing homelessness when paired with the barriers of reentry after serving time creates a vicious cycle or revolving door of homelessness and incarceration. Research suggests that formerly incarcerated people are almost 10 times more likely to be homeless than the general public, and that individuals who have been incarcerated multiple times are twice as likely to be as homeless as those who are returning from their first prison term. Recent data analyzing the homeless population in neighboring Connecticut also found that when considering individuals with overlap between shelter use and incarceration, most formerly incarcerated people, 69% of them in the sample, were homeless before their initial incarceration. When law enforcement is enforcing an offense such as sleeping in public spaces or other low-level offenses committed in public, individuals are pushed back through the criminal system, adding additional offenses to their records and making their likelihood of future homelessness and therefore future incarceration and so on more likely. LD 1478 would stop this nightmarish carousel, cycling people through Maine's system and the streets. The reason why I'm glad supporting this, besides the general equity concerns, is also for equity concerns for people that are more likely than not to enter the cycle than others. Focusing here on LGBTQ people, this community, and especially LGBTQ youth relative to the general population, are more likely than their cisgender or heterosexual counterparts to experience homelessness, exposing them to frequent interactions with law enforcement and the criminal legal system. And research demonstrates that the LGBTQ community faces alarming rates of discrimination in housing as well, which can lead to homelessness. These issues of discrimination are even more pronounced for the transgender community and LGBTQ people of color. A recent data from the Williams Institute out of UCLA School of Law, analyzing nationally representative surveys of US adults between 2016 and 2019, found that 8% of transgender adults had recent experience of homelessness in the last 12 months prior to reporting, in contrast to only 3% of cisgender sexual minority adults, in other words, queer people, and 1% of cisgender straight adults. The analysis determined significant racial and ethnic experience with homelessness among queer people, indicating disproportionately higher rates of recent experience with homelessness among Black and Latinx queer people as compared to white queers. Ultimately, the data suggests that 16 or 17% of the surveyed individuals experienced homelessness at some point in their lifetime. And these are queer individuals, members of the LGBTQ community, in comparison to the estimated prevalence of homelessness among the general population, which is about 6%. So the fundamental principle undergirding reform efforts is that individuals that are experiencing these conditions need more support, not the added risk of arrest and imprisonment. LD 1478 aims to address this by redirecting the public's response to homeless individuals from anger and disgust to compassion and empathy, and doing so can break the cycle of homelessness, incarceration, and recidivism due to the crime of lacking shelter in Maine. I noticed that my time's expired, so I'm happy to answer any questions.
Thank you very much, Anthony. And let's go to questions. Senator Searway.
Thank you, Madam Chair. Mr. Lombardi, I've been in law enforcement for 33 years, and law enforcement are not racial people. They're not going by gender. They're going by what they can do of the incident that's happening. And every time you bring this up, it makes it sound like it's a racial, gender thing that we're doing. It's really not. What
Senator
we're trying
Searway,
to do.
Do you have a question?
Yes, I'm trying to get to that. If you'd let me get to that.
It sounds like
So,
you're being a little accusatory, but
Point of order. No, point of order. I'm trying to ask a question. And every time you speak up when I'm trying to ask a question, I'm trying to make the sentence and then the question.
get right to your question, Senator. Thank you.
So in order to get things done, how do we get them done if we keep doing what you keep bringing up? We're trying to accomplish taking care of the homeless issues and how we get them directed to the goal. And I think that's the issue here. And I'm just saying, how do we get there? For mental health, we don't have the resource. So how do we get that resource? How do we get the person to connect them? That sort of thing. And that's what I think this is trying to do. So how do we do that?
Senator Seaway, I wholeheartedly agree with you that there's a mental health issue. And I just to push back, I'm not, and GLAD is never trying to insinuate that this is based on racial biases of police enforcement. What I'm using here as this data is to highlight that there's an equity concern that a disproportionate number of the population are from traditionally underrepresented groups, which is to highlight an equity concern that if we care about all members in our community, we need to pay special attention to the fact that some of these impacts, such as homelessness, are disproportionately impacting other members of the community. That's all I mean to intend to with this data.
As a reminder to committee members, everyone that's here to testify has taken time out of their day to come and share their thoughts with us. And even when we disagree, it is our job to listen and not assign some intention to them. Next up, I will go to Ben Martineau and then Pedro Vasquez.
Good morning, Representative Warren and distinguished members of the Criminal Justice and Public Safety Committee. My name is Ben Martineau. I reside in South Portland, and I'm an advocate with Homeless Voices for Justice, based in Portland, Maine, organized by people who have experienced homelessness with the goal of creating positive policy change to end homelessness and poverty in Maine. I am here on behalf of Homeless Voices for Justice to testify in support of LD 1478, enacted to criminalize homelessness. Twice in my life, I've swam through the sludge that could be homelessness. The first time with a girlfriend, the second time alone. Living day to day until I emerged under a warm roof. Day to day, that's what it is like to a great amount of people without a home. While you sit at your kitchen table, pondering over the steps you need to do to plan your brother's wedding, that's 2 months away, some poor souls praying somewhere along this chain of stores, some employees empathetic enough to allow them to do one of humans' most basic functions, use the bathroom. While you shoo away your child from the bathroom door so you can do your business more peacefully, that same person's trying to wash their face and hands so they can suddenly feel halfway human before the management bangs on the door demanding them to leave the premises. So trying to traverse the phase of life towards the goal of a warm roof overhead, the day-to-day basic features living right there in their face. The most basic and for granted activities, such as sitting down and taking a load off your feet, having a beer after a long, hard day's work, resting on your face on a soft pillow on the most comfortable bed, thank God for the memory foam, can become the most difficult things to be done by those people experiencing homelessness who are dodging the routine law enforcement patrols. The other day, I was downtown Portland doing errands in between transferring buses. My bladder decided to let me know it's full. Where can I go? Nowhere. One side said, due to the rules set down during this pandemic, the use of restrooms was prohibited. I need to restrain in the door another half hour into my destination. Now, what's a person without a home, without a destination supposed to do? People who have mental health and behavioral problems and or substance use disorder have a disproportionate rate of police contact, leading to arrest and incarceration. With LD 1478, the person does not need to go to jail to be put on a sex offender list because an officer catches a slight glimpse of him, attempting to squeeze it up in the corner of an alley in the street to do the most needed bodily function out of the corner of their eye. Trained mental health and now trained substance use disorder professionals will be called in to mediate the interaction. The person experiencing homelessness can also be referred to other provided services to help aid them in a better way of life. The importance of each of these points of the bill cannot be overstated. I plead you to support LD 1478, enacted to criminalize homelessness. Thank you for your time.
Thank you, Mr. Martineau. Thank you so much for your testimony. Questions? Seeing none. Mr. Vasquez, I made a mistake and Riley was before you. So let me go to Riley McNeil, and I apologize for that, Riley, and then I'll go to Pedro.
Thank you. Good morning, Representative Warren and distinguished members on the Committee of Criminal Justice and Public Safety. My name is Riley McNeil, and I am a resident of Biddeford, Maine, and I am here today in support of LD 1478, an act to decriminalize homelessness. I recently just graduated with a bachelor's in social work, and during these past 4 years, I have been fortunate enough to also take classes in criminology. And much of what I have learned during this time is that the most vulnerable people in our communities are criminalized and jailed from impacts of poverty. In this case, folks experiencing homelessness. This bill gives the state of Maine an opportunity to address this issue with an equitable response. As you have heard from others in this public hearing, folks experiencing homelessness are not afforded the same protections as those who are housed. So I ask you to picture yourself in this situation. You are experiencing homelessness and you need to take a rest. You sit on a curb or maybe even a bench and you are asked to move along, only to move along to the next place. And then you are asked to move along yet again. You are cited for loitering. Now imagine that you have to use the restroom. You cannot use a restroom at a business unless you spend money there. There are no public bathrooms. So unfortunately, you have to use the restroom in public. You are then jailed for this decision. And this decision is framed as a choice, but it is clearly not. The real crime here is a society and system where people experiencing homelessness and poverty have to go through dehumanizing things every day in the midst of their survival and then are penalized for it. These nonviolent criminal charges only further create barriers to housing, exacerbating the issue. We can do better, and this bill gives us the opportunity to do so. In addition to the decriminalization of homelessness, this bill gives a solution: the Homelessness Crisis Protocol. This would connect folks to the resources they need: housing, recovery services, and case management instead of jail. And I believe this is an equitable approach that needs to be implemented. And for these reasons, I support this bill, and I urge you to as well. Thank you for your time.
Riley, thank you very much for your testimony. Any questions? Seeing none, thank you again.
Thank you.
Next up, we have Mr. Pedro Vasquez. Welcome, good morning.
Thank you. Good morning, Representative Warren, Representative Morales, honorable members of the committee. I am Pedro A. Vasquez. Professionally, I represent disabled individuals in federal court. Currently, I'm the chair of the South Portland Human Rights Commission, and I also hold advanced certifications from the United States Institute of Diplomacy and Human Rights. I'm here in support of LD 1478. Poverty and homelessness in the United States are largely outgrowths of institutionalized racism. Inequity in housing, education, healthcare, and wealth creation are inextricable from that which fuels police brutality, mass incarceration of Black, Indigenous, and other people of color, and the criminalization of poverty. Instead of addressing the inequities in these systems, our national, state, and local governments have tasked our criminal justice system to police and punish those who have suffered the most. A report entitled "The Poor Get Prison" by Karen Dolan noted that poor people, especially people of color, face a greater risk of being fined, arrested, and even incarcerated for minor offenses than other Americans. A broken taillight, an unpaid parking ticket, a minor drug offense, sitting on the sidewalk, or sleeping in a park can result in jail time. In other words, poverty is often treated as a criminal offense. And so criminalizing homelessness is costly, it's ineffective, and it infringes on human rights. This revolving door of arrest, court hearings, incarceration, and release with a return to the streets frustrates not only those who are unhoused, but also our police, judges, and the business community as well. Penalizing people experiencing homelessness tends only to exacerbate mental and physical health problems. It creates or increases criminal records, which then creates barriers to benefits, employment, housing, treatment, and services, and may result in the loss of key personal documents that can make it even harder for people to access the services they need to secure housing. Policies that criminalize the poor are costly and consume substantial community resources. We know this. So to create new policies that are effective and efficient requires not only alternative strategies, such as the protocols detailed in this bill, which focus on the underlying causes of criminal activity, but also a response from all providers that addresses both the legal and the non-legal obstacles that impede an individual's ability to break free from homelessness and an increased community awareness of services that are available. The right to adequate housing is a human right. It is recognized in international human rights law. It's part of the right to an adequate standard of living, which is referenced to in Article 25 of the Universal Declaration of Human Rights. The article reads, "Everyone has the right to a standard of living adequate for the health and well-being of himself and of his family, including food, clothing, housing, and medical care, and necessary social services." And it goes on to describe that every one of us has these rights despite any lack of livelihood and circumstances beyond our control. And so I know my time's running out. To borrow the term from the National Law Center on Homelessness and Poverty, we need housing, not handcuffs. And so on behalf of the South Portland Human Rights Commission, I am here to encourage you to support LD 1478. I'm willing to take questions. I've spent a lot of time with law enforcement leaders in our state recently discussing this very issue. Also have been a part of police services review working group here in South Portland. Our city council has had the forethought to set aside some money on our budget to explore an alternative response model which would be patterned after STAR in Denver or Cahoots nationally. So we are looking at this locally, and I would encourage you to look at it from your seat. Thank you.
Thank you very much. Any questions? Seeing no questions, thank you for providing testimony this morning. Next up, I have Heather Zimmerman and then Andrew Bove. Good morning.
Good morning. Thank you, Representative Warren, and thank you, members of the Committee on Criminal Justice and Public Safety. My name is Heather Zimmerman, and I'm a resident of Portland, Maine, and I am here to testify in full support of LD 1478, an act to decriminalize homelessness. I think I'm speaking after a lot of brilliant people, so I'm going to try and streamline what I was going to say. But I think one of the things that I wanted to touch on is, first, I certainly agree with what Representative Morales started us out with, that criminalization is not a solution to homelessness. In fact, I think I would go further to say criminalization of homelessness makes the crisis and trauma of homelessness much, much worse and profound. It, as we've heard many people talk about, it creates a revolving door between the street and jails and prisons, and it locks people in homelessness and actually increases and exacerbates all of the public health and public safety issues that are already associated with homelessness for both individuals experiencing the homelessness itself as well as the community at large. In addition, I want to stress to this committee that I think now is precisely the time to pass this legislation. I recognize that I don't have the stressful job that you all do in terms of appropriations and prioritization, but I think what COVID-19 has shown us over the past year and what the movement for Black Lives has shown us over the past year, beforehand, but certainly the increased attention over the past year, is that now is the time that we need to pass this legislation for two real reasons. First, what we've seen across the country during the COVID-19 pandemic is that the criminalization of homelessness, which was already increasing over the past 2 decades, has had gasoline added to the fire during this pandemic. We have seen municipalities be able to increase and ramp up the criminalization of people under the guise of public health and public safety because they have more flexibility to sidestep some typical legal protections due to the pandemic and public health orders. In addition, the movement for Black Lives reminds us to always look at the history of where these policies and laws come from. When we look at some of the offenses that this bill seeks to decriminalize for people experiencing homelessness, such as vagrancy, that is rooted in the Black codes that came out of the South in the Reconstruction era. We can trace the laws that are continuing to punish poor people, and particularly Black and African American people, to slavery and its remnants in our country. And that is the reason why this moment is precisely the right moment to pass this legislation. Thank you very much.
Thank you for your testimony. Any questions for Heather Zimmerman? Seeing none, thank you very much. Next up, I have Andrew Bove, and then I'm going to go to Jim, who's on the phone. Andrew, good morning.
Good morning. Good morning, Senator DeChambeau, Representative Warren, and the esteemed members of the Committee on Criminal Justice and Public Safety. My name is Andrew Bove. I'm the director of the Street Outreach Collaborative at Preble Street. Preble Street's a human service agency providing services statewide to empower people experiencing homelessness, hunger, and poverty. I'm here on behalf of Preble Street and also as a lifetime Mainer and Portland resident to voice our strong organizational support for LD 1478. In my 14 years working with people experiencing homelessness, I've seen how the criminalization of homelessness has had a detrimental effects on the lives of our most vulnerable neighbors. As part of a street outreach team, I work every day with people who are unsheltered. Most of these individuals sleep outside as well as pass their days outside. The public nature of their homelessness makes them vulnerable to laws that criminalize loitering, sleeping outside, urinating in public, drinking in public, and more. These type of laws really unfairly target this group of people and people without homes in general, who are unable to perform the basic activities of resting, sleeping, using a restroom without having the privacy of their own home to do it in. And instead, they have to endure an ongoing cycle of criminalization and trauma due to their high levels of contact with the criminal justice system. In addition to doing our street outreach work, we try to connect people with housing resources, work on long-term goals. I can't tell you how many times we've done our background check or a landlord's required some sort of review of somebody, and it just prints out pages and pages of what appear to be, significant criminal involvement. But, you dig a little deeper and you see that all of these crimes are nonviolent. They're all of the types of things we're talking about: loitering, public drinking, and those types of situations. And it can really scare off potential landlords and, follow people around and haunt them, preventing them from having future opportunities. So, tonight, many of us are going to go home, be able to sleep comfortably, change our clothes, use a restroom, have a drink of alcohol in the privacy of our own homes. And these very activities done in public, because an individual does not have a home, can be cause for arrest. This is not the case for people experiencing homelessness. Instead of privacy and comfort, these individuals will be subjected to unnecessary charges and traumatic involvement with the criminal justice system. Experiencing homelessness and trying to survive should not be a crime. For this reason, Preble Street asks you to vote in support of LD 1478. Thank you for your time, and if anybody has any questions, I'm available for that.
Thank you for your testimony. Very good timing. Any questions? Seeing none, thank you very much for being here. I'm going to go next to Jim on the phone. Good morning, Jim. And if you are talking, we can't hear you. You're still muted.
Oh, can you hear me now?
We can perfectly. Thank you.
Okay, thank you very much. Good morning, Representative Warren and members of the Criminal Justice and Public Safety Committee and Representative Morales. My name is Jim Devine. I live in Portland. I'm an advocate with Homeless Voice for Justice, along with Ben Martin, who spoke earlier. And Homeless Voice for Justice is a group of advocates supported by Pearl Street that have all experienced homelessness. And during my time as an advocate, it was my privilege on several occasions to accompany what was called the Home Team, which was a group of caseworkers sponsored by Pearl Street Milestone that would journey out throughout the city and to visit homeless people on the street, and especially to respond to complaint calls as an alternative to needing law enforcement to arrest people, and talk to people and try to deal with their problems and connect them to services, and as an alternative to going to jail, and it was, in my opinion, it was very effective and a humane approach to this ongoing problem. And in my small brain, it seems like 1478 is along the same lines, and so I wholeheartedly support voting ought to pass on this. And on behalf of Homeless Voices Justice, I'll echo that. And I think I'm running out of things to say, so thank you very much.
Thank you very much for your testimony. Any questions for Jim Devine? Seeing none, thank you very much for taking the time to give us your testimony.
You're welcome.
I'm going to go next to David Getchell and then Summer Becker.
Good morning, Senator DeChambeau, Representative Warren, and distinguished members of the committee. You'll be seeing my face a couple more times today, but I wanted to thank you for giving me an opportunity to speak on LD 1478, an act to decriminalize homelessness. I am a resident of Gray, Maine, and in my time here in Maine, I have witnessed friends of mine who have lived out of their cars because they had, there's a bunch of different instances I can think of, but one in particular, they had a bad relationship with their family, and they were living out of their car, and every time it seemed like they were getting somewhere, there would end up being an incident with law enforcement where they would, you know, someone would just ask them why they were parked, their car was parked in a business parking lot, or they would be asked like why they were quote unquote loitering in a public space, you know, and every single time that happened, it defeated them. Like I watched it defeat that person, and the problems that they had only got worse. And I'm sorry, I didn't have anything prepared for this, but I really urge you folks to prioritize our humanity in all of this, because that's really what we only have one life here on this planet, and it's incredibly short. And I hope we've all realized in the past year plus just how short and precious these lives are. And to continue to criminalize people for not having a place to go to the bathroom, or because they just don't have anywhere to go, it's brutal. Honestly, it's brutal and it's inhumane. It's unjust, and I'm buoyed that Representative Morales, you put this bill forward. I think it does a lot to help the problem, and yeah, just ought to pass. Come on, you guys got this. You have so many great bills this session. You have so many great bills this session, and this is one of them. Just ought to pass. Just ought to pass. Thank you for your time.
Thank you, David Getchell. Any questions for David? Seeing none, thank you for taking the time to provide testimony. Up next, I have Summer Becker.
Hi there. I am Summer, but I'm also here with Randa, who's also registered, but we're using the same computer.
That's fine.
Does it matter what order we go in?
Not at all. Thank you.
Okay, Randa's going to speak first.
Good morning.
Good morning. I'm Randa. Well, I just wanted to say thank you for letting me be part of this also. And what David was just saying is exactly kind of what I experimented myself. Since 13 years old, I've been homeless off and on. And every time, you know, you get back up, something would happen and I fall back down. And this past recently in January 2020, during the pandemic, right before that, I ended up getting pregnant. My husband and I got separated and I lost everything and I was homeless again, 34 years old, pregnant, living in a truck on my own. I ended up getting sexually assaulted during that time, and I went to the police and they didn't take it seriously at all because I'm a recovering addict. And they did nothing. I even went to the hospital I had verification. They still haven't even done nothing about it. But anyways, real quick, because I know I don't have much time. Also, during that time, I had my license, and then I don't know, out of nowhere, I got pulled over one day, and they said it was suspended. And okay, so they gave me a summons, which is fine. So, but I'm living in my vehicle, so I would just park at places, and I wanted to be safe because I was scared. So I'd park it at like hospitals, things like that, under the light, and the cops would always come and make me move and not help me at all with any resources. And I would tell them that I was homeless, pregnant, and I had a caseworker through my doctor's office, but they never helped. They never called back. They never did anything. And then also just like I got 3 driving charges in 1 week. I was sleeping in the park and ride, and it's the winter time, so I need heat. So I had the keys in the ignition and I was sleeping, and they knew I was homeless, and same cops that deal with me, and I wasn't driving. They ended up coming and they arrested me, and I had an $800 bail. Like, then, you know, and then they tow my truck every time, and it just adds up with money knowing you're homeless. I also have 3 other children that my father had to watch because I can't have them sleeping in a vehicle. And so I'm just saying, like, there's got to be other ways that people can go about things like this. I vote in favor of this bill because I experimented it. I could seriously tell you more stories that have happened of me, things like this all day because of being 13 homeless on and off. But I just wanted to give you a quick idea, like being sexually assaulted and then cops not helping and then them just harassing me. And they did that, and that the judge dropped the charges because of the harassment. So I hope this bill passes.
Thank you so much for your testimony. It takes a lot of courage to come and share your story. I want you to know that we appreciate it. And congratulations on your recovery.
Yes, thank you very much. And one real thing. I now have a caseworker through Preble Street in that summer, and she found me a home within 2 weeks. And now I have all my kids under one roof again, and everything's great because it's Preble Street, that they're great. So anybody needs any help, go to Preble Street, and I promise you they're great.
Thank you so
And
much.
thank you.
It's nice to hear some good news.
Yes, I didn't think there was any good news because you think the cops would give you resources, like to help me.
Thank you.
They didn't. Have a good day, guys. Thank you.
You too. Thank you so much. And now we'll go to, oh, excuse me, we have a question from Senator DeChambeau before we go to Summer. Yes, Senator, good morning.
Good morning. Hi, Miranda. You did a great job presenting your, unfortunately, that whole history that has surrounded you for the last few years. And I totally agree with you about Preble Street. Even for caseworkers, Preble Street is helpful with other caseworkers.
Correct.
I just want a clarification of, and I was taking notes and listening very intently. You were living in your vehicle and then the cops came and just tell you to move it. And then you went on to say, I have a caseworker through my doctor's office. They never called back. I didn't know if you meant the police never called you back or your
Oh, sorry. Okay. So okay. Sorry. I probably didn't explain that right. And I apologize. Okay. So no, I was just saying that I had a caseworker through my doctor's office that was working on helping me get a home, and they would say, call me and do an application over the phone, and then I couldn't find them or hear back from them. I'd call them and text them because they're cell phones, and I'd call the doctor's office, and they would just fall off the face of the earth. I didn't know where they went, and then I ended up calling. I looked the guy up online, my caseworker, and I found his other job, and I called there, left a message. All of a sudden, the next day, another caseworker called me the next day, and she was like, I'm taking over for you. She showed up at my father's house to meet me, and I met her one time, and then I ended up having this last time, nowhere to go I had the baby then. So I had nowhere to go, and that's how I ended up getting the resources to Preble Street, because I got a new caseworker, which was Summer, and all of them there, they all it took literally, I was a month maybe the most to get me into a home. They're amazing. So I'm sorry you misunderstood that, but
I didn't misunderstand it, and I'm glad I asked the question.
No, I was just saying the cops didn't do anything when I went to them about the sexual assault thing, because because I'm a recovering addict, things like that. You shouldn't be hanging out with those type of people. Well, I wasn't, it was just a situation. So that's what I was saying. So I apologize that you wasn't understanding.
Well, what I was about to say is I do appreciate you relating this to us. It's disturbing for me sometimes that it goes caseworker to caseworker to caseworker with no communication. So
until I got them on Preble Street, though, once I got them, I tell you what, they're here during business hours. You call them, they're here like a snap of a finger, anything you need. And I couldn't be more blessed for them. So thank you, guys.
Thank you. And let's go to Summer now.
Hello, my name is Summer Becker. Thank you all for being here and letting me share a testimony today. I've worked in homeless services for almost 2 years. I currently am working as a rapid rehousing caseworker. And last spring, when the pandemic first hit, I was working at a soup kitchen in Portland, and clients would come to the soup kitchen trying to access restrooms and food services. And those weren't open at that time because of the restrictions. And so clients had to go to the bathroom outside, and they also had to eat their meals outside, and that created a vulnerable situation for them where they could get charges such as public indecency or littering, or public intoxication, if they were engaging in other activities. And, my point is now that I'm a rapid rehousing caseworker, when I go to house these individuals that have been experiencing homelessness for quite some time, they have an extensive criminal record that, follows them and creates barriers to them getting into housing. And the criminalization of their homeless situation is perpetuated because of these, charges that were unavoidable at that time. There were no other resources, or, they're in survival mode. And in that situation, there's not a lot that they can do. And, I really urge the committee to vote in favor of this bill. I think that, experiencing homelessness is an unfortunate situation, and it's not something that somebody should be penalized for, because, it's easy to find ourselves in that situation. And thank you for your time.
Summer, thank you for providing your testimony. Any questions? Seeing none, thank you again.
Thank you.
Anyone else here to testify in support of LD 1478?
Hold on 1 second.
Let's start with Hutch Brown.
Hello.
Good morning.
Thank you for picking on me and for having this conversation. I work in an agency and I deal specifically with homeless veterans. And I wanted to talk a little bit about how being homeless and being a veteran and the trauma around authority figures that a lot of our veterans are dealing with when they come back from service, and the run-ins that they have with police often go terribly wrong because of their trauma associated from their time in the military with authority figures. So when police approach them for doing something as simply as peeing outside behind a dumpster, where they're not being a sexual offender or anything, they're just meeting a basic human need that they don't have access to because they're homeless. And it can go wrong for these men and women, and often does. And then their time in jail, like someone else pointed out earlier, just follows them around for things that happen when you're living outside on the street that all of us house people just take for granted. So it's a challenging thing to see these veterans in a stage like that. So I recommend that we approve the bill and decriminalize everything you can about being homeless, because it's the system at large is making things, oftentimes makes things worse. So I hope we consider that. Thank you.
Thank you very much for your testimony. Any questions? Seeing none. Next, I'm going to go to Mike Stuckmeyer and then Frank D'Alessandro.
Okay, go ahead.
Well, hello, good morning, Senator DeChambeau and Representative Warren and all the distinguished members of the Criminal Justice and Public Safety Committee. My name is Mike Stuckmeyer. I live in Portland, and I'm a member of the Homeless Voices for Justice with Preble Street. I'm here today to speak in support of LD 1478, an act to decriminalize homelessness. I'm speaking today to express to you how important this bill would be, and it's so important for the Maine homeless community. This bill is important because everyone, whether or not they are experiencing homelessness or not, deserves human dignity. But just because someone is homeless does not mean they should encounter undeserved harassment or punishment from laws that criminalize being homeless. I experienced homelessness for 3 months in Portland, Maine, and I've been homeless in other places, including Maine and other places in the United States, including New York City proper, for periods in my life in the past. I was homeless in Portland in March of beginning in Maine in 2017 for 3 months. There was a time that I needed to use the restroom so badly, and there was no place to go at all, anywhere. I was multiple blocks away from the shelter. Another homeless person I was with said to me, "Oh, just go ahead and urinate anywhere. It's no problem." And like, I was only in Portland for 1 week, and so I didn't know the laws or anything. I replied, "Really?" And so upon 5 seconds into the process of considering doing this, well, I was like 5 seconds, and I was about to, all of a sudden I had this feeling in my intuition of don't do it. And within 5 seconds, a patrol car turned the corner, and the officers got out and questioned us about what we were doing. I'm so grateful that I listened to my intuition, because the officer said to us, "You know, it will put you on the sex offenders list if you urinate in public." Sometimes I think about that day, and I'm so grateful that I made the choice that I did, because something as simple as needing to use the restroom could have gotten me on the sex offenders list for the rest of my life. No one experiencing homelessness should have to experience this. Another point I would like to make is important for this bill is how important it is for people experiencing homelessness not to be criminalized for drinking in public, as long as they're not causing any trouble. This is very important because I have witnessed, while living in Portland for over 4 years, both while being homeless and also housed, homeless individuals being arrested, harassed, and humiliated by the police just because they were drinking in public. Anyone who is of legal age to drink, as long as they're simply being peaceful, keeping to themselves, should not be arrested and humiliated and harassed for doing something they are not able to do in the comfort of their own homes because they are homeless. And I don't even really hardly drink that much. I'm sharing. It's just really, I've witnessed this. I was really stunned and horrified. I was only able to touch on 2 of the 5 points the bill would decriminalize, but all 5 of them are the utmost importance. This bill prioritizes human dignity. For that reason, I urge you to vote pass for this bill. Thank you.
Thank you very much for giving us your testimony. did you also submit your testimony so we can read the other 3 points?
Yeah.
Yes.
Wonderful. Okay, we will do that, I promise you. And let's see if there's any questions for you. Any questions for Mr. Stuckmeyer? Seeing none, thank you again, sir, for being here and sharing your testimony. I'm going to go next to Carolyn Silvius. Welcome. Good. Excuse me, I'm wrong. I said Frank D'Alessandro next, and then I'll come to you, Carolyn. Good morning, Frank.
Good morning. Thank you, Senator Deschambault, Representative Warren, and members of the Committee on Criminal Justice and Public Safety. My name is Frank D'Alessandro, and I'm the Litigation and Policy Director at Maine Equal Justice. We're a civil legal services organization, and we work with and for people with low income seeking solutions to poverty. Maine Equal Justice strongly supports LD 1478 because no one should be criminalized for not having a home. This bill would decriminalize certain offenses for individuals who are homeless that occur because someone lacks a place to live. You've heard a lot of stories this morning about how our current policy negatively impacts homeless people. There are also stories in my written testimony that I won't repeat, but I just want to highlight what we hear over and over from people is, I can't be anywhere. Well, that's what we hear from homeless people. And we've heard also a lot about the role of law enforcement. And I just want to raise up, make sure people hear how important the work of social workers is in working and helping people who are homeless. First, I'd like to say homelessness is an inevitable result of inequality in the housing system that we currently have. Right now in the state of Maine, 60% of extremely low-income households pay more than half of their monthly income towards rent. That leads to a situation where eviction and potential homelessness becomes inevitable. Also, you also heard how the criminalization of homelessness makes it harder for homeless people to get housing because they have a criminal record, regardless of why that criminal record is. Also, what you'll hear later and in some of the written testimony from opponents to the bill, that they argue that this bill somehow violates the Equal Protection Clause of the federal Constitution. This is an overstatement of how equal protection is interpreted. Unfortunately, for better or for worse, neither wealth nor homelessness is a suspect class under the Equal Protection Clause. And what that basically means is that this bill will survive constitutional scrutiny if there is any rational basis for its existence. And as you've heard already, there's obviously a rational basis not to criminalize behavior that people engage in because they lack housing. In fact, courts that have looked at this have actually found that criminalization of sleeping out when there's not available shelter, actually, that's what violates the Constitution. The cost of criminalization of poverty deals with poverty in the most expensive way possible and is, in my mind, the most vivid example of an unfunded mandate. According to a study done by OPLA, the cost of jailing someone is between $43,000 and $55,000 per year. According to Maine State Housing Authority, the cost of a Section 8 voucher for an entire family is $7,500 per year. The activities decriminalized by this bill are activities that people who are housed engage in routinely within the confines of their home, and they only become criminal when someone lacks a place to live. A person with a home doesn't need to seek shelter in a public place. They go home at night to sleep in their own bed. A person at home who has a home doesn't need to urinate in a public place. They use the bathroom down the hall. A person with a home can have a beer after work at the kitchen table. The fact that a person lacks a home shouldn't make them criminals, especially for engaging in activities that people who have a place to live take for granted. So for these reasons and multiple others that you've heard, we strongly urge you to vote ought to pass on this bill, and I'm available to answer any questions.
Thank you so much for your testimony. Any questions? Seeing none, thank you again. And now we have Carolyn, excuse me, 1 second. Again, Carolyn, Senator Searway has a question.
Yes, Thank you, Madam Chair. Just a question for Deanne Zalandro. I guess that's how you pronounce it. I'm not sure, but anyway, what avenues are there? I mean, I know towns usually will find you housing if you need it, but what other avenues do you have for access to get homeless people into a home? I guess that's the question.
Maine has, there are vouchers available through the Section 8 program. Those are run by local housing authorities and Maine State Housing Authority. Unfortunately, the waiting list for those vouchers is years long, and there's tens of thousands of people on the waiting list for those vouchers. For people who, I heard people talking about AMHI earlier. For people who are part of the AMHI consent decree class, there is a voucher program that's administered through the Department of Health and Human Services called BRAP, and that provides a voucher for that population. It is time limited, and there is also a waiting list. The only significant housing program, to my knowledge, in the state of Maine that does not come with a significant waiting list is the Maine General Assistance Program, and that is administered directly through municipalities with some oversight from the Department of Health and Human Services. The problem with the General Assistance Program is first that the maximum amount of benefit is also often inadequate to meet the needs. So in a lot of municipalities, the maximum amount for rent is below what the market charges. And so it's really difficult to find housing for people. The other problem is that the administration of the General Assistance Program varies wildly from municipality to municipality. Some municipalities have a pretty robust General Assistance Program and they will provide assistance. Some municipalities will tell people who apply to General Assistance that they've run out of money, which actually is not an answer. Under state law, municipality is supposed to administer a General Assistance Program. If someone is eligible, is supposed to be providing assistance. Municipalities also get a significant amount of the what they spend for General Assistance reimbursed by the state. So that's what's out there. And then there are shelters. The shelters are not evenly distributed throughout the state. And I'm sure as people on this committee have heard, often people who are homeless gravitate to service centers such as Bangor and Portland, even though that there are shelters in other places.
So it sounds like it's a lot of, the resources is a big issue. Back years ago, the law enforcement used to have a yellow book. And the yellow book would have a whole bunch of resources in it so that the officers could call to help that person. But that's long gone. So I don't know if that would be something, but also to get the resources is, I think, a big key. What do you think?
Well, I think, I am not an expert in criminal law, but in reviewing this issue, I think redirecting resources that are currently spent in incarcerating people who are homeless can be better spent in preventing people from becoming homeless in the first place. And in providing Section 8 vouchers for people and other housing assistance is a very cost-effective alternative. Also, providing the type of case management services that some social workers provide, but also that are provided by agencies such as Preble Street and many other agencies throughout the state, so that people have the support, the case management support they need to maintain house and to be good tenants. There is a bill actually, but there is another bill that out there, LD 473, which one of the things it does is it provides navigation and other sorts of support services for tenants so that they can be successfully housed. And a big part of this is, a public-private partnership, also a partnership between tenants and landlords. Tenants want to stay housed and they need to stay housed. Landlords want tenants who can successfully be housed in their apartments. And providing the assistance so that people can pay rent and also that they can meet their obligations for people who have challenges and who need assistance to meet their obligations to tenants. That's a critical piece. And it is much less expensive than incarcerating people. So I think
Thank you for bringing up 473. I think that maybe we could take a look at that and combine this bill with that. I think it would help. So thank you.
Next, we're going to go to Carolyn. Thank you very much for your patience this morning. And please go ahead.
Good morning, Senator DeChambeau, Representative Warren, and members of the Committee on Criminal Justice and Public Safety. I'm Carolyn Silvius from Portland. I'm an advocate for Homeless Voices for Justice and a member of the State Committee of the Green Independent Party, and I'm here to speak in favor of LD 1478. It's a verifiable fact that the homeless are arrested more often than those who are housed, and often for acts that would not be considered criminal by those housed. Since Black and Indigenous people constitute a larger percentage of the homeless population, this means that these arrests play a big part in racial inequity. The situation has many causes. One is the false perception by some in law enforcement that if you are homeless, you must have done something wrong to be in that situation. Profiling the homeless enters here, and I have experienced this profiling myself when I was living in a shelter. Another is that if you are housed, you have the privacy afforded by your home to drink and use the bathroom. You have a place to just sit and think. However, if you are homeless, that privacy is absent and you can only drink or urinate or sit and think, also considered loitering, where you live, outdoors, in a park or other public area. The other provision of this bill, the non-traditional alternatives to arrest, will help rather than hurt the homeless. If a person is arrested for a minor infraction, the time spent in custody interrupts his ongoing efforts to end the homelessness. And in fact, the arrest itself may be a barrier to getting a home, since landlords often refuse to rent to those recently involved with the criminal justice system. Having a social worker respond to the infraction and offering resources may speed up the efforts to acquire safe and decent housing. Being homeless is not a crime, but the homeless are criminalized by the system currently in place. To change this, I urge you to vote ought to pass in your work session and take a step to make justice equal for all. Thank you very much, and I'm willing to answer questions.
Carolyn, thank you so much for your testimony. Any questions from committee members? Seeing none, thank you for taking the time to be here.
And thank you for listening to me.
Anyone else here to provide testimony in support? So we're doing our last call for folks, and I see we have Representative Talbot Ross coming in. Our last call for folks in support of this bill. Good morning, Representative Talbot Ross. Good to see you.
Hey, good morning, everyone. I will be brief, and thank you for taking my testimony. Senator DeChambeau, Representative Warren, distinguished members of the Joint Standing Committee on Criminal Justice and Public Safety, I am Rachel Talbot Ross. I represent House District 40, which comprises the neighborhoods on the peninsula of Portland, the University of Southern Maine campus, and the current home of Preble Street, which for over 40 years, as you have heard, has worked to create welcoming environments where all are treated with respect and empathy, regardless of housing, income, or employment status. You've heard from several people already associated with Preble Street and Homeless Voices for Justice this morning. So I want to just take an opportunity to thank them for their work, and also thank you for the opportunity to express my support for LD 1478, an act to decriminalize homelessness. Last year in the 129th legislature, we passed into law LD 1294, which directed the Maine Human Rights Commission to implement a pilot program to investigate and report on incidents of harassment due to housing status, lack of employment, and other issues. The program provides a vehicle for those experiencing homelessness to record incidents of harassment, which we have all heard this morning and we all know are taking place each and every day, including from law enforcement. This pilot program is a way for people to safely record their experiences with the Maine Human Rights Commission. And it requires the Maine Human Rights Commission to issue a report on this harassment, which will be presented to the Judiciary Committee in September of this year. However, to get this bill passed last year, it took 2 years of advocacy and hard work by the Homeless Voices for Justice, who really wanted us to pass a homeless Bill of Rights, but we were not ready. They did not want us to merely study the issue. A homeless Bill of Rights, also known as a Homeless Person's Bill of Rights and Acts of Living Bill, refers to legislation that protects the civil and human rights of homeless people. These laws affirm that people experiencing homelessness have equal rights to medical care, free speech, free movement, voting, opportunities for employment, and privacy. Over 120 organizations in 5 different states have shown public support for a homeless Bill of Rights and are working towards its implementation. Right now, it's become law in Rhode Island, Connecticut, and Illinois, and is under consideration by several other states, including California, Delaware, Minnesota, Missouri, Oregon, Tennessee, and Vermont. But the pilot program that we passed last year and any movement towards a Bill of Rights are only small steps to take forward. This bill, LD 1478, is a necessary step to meet us at those places. The criminalization of homelessness, as you have heard, can be defined as the passage of laws or ordinances that prohibit sitting, sleeping, sharing food, or even practicing your own religion in public spaces. We need to take this next step and pass LD 1478. It's the tool that is necessary to ensure that all Mainers have the opportunity to live a dignified, safe, healthy life with equal access to shelter, food, and their communities. So I urge you to pass LD 1478 and really take a big step forward in protecting all Mainers. So thank you very much.
Thank you, Representative Talbot Ross. Questions? I have a question from Senator Searway.
Thank you, Madam Chair. Good morning, Representative Ross. How are you?
Very good. Thank you, Senator.
Good. Now, I hear you about the helping the homelessness, and I think that we did a good job with the VA for the homelessness so far. They've been very happy with it. And when we were talking about it during the VA hearings, very little was about decriminalizing and all this. It was mostly directing on what we was lacking for resources to help them. It became very successful. So I didn't know if there's a way of modeling towards what we accomplished instead of blaming police for the actions of individuals, because the police are called to a situation or whatever, and then what happens, it goes to the DAs, or they find resources for them, which we are lacking. And that's what I think the real problem is, the lack of resources. So, and there was a bill, LD 473. I don't know if you could look at that and see if it could, I just wanted to ask you if that's something that could be combined with this to kind of work it and see if we could find some way to help the homeless. And reflect it with the VA's thing.
Right. Well, I thank you, Senator, for your comments and for your question. I cannot comment on whether LD 473 is the right vehicle for this. Since both of these bills have the same sponsor, I would certainly leave that up for Representative Morales to determine, and this committee. What I would say to you is, Senator, it's not an either or. You know, we're trying to place these as extremes, like you either provide the resources or you criminalize them. It's not an either or. I don't think anyone's blaming law enforcement. I think we have to do all of the above. I think we have to make sure that we provide pathways so that people can live safe and healthy lives on their own terms, as well as making sure that we don't criminalize behavior that is as no criminogenic. There's nothing criminogenic about the behavior at all. I'll tell you a very, very short story, and that is, as I was, when I first started to run for office 4 years ago, because Preble Street is in my district, I talked to a whole lot of folks about what could be done to get people the right resources. And I was told story after story about how in the summertime in the city of Portland, when the cruise ships come in, there's a big sweep by police because they don't want people to interrupt our tourism business. They don't want anyone on the street. And our jails would just fill up with individuals who had never committed a crime. But we wanted to, in other words, get rid of folks who didn't, the city didn't feel represented us very well. And so they just were sweeping people into a criminal justice system when they should be able to access the resources that you just mentioned. So I don't think, I think it's all of the above. And I think this bill, and I want to thank Representative Morales for sponsoring it. I think this bill brings us a little bit closer to the humanity that all Mainers deserve.
So how did they not commit a crime and go to jail? I don't get that.
They were sleeping on park benches. Folks were in camps. All the ways in which people have described, all the testimony that you've heard this morning about the lived experience of people who are experiencing homelessness, that was their crime. That was their only crime.
The DAs had to put them there, or the courts had to do that. So that would be a court situation. You'd have to talk to. Thank you.
No, you have to be arrested.
Or the criminal justice and public safety could attempt to fix that, since that is the role of the committee. Any other questions for Representative Talbot Ross? Seeing none, thank you.
Thank you.
Anyone else here? Final call for testimony in support of LD 1478. Now I'm going to open testimony for those here to oppose LD 1478. And Deb will bring you in. Good morning. We're going to start with Jim Hall. Good morning.
Hi, and thanks to the chairs and committee members for opening up this remote engagement. I do hope this continues after the need of COVID, because a lot of people who couldn't otherwise get to you have been able to testify. So I'm Jim Hall. I oppose the core assumptions of this bill based on direct experience living on the block, where frankly, your hometowns probably send people experiencing the emergency of homelessness. It's called Bayside in Portland. The worst flaw of this bill is that it would codify into law a false assumption that people experiencing homelessness are constitutionally unable to abide by social norms. And that has not been my experience. Pardoning disruptive behavior will only create community resentment and make it incredibly hard to cite any new services. The reality is, from the public safety side, when a first responder needs to deal with an emergency and they are blocked from a whole class of options, the result will be more severe class of arrests. leading to worse disruption in people's lives. And this is a harm reduction tool that is needed in congregate emergency settings. About 50% of the cases where individuals have been criminally trespassed from a emergency congregate setting have to do with fighting. And social workers are appropriately trained to escalate to that point when other measures have failed. Please don't take that away. It would endanger the individuals you're trying to protect. Portland already has a successful program you should be looking at rather than dictating and taking away local control. And I would also mention the VA program. Portland has this long-term stayer program that the Maine, I'll skip that. I'm losing the words for the department, but in other cases, you're asking every village in Maine to pay for its own program, and these are not going to be successful. Budgets are already strained. It's ineffective to simply mandate that you spin up a department that provides, quote, information and referrals. Anyone working with vulnerable people know that it's often very hard to connect people with what would appear to be the right resources. And I just want to underline Professor Undercuffler's. Oh my goodness, I only got halfway through. Well, I'm open to questions and also to challenges to my assumptions. Thank you.
Thank you, Mr. Hall, for being here this morning and providing your testimony. And we will read your testimony if you've submitted it. I promise you that. We're going to start off with questions. And so I see I have Representative Pickett with the first question.
Yes, thank you, Madam Chair. Thank you, Mr. Hall. I know the time ran out on you quickly, but if you have anything else in there that you thought was critical we should hear, if you would like to do that, I'd like to hear what you have to say. I think it's important that we hear that.
Well, thank you so much. We've heard the need to address the precursors such as behavioral health support, systemic bias, affordable housing. This bill does nothing to help. It basically enables the outcomes of failing to help people. And I urge you to table this indefinitely and wait for the unnamed proposal that would have various departments working together to assess how to better utilize available resources. I don't think there's anything else urgent there. Just please do your homework before trying to enable these disruptive behaviors. Thanks.
Thank you, Mr. Hall, for your testimony, and thank you for being here today. Would you be willing to come to the work session?
Absolutely. It's already on my calendar.
Okay, very good. Thank you.
Seeing no more questions, thank you, Mr. Hall. I'm going to go next to Rebecca Graham.
Thank you, Representative Warren, Senator DeChambeau, and members of the Criminal Justice and Public Safety Committee. My name is Rebecca Graham, and I'm here testifying in opposition to LD 1478 at the direction of MMA's 70-member Legislative Policy Committee. The association and its members do not disagree with the spirit of this bill or the need for a system to direct individuals into services or alternatives for our police. There is no level of government that is more intimately aware of the challenges for the homeless population than municipal government. We are often the single point between an individual and care while funding, managing, and struggling against the lack of resources allocated to address the key socioeconomic fallout of attainable housing, substance use disorder, and mental health support services that are a result of state-level policy. LD 1300 passed out of state and local government committee in a divided report and was supported by MMA's LPC because it establishes a regional view of housing and other supports, creates a coordinating entity and a mechanism for all communities in that area to have skin in the game regardless of available housing. This is the path towards addressing this issue because communities who have services draw homeless individuals from across the state from those who do not. Try to get a homeless shelter situated in any community, and you're going to find an overwhelming turnout of residents who are concerned about the perceived antisocial behavior that accompanies such services. Municipal officials are caught between resident desires and the lack of services and need for programming. And officials and police need more tools, not the removal of the few existing ones. As drafted, this bill seeks to strip municipal police of the often only tool that connects a homeless individual with any sort of services when they exist, and balances the delicate relationship between residents and the nonprofits that are providing for those homeless population services. The fallout of such policy could cripple the efforts to expand homeless shelters in communities, and assumes police in those communities are not already acting with the wide discretion afforded to them when called to address illegal behavior. Nothing could be further from the truth. Police do not arrest individuals for randomly urinating in a dark alley, but they do need a mechanism to address a complaint of public urination from a sidewalk into a residential flower bed that occurs in front of families. And arrest is the last resort action. Often they use a city urination ordinance violation instead. The committee might want to consider if the violation for public urination is a reportable sex offense list registry violation. That is still, I think, at question. However, that would be the one provision that we would ask that you consider with regard to that issue. Active assault simply must be addressed for the protection of the public and the individuals involved, regardless of their residential status. No officer, prosecutor, or judge places someone in prison simply because they are homeless. However, jails do offer warm spaces for nourishment in January because we remain unwilling to deal with the core socioeconomic and mental health issues that are plaguing the system. So I'll wrap up just by providing that before the pandemic, towns like Brunswick were dealing with over 100 homeless juveniles they sought housing for, and they didn't have any of those services available. Officials ask that you use your legislative authority to really create the mechanisms and the alternatives for police rather than removing what little tools they have. Thank you.
Thank you, Rebecca, for your testimony today. I'm going to start with a question from Representative Pickett, and then we're going to go to Representative Pluker.
Thank you, Madam Chair. Thank you, Rebecca, for being here today, and thank you for clarifying the police role so that we wouldn't have to, those of us that have been in it, on this serious issue, that police care very deeply about this position as well, and they're advocates out there trying to do their job. But the question I have for you, would you please present, make sure your testimony makes it into the queue so that we'll have it for the work session, and would you please plan on being present at the work session?
Absolutely, sir.
Thank you.
Representative Pluker.
Thank you, Madam Chair. I was just wondering about MMA's feeling on the fourth section of the bill around adoption of homelessness crisis protocol. Are you also opposed to that aspect of the bill, or not as much?
No, and that's included in my written testimony. We don't argue that there isn't a need for alternatives for police and that it wouldn't be helpful to have an AG's protocol within that. However, there aren't any services for folks to be pointed to. And we believe that the coordinating council at the county level that is proposed in LD 1300 would create those systems where we can actually start to look at our law enforcement responses. But right now we don't have any of that, and there is not statewide uniformity in access to this. It is very much a service center community focus, and those service centers range from 4,000 residents to 60,000 across the state. So there's a lot of disparate access to services as well that need to be accounted for.
And so you are in favor of the kind of approach that they're taking in 1300?
Yes, we supported that bill.
Thank you.
I think that was sort of my question as well, Ms. Graham, is just, I feel like I have a pretty good sense of you, and I have a pretty good sense of your members and the LPC, et cetera. And so, in my brain, I'm trying to figure out the opposition because I know that we all know this is a serious problem. And maybe if you live in rural parts of the state, you can pretend it doesn't exist. But if you live where I live now, where I've lived for a long time, this year and last year is really the first time that I actually see people on the side of the road. I haven't lived in Portland. I've lived in Central Maine my whole life. It has not been as evident. I know it exists, and obviously the work that I do, I know unhoused people exist, but I cannot go to the places that I shop now without seeing folks that are really struggling. And so I know that you folks aren't opposed to finding a solution. So what do we do? How do we help?
And the only pieces of this bill that we're opposed to are the reclassification of those crimes and the removal of police to be able to respond to them, because that is the balance in communities that have particularly home. And it's what folks often complain about when they're in planning board sessions about citing these places that are desperately needed. So we want to create a culture that facilitates a recognition that we need to actually have statewide housing supports. And we also need to kind of stop this ebb and flow. All of us have skin in the game within the housing realm. However, I don't have any housing supports in my community. Does that mean that there aren't homeless individuals? They're probably unseen. And we have an obligation to support that individual if they've moved to Portland as well. But that's really hard when you're at the homeless shelter as to trying to figure out someone's residence and trying to hold that community accountable. The county model that was proposed in LD 1300 would be on that regional basis. So the resources would also be regional. Those individuals wouldn't necessarily need to be going to Lewiston or Bangor or Portland for those services, because ideally we would create and support and supplement the services that are available at the county level, but with all the communities having skin in the game, so that those individuals are also staying closer to their communities, and maybe even in the case of homeless families, keeping their children in the same school.
Mm-hmm.
So we think it needs to have that regional approach. But anecdotally, some of the things that were encountered when I was working at Waterville Police Department 20 years ago were individuals who were chronically homeless, and when the temperature dipped, would do things specifically so that they could get into that jail system, because it did provide them with all around 24-hour food and shelter. And the homeless shelters, often you had to vacate in the morning, and it's still cold. So it was also a mechanism for people to get housing when they shouldn't necessarily need to be relying on that. So those are the gaps. Those are the service gaps that we really would like to see focused on and addressed, and kind of not removal of the people who are pretty much the last resort and have been dealing with this for a very long time.
Mm-hmm.
They're not
Thank
the
you.
bad part.
Thank you for that answer. I'm going to go to Senator DeChambeau.
Thank you, Representative Warren. I came in halfway through this from another meeting. And even when I read the bill and listening about decriminalizing, I just felt we were talking more about adults. And in my head, one of the largest social services agencies outside of DHS is our school departments and our schools. In my own community, about a year and a half ago, because no one's taken account since COVID, there were 70 in the high school who were considered homeless. Again, an anecdote, because the people who deal with them are the local police who try to divert them. They will not arrest them for a juvenile crime unless they get called from Hannaford that they're shoplifting. So again, I guess I'm just bringing in another agency, another area. If you're talking juveniles, if we're really concerned about homelessness, they don't have families. They have been kicked out of the home, or they're afraid to go back to the home. And our own school departments, their hands are tied. They know they're doing couch surfing and what have you. So I guess I'm making that broader picture rather than focusing it only on law enforcement and decriminalize. This is a larger picture. In my day and age, we never talked about homeless teens. And it's probably the saddest thing to see the same child, and I would call them a child, 15 years old, on the streets, shivering, and no place to go. So this is a big, if there was to be a war, this is the second war on poverty or homelessness that there is. So I wanted to, for us, whether you're for this bill or against it, please, I just wanted to bring up that there are children out there too, the homeless teens. So that's all I wanted to say. I didn't want us to forget about it, that's all.
Thank you, Senator DeChambeau. Any other questions for Rebecca Graham? Seeing none, thank you for your testimony. Next up, I have Laura Undercuffler. Good morning.
Thank you.
Welcome.
I appreciate this opportunity to speak to you. I am a lawyer, law teacher, and also for the past 12 years have lived across the street from the Portland Oxford Street homeless shelter, the main homeless shelter low barrier in the city of Portland. I think all of us want to do right by the homeless. I absolutely support diversionary programs, services, resources, and I'm willing to pay the taxes to support them. The problem with this bill is that it completely exempts the homeless as a class from this entire area of criminal laws. There are a couple of deep problems with that. One is that by their very nature, criminal laws must apply to all people equally. The state cannot, consistent with the Equal Protection Clause, simply exempt a certain predetermined group based on personal characteristics, demographic characteristics, property ownership, whatever. As we know, and from the previous conversation, there are many people who can have cognitive issues, health issues, family issues that can cause them to engage in the behaviors perhaps that are a part of this situation. None of them are instantly exempt as soon as they assert the fact that they are who they are. This situation would not survive any equal protection challenge. I know that a prior individual said that there have been courts who have upheld this. In fact, there are no courts that have upheld an exemption of this type from wholesale exemption from criminal laws. Those courts dealt with the ability of cities to criminalize individuals for sleeping outside when the city, in fact, refused to provide shelter. Different situation. Another point, and I know I have very little time, but another point I wanted to mention is that from my experience with homeless people, both as friends, employees of my husband, and people we've known in the community, there is no such thing as a monolithic homeless population when it comes to this issue. There are many homeless people who never commit these offenses, try very hard not to commit these offenses. There are others who are usually the periphery of the shelter who engage in these offenses chronically. They yell and threaten at those of us in the neighborhood who try to ask them to turn down music or to not urinate on the front yard. There are many different situations here, and the police simply have to have some sort of ability to control this behavior. If this law is passed, there will be absolutely none. As soon as the individual asserts homelessness, he or she is completely exempt from any consequence, which will also, of course, as someone else mentioned, make the welcoming of any homeless shelter or homeless facility in that community virtually unavailable after the passage of this bill.
Thank you very much for providing your testimony today. Any questions? Seeing none, thank you very much. Next, I have Sarah, and I can't read your last name. I apologize for that. It's too long in the screen. There we go. Welcome.
Thank you. It probably wouldn't matter. You probably couldn't pronounce it anyway. Very few people can, and it's totally fine. Representative Warren and honorable members of the committee, thank you very much for allowing me to speak. I may go slightly over, and I hope if I do, you'll let me have a couple extra seconds. I think it's a perspective that not too many people have. Like Laura Undercuffler, I live near the shelter in Bayside, 4 houses down. And as you may or may not know, Bayside the neighborhood is home to a social service cluster of 365 permanent and over 200 overflow beds within about a 500-foot radius. And, shelter seekers, they're my neighbors. And frankly, they would be your home to neighbors if other communities offer the resources to help them there. 29% of the state's emergency shelter beds and many of the 200 chronically homeless individuals mentioned earlier are segregated here, anywhere from 0 to 500 feet from dwellings. And this bill is well intended, but the situation is far more complicated than anyone in support has alluded to. And the unintended consequences would inordinately impact this neighborhood. 20% of Portland's police calls for service, including violent property crime, theft, et cetera, come from here. And many of those come from those who are serving homeless individuals. Interestingly, one of the agencies who testified earlier engages police to calm and clear the sidewalks around their facilities. The number of these so-called quality of life crimes and other crimes it's really staggering here. And they impact the same neighbors and businesses over and over. Drinking, doing drugs, meth, crack, and heroin, it does often escalate to unpredictable and unsafe behavior like fighting, and it attracts drug dealing, which attracts more crime. And if a person says they're homeless and don't want services, what options would police have to mitigate that impact? Now, I can't speak for other communities, but Portland police, they really do use a very robust homelessness protocol. Alternative responders, liaisons, community policing, they do a great amount of good, compassionate work, and they coordinate with social service providers and outreach teams. They've just already instituted a lot of the measures that this protocol requires. So I support continuing to refine that approach and encouraging and financially supporting other communities to do the same. And I also support using courts wisely and compassionately to address these crimes. I support conversations over incarceration. I myself have participated in restorative justice, speaking up for a woman in court who had burglarized my car so that she could stay out of jail and continue her recovery and stay housed, which she did. So these interventions, they can work. I don't advocate for more arrests or enforcement. Everything else works better for the long-term solutions, absolutely, but it's a necessary tool to manage the extremes. So I ask that you rethink this bill if you're considering it, and use the Portland Police Department's protocol as a model, and also work really hard to create transitional, supportive, and permanent housing and regional service hubs, and find, and most of all, fund ways to keep people healthy and housed in their own communities, and commit to expanding access to mental health and recovery resources, because that's what will make arrest ever less likely or necessary. So thank you for your time, and I'll take any questions if anyone has any.
Thank you so much for your testimony. Any questions? Seeing none, thank you. Next, okay, so let's see, do we have any more people here to testify in opposition to LD 1478? And if you do, raise your hand and we'll bring you in. We have Ann Pringle, good morning. And Ann, if you're talking, we can't hear you, so you'll want to unmute.
Sorry.
There you go.
Senator Deschambault, Representative Warren, and members of the committee, my name is Ann Pringle, and I'm testifying in opposition to LD 1478 on behalf of the Friends of Deering Oaks. As a personal introduction, I'm a former board leader of Spring Harbor Hospital, which is a psychiatric hospital and main behavioral health care. And I have friends with mental illness who are recovering alcoholics and who have been homeless. I submitted written testimony on May 11th with complaints and photos from the public about what transpired in the park last summer. And I will not repeat that testimony, but offer the following comments. First, the summary of the bill indicates that the behaviors cited that would prohibit arrest or prosecution for, quote, low-level violations if committed by, quote, a person who lacks a home. All of the behaviors cited, as well as drug dealing, drug use, overdoses and deaths, public sex, public defecation, assaults, and so forth, were evident on a daily basis in the park last summer with groups of 50 people or more that congregated. While the bill is perhaps well-intended, we are very concerned that serious consequences could lead to even more illegal activity than we are already seeing in Deering Oaks and in the broader community. These are not victimless crimes. They affect the general public who does not feel safe using certain public places. There are also practical problems with this proposal. Ask yourself how the police will determine if an individual is committing a crime or violation that the individual, quote, lacks a home. Local police may retain certain enforcement powers, but imagine the pushback. Quote, you can't arrest me or cite me for engaging in fill in the blank, public drinking, drug use, etc., because I, quote, lack a home. Imagine the lawsuits that would occur. Surprisingly, last summer, many people in the park participating in these activities were not homeless, they were housed. And it makes you wonder with the comments made, you know, why didn't they invite their friends back to their home to use their bathrooms and to drink if that's what they were doing or whatever, rather than do it in a public space at the cost of affecting the public's enjoyment of the space. Appropriately, we are all increasingly reminded and challenged to treat all people equally. Certainly the homeless should not be targeted by the police. While decriminalizing homelessness has become a popular mantra, please reject the notion of legitimizing a full range of illegal public behaviors that could be committed without consequences by one class of individuals, but not others. Is this fair and equitable? 30 years ago, Deering Oaks was perceived by law-abiding citizens as a dangerous place where illegal behaviors were tolerated. If this bill passes, the Friends of Deering Oaks fears that the park will again become a place to be avoided, except by those who have appropriated it for their use and ignore the rules that apply to all. We can't let that happen, so we encourage you to vote against this bill. And I would add as a final comment, the state is engaged now in a homeless system redesign effort. And as some people have referenced, they're talking about a hub system to provide homeless services throughout the state of Maine. Table this bill and wait to see what those recommendations are, which could include some addressing some of the issues you have before you today. So table the bill, kill the bill or table the bill, one or the other, but please don't pass this bill because of the unintended consequences we believe it would have. Thank you.
Thank you for your testimony. Questions for Anne? Seeing none, thank you so much for providing testimony. Now I'm going to ask if anyone's here to speak neither for nor against LD 1478. Good morning, Major Scott.
Good morning. Representative Warren, Senator DeChambeau, and members of the Joint Standing Committee on Criminal Justice and Public Safety. My name is Major Brian Scott. And I'm here today to testify neither for nor against LD 1478 for the Maine State Police and the Department of Public Safety. While we believe that the intent of this bill is a noble one, we also believe it would result in unintended consequences. Being homeless may increase the risk of a person coming into contact with law enforcement for what might seem like minor crimes. However, being homeless should not be a license to engage in behavior that infringes on the rights of others. As written, a person who lacks a home, and I put that in quote because it's not defined, may commit a criminal trespass on the property of another and refuse to leave in order to do so. They may also engage in disorderly conduct with loud and unreasonable noise or by starting a fight in public, or knowingly expose their genitals to a school bus full of children as long as they're urinating at the same time. They could openly use drugs and alcohol at a school playground with children playing or a crowded beach where families are trying to enjoy the outdoors and then refuse to stop their conduct after having been ordered to do so by a law enforcement officer. The police would not be able to stop these crimes in progress by making an arrest and restoring order to what could be a disturbing and chaotic situation, resulting in the continued victimization of others. I'm concerned that, as an example, a person could camp in the front yard of one of your constituents' residence, make loud and unreasonable noises, and urinate on their flower garden, possibly with their children watching. And then when we, the police, get called, we would respond and be powerless to help them remove the person from the premises or arrest them if they refuse to leave. A person who is not actually homeless could simply say that they lacked a home as a defense to any of these crimes listed in the bill, and law enforcement may not be able to prove that they in fact have a home. The bill also does not define what the meaning of lacks a home is. If a person does not rent or own, but stays with family or friends, are they considered a lack a home since the home is not theirs, yet they still have a roof over their head? This bill would also mandate that if a law enforcement officer encounters a person who lacks a home committing the crimes described in the proposed statute, that we would have to require mental health and substance use disorder professionals respond and provide appropriate information and referrals to resources in the community to include crisis services, emergency and transitional housing, and case management services. Most law enforcement agencies do not employ these professionals, so we would either have to hire or contract with such professionals without the available funding or the expertise to properly supervise them. And many communities in Maine do not have the services that are contemplated in this bill. Law enforcement officers exercise discretion every day and rarely arrest for minor violations when other options are available. District attorneys often do not prosecute minor crimes with extenuating circumstances, and there is currently a statute in the Maine Criminal Code that allows a court to dismiss de minimis infractions. We recognize that homelessness is a terrible problem that Maine must deal with, and we hope that steps are taken to provide housing and other services to reduce this issue. However, even though this bill aims to help the homelessness, we are not sure it will reach that end, and we remain concerned of the unintended consequences that will impact the quality of other Maine lives. On behalf of the Department of Public Safety and the Maine State Police, I thank you for your time, and I'd be happy to try and answer any questions.
Thank you, Major Scott. I'm going to start with Representative Pluker.
Thank you, Madam Chair, and thank you, Major Scott, for being here. In your testimony, you outlined a lot of different things where the law enforcement officer might not be able to take action as a result of this bill. But there's in section 3, it says, the law enforcement officer shall respond to the person using the homelessness crisis protocol. And then it says that the homelessness crisis protocol should be adopted and created by the Attorney General. Do you think that it's possible that homelessness crisis protocol could include actions that the law enforcement officer could take to stop some of those crimes from being committed?
A great question, Representative Pluker, and thank you for asking that. And it is hard to envision what the protocol might look like since we don't have one. However, I can tell you that Maine law enforcement, certainly the Maine State Police, would be thrilled if we had some resources that were available when we encountered someone who was homeless or suffering from substance abuse, and we were able to get them and connect them with services. It does happen quite often, even in rural patrol areas, that we are called and we try to provide assistance and we look for housing. We might travel 30, 45 minutes, an hour away to find a homeless shelter. I've had troopers and myself personally who have gone through a drive-through and reached into our own pockets to provide a meal for someone who is hungry, because that's just something that we do because we want to help. So if there was a protocol that was available and it had resources, we would love to be involved with something like that. We absolutely would rather not try to arrest our way out of this type of a problem either. We would rather provide them to the resources that help them to get the help that they need.
Thank you. Appreciate it.
Very welcome.
Next, I have Representative Costain and then Representative Pickett.
Thank you, Madam Chair. Major Scott, thank you for being here today. Earlier in the conversation, someone asked about indecent conduct. If somebody was urinating, would that make them go on the sex registry? And I just wanted you to clarify that.
Representative Costain, good morning as well. No, so a violation of Title 17A, Section 854, which is indecent conduct, would not require a registration on the Maine Sexual Offender Registry. But I think also what's important to note regarding 854 is it says that you knowingly expose your genitals with the intent to cause affront or alarm. So discreetly urinating somewhere and trying to hide or conceal your genitals from public view would not be a violation of the indecent conduct statute, in my opinion.
Thank you, sir.
Welcome.
Thank you. Representative Pickett.
Yes, thank you, Madam Chair. Thank you, Major Scott, for being here. In response to a part of a testimony that was given earlier, it was mentioned that the the homeless are often harassed and needlessly harassed. And it was said that law enforcement were involved in that harassment as well. Can you speak to that?
Thanks for that question, Representative Pickett. So it's a little hard to hear and actually try to understand what that means. What I can tell you, especially in rural patrol, I've never done city policing, and the state police doesn't do city policing. So I'm not sure what or where that might come from, or what behavior that is being characterized as. What I can tell you is when we're dealing with folks, we're generally called to that area. It's some type of a complaint. There's a disturbance. There's a fight. There's someone that's openly either using drugs, consuming intoxicants, refusing to leave, being belligerent, boisterous. There's a fight in public. There's a reason that we're called. So engaging in harassing because someone's homelessness just is not something that the Maine State Police or any law enforcement that I'm personally aware of would engage in. We're called. Again, if we're not called, we don't have a reason to be there. We certainly have encountered homeless folks in our travels. We do see that throughout the state. If there's not a problem that's occurring, again, we often might say hi, smile as we drive by. And yes, I've heard of many troopers. And again, I've done this myself on other occasions. We've gone through the drive-through somewhere and gotten an extra sandwich and given it to them to be good community members and to try to help out those who are in need. Harassment, that's just not something that we engage in.
Thank you, sir.
You're welcome.
Next up, I have Representative Costain. Oh, okay.
Sorry about that.
No problem. Anyone else with any questions for Major Scott? Seeing none, thank you, Major, for being here.
You're welcome, Madam Chair.
And good morning to Kate Knox. Welcome.
Good morning, Madam Chair, members of the Criminal Justice and Public Safety Committee. Thank you for giving me a few minutes this morning. My name is Kate Knox. I'm a resident of Portland, and I'm here just to offer some very brief comments on behalf of the City of Portland, neither for nor against this particular piece of legislation. You've heard a lot about Portland today. You've heard from some of our residents. You've heard from some of our community partners like Preble Street. This issue is hugely present in our city. It has been for quite a while. And so for better or worse, we have a lot of experience trying to come up with innovative ways to deal with the unhoused population. I want to thank Representative Morales. She's been so open to us, and we've had some great conversations with her. I think the city merely wants to express to the committee their concern, if you decide to go forward, about having the AG's office adopt a one-size-fits-all protocol on these issues. So I think that the concern is not necessarily requiring a protocol. It's just that when you think about how different municipalities are and how different their challenges are, that we would argue to you there needs to be some space for us to create and implement, and in Portland's situation, continue to sort of innovate and work on the local model we have now. That the local solution to this, our ability to be flexible, our ability to be responsive to new sources of money, new programs, new things our community partners are doing, is really important to continue our work and to try to get at the issue that you've all heard about this morning, which we absolutely agree is an issue we need to address. So that's all I'll say for now. We would just ask for when you get to the point of thinking about this protocol, that you think about allowing municipalities to customize and individualize their protocol, in particular for cities and towns that have been doing this work for a long time and have a relatively sophisticated protocol they're already using. Not that protocols can't be improved or things can't be better. That is absolutely true. But we just want to maintain our local ability to do what works best for the unhoused and the neighbors in Portland. So thank you for your time. I appreciate it.
Thank you for your testimony. Any questions? Seeing none, thank you. One more opportunity for those here to testify neither for nor against. LD 1478. Seeing none, now I'm going to ask the committee members what you might need from our analyst before the work session. Any requests on that level? Seeing none, I'll close the public hearing on LD 1478. Senator Searway. Oh, you're muted.
Thank you, Madam Chair. I just wanted to mention that I think it was LD 46. Kind of lost my page here, but it was like
Representative Morales's other bill, 473.
yeah, if that was something that can kind of be looked at and combined, because I think that you know what we have, it seems like we have to find an avenue to get them the services and the help, and those that resources is lacking, but also the direction of that bill that was mentioned sounds like there's someone to be able to direct them and get that resource out there. So that seems like that's a good avenue.
Do you want Jane to make sure we have a copy of that bill for the work session? Is that your
Yes.
question? Okay,
Yes.
we can do
Thank
that.
you.
Thank you, Jane. Thank you, Senator. Anything else people need from Jane? I don't see any other hands. I'm going to close this public hearing. Next up, we're going to have LD 1588, but I want to check with the committee. You want to do one more and then take a lunch break, or you want to take a lunch break and then go after? I'm open.
Probably a good time right now. Take it until 12:30 and be back and finish out the afternoon.
I'm cool with that. Other folks back at 12:30? Great. Okay. Have a nice lunch and we'll see you at 12:30. How was lunch? Good. Not as good as Sawyer's though, right?
It wasn't. Actually, I had a burger and their food's good downstairs, but it's not native beef. So
Oh, right, exactly. Big difference.
can I just make a note that it's nice and warm outside?
Yeah, I agree. We could make this a very long day or
Well,
all depends on us.
normally I would have these windows open and there's no air in here. So I called my son and I says, I think we need to take a trip. I need an air conditioner. He'll need an air conditioner. Just
Right.
beginning.
Could we, to the two chairs, could we consider possibly on these hearings that have a lot of people that want to testify? I'm all for everybody having a chance to testify, but if we start getting repetitive testimony, can we do like we did last session in the 129th with the gun bills, when we said, bring something new to the table, we have your testimony, we can read it, but bring something new. If we did that and we suggested that, I think it would really speed things up a little bit, because we're getting a lot of that, the same thing over and over and over. And if we did it then, I don't see why we can't do it now.
Let's have a conversation about it, Representative Pickett. I'm happy for you and Susan and I to have a conversation about that. And I'm also going to ask that we make some better rules about the questions that we ask, because that's actually what takes a very long time. So I would love to tighten things up a little.
Yeah, and I agree on
now
that.
isn't the time to do it.
I agree on that. I think on both sides here, we're having that issue. So we got to get that straightened out, I think.
Yeah, I keep saying it, but it doesn't happen. So let's, we don't need to do that. I mean, it's the truth.
Well, we're all in that. We all do it. We all do it.
So I'm really happy to have that conversation. Representative Costain.
Yeah, as somebody sitting aside here, a lot of questions that's being asked are not clarifying questions, they're work session questions.
They are. And I know people are getting frustrated when I call them on it, but just don't do it and you won't get called on it. So let's get started. We can definitely have an offline conversation. I'm sure the public isn't interested in listening to us kind of work out those details, but I think it would be really important for us to do. Senator DeChambeau, do you want to chair this next one or do you want me to?
Go right ahead. Thank you.
Thank you. Next up, we have LD 1588 with Representative Bill Pfluger, and it's a resolve to convene a working group to identify and find replacements for certain stigmatizing references throughout the Maine revised statutes and government publications. Thank you, Representative Pfluger.
Thank you, Madam Chair. Thank you, committee, for having the chance to work with you all today. And thank you for the chance to present LD 1588 with resolve to convene a working group to identify and find replacements for certain stigmatizing references throughout the Maine revised statutes and government publications. The work of this bill has already been begun within the Department of Corrections, as they have gone through their rules looking for stigmatizing terms that could be changed to person-first language. The core of the idea is that a person should not be defined by the challenges they face, and we as a government should be making it clear in our use of the language that they are people who face these challenges. When people know they are seen as people by the government and the language the government uses, it can help shift one's own self-perception. My greatest challenges do not define me. I'm a person who faces challenges and overcomes them. The bill requires the Department of Corrections to convene a working group that includes people from DOC, DPS, DHHS, and DACF, as well as a person with a lived experience of being labeled by one of the terms they're looking to change. They'll create a list of where the terms arise in the statute, rule, and other government documents and publications that need to be changed, and they will then report back that list to this committee in 2022. We can then introduce legislation to correct the statute. The terms listed in the bill are convict, offender, inmate, prisoner, and drug user. However, I would like to offer a small amendment to the bill that if the working group in the course of its work finds other terms that they would like to address, I would like them to authorize them to do so and include those terms in the report back to this committee. This sort of review of language use is evolving. There may be terms that need to be addressed or others that just create more problems to address than they heal. I've looked online to the DOC's testimony, and I just like to put out to the committee that I'm willing to work with anybody from DOC or any other departments to make sure that this review of language is as little burden as possible, to make sure I think we're all together and that we want to see the work get done, and we just want to make sure it can be done as efficiently and effectively as possible. Thank you to the committee for supporting this work and furthering the work, which has already begun within the DOC. It may seem a small thing to those who have not faced these labels in their lives, but for those living with this stigma, this can be a significant step towards seeing oneself in a new light and beginning the crucial work of recovery. Thank you to all, and I'm happy to answer any questions.
Thank you, Representative Pluker, for your testimony and for bringing this bill to us. Questions from the committee for Representative Pluker? Seeing one. Representative Rudnicki.
I have a real problem with this bill, so I'm going to ask it right out. Don't you think they earn these labels? They are convicts, they are prisoners, they are inmates.
Representative.
I'm just asking the question. Haven't they earned those titles?
No, none of us have earned the title of pejorative title that might be used against us. That is what our society would like to use to label us. And as I said my testimony here, which is that I face challenges, I overcome challenges. I'm not defined by those challenges, and I don't expect any other person to be either in the language of government or in the language I use about them in my personal life.
Other questions for Representative Pluker? Seeing none. Any other sponsors here to testify or legislators here to testify on this bill? Anyone here to testify in support of this bill, please raise your hand and Deb will bring you in. For committee members, it's been a very long week. It's been a long couple of weeks, and I know we are all tired. And again, our job is to listen and try to understand even when we vehemently disagree. I hope that we can continue to do the good work that we've done through so much of this session. Deb is bringing in folks. I'm going to start. I see on my screen Courtney Allen and Marshall Mercer. Courtney.
Good afternoon, Senator DeChambeau, Representative Warren, and members of the Criminal Justice and Public Safety Committee. My name is Courtney Allen. I am the Policy Director for the Maine Recovery Advocacy Project. I'm here to testify on behalf of our network in favor of LD 1588. Representative Pluker just did a great job overviewing the reasons why we support this bill. So I'll just take us really quickly into some of the meat of the policy proposal. We do support the amendment proposed by the sponsor, and I have provided you with language changes in my written testimony to line 5 of the resolve, proposing that we add language and other stigmatizing language deemed appropriate by the working group, following the words drug user. This amendment is proposed with the desire to ensure that the working group has the authority to review all stigmatizing language that may exist throughout the Maine revised statutes and government publications and propose the alternative language. That was after a conversation with a wider coalition of advocates, and they would desire that you consider that as a committee. We do know that this work has already begun within the Department of Corrections, and we applaud Commissioner Liberty for his leadership on this matter. This resolve just simply seeks to take that work and build upon it. In 2020, after convening a multidisciplinary work group, the commissioner did undergo many of the language changes that are proposed in this resolve in recognition that language does matter and words do have the power to shape our perceptions and influence our behaviors. As one of my favorite researchers, William White, has once said, words have immense power to wound or heal. The right words serve as catalysts for personal transformation and offer citizenship and community service. The right words awaken process of personal healing, family renewal, and community and cultural revitalization. The wrong words stigmatize and disempower individuals, families, and communities. I also want to put on the table that we're completely open to the testimony of Commissioner Liberty. I believe he'll probably be here today and recognize his concerns. We are open to any process that provides the outcome desired by this bill, which is simply that we recognize people as people and that we seek to use person-first language throughout our government entities. So with that, I'm happy to answer any questions of the committee, and I've attached references to extensive research on this matter to my written testimony. I'm hoping that you will vote ought to pass and provide us with an opportunity to come back to your committee. Thank you so much.
Thank you, Ms. Allen, for your testimony. And we have a question for you from Senator DeChambeau.
Hi there. Hello, Courtney. And I'm sorry, I'm going to ask you this question because I was not quick on the draw when Representative Pluker was done with his. I'm just looking at the membership, and I assume that you may have been in conversation with Representative Pluker and others, and you might be able to answer that. On the membership, first of all, this focuses on the Department of Corrections and their clientele within the facilities, what to call them. But the first thing I looked at was Department of Health and Human Services. I would think that there are words or titles that are offensive to people using welfare recipient or about the Department of Agriculture. We are coming upon blueberry season, and then is migrant worker a word that's offensive. So when I look at different departments, there are a lot of words that may, for the recipient, be offensive. And so if this was to go, it seems we could do this for many departments. So could you comment on that?
Yes, Senator. I agree with you. There is probably a lot of words that that is not included in this bill, and that was kind of the intent and desire around the proposed amendment that the representative made, and including all of the folks who have been victimized by the words that we choose would be great. I know that the Health and Human Services Committee has done some of this work around substance abuse and addict a couple sessions ago. And there was another bill this session that sought to finish that up. So we've been working towards this as a state and as a community. And my intent and desire is to kind of get this done so that we don't have to keep coming back and trying to clean things up piece by piece.
All right, thank you.
Thank you. Any other questions for Courtney Allen? Seeing none, thank you, Courtney. Next up, we have Marshall Mercer.
Dear Madam Chair, Senator DeChambeau, and members of the Criminal Justice and Public Safety Committee. My name is Marshall Mercer, and I am a student of recovery and an organizer with Maine Recovery Advocacy Project. I'm here today to read testimony for Gayla Sheldon in favor of LD 1588. My name is Gayla Sheldon. Currently, I am residing in Windham, Maine at the Southern Maine Women Reentry Center. I am passionate about advocacy and positive change into making this world a safer and healthier place for everyone. I am an advocate with Maine Recovery Advocacy Project. I have been a recovery coach since 2017, and I have met some wonderful people. I have heard stigmatizing language, direct and indirect, to other individuals that suffer with substance use disorder. I've heard the stigmatizing language such as junkie thrown out. People who suffer from substance use disorder should not be looked at differently than others. No one knows what kind of background each person is from, traumatic events that took place, nor can no one feel the harboring and pain these individuals carry. When people are used to being treated poorly, then having this stigmatizing language thrown around it is another way of tearing them down. That is not going to help that person's recovery. All that will do is make individuals feel lower about themselves. I have also heard the other stigmatizing language thrown around, such as inmate, prisoner, offender, repeat offender. As I stated above, we all come from different backgrounds, traumatic events, and the pain these individuals carry. Why use such language that will tear a person down more? Sorry. There have been many residents who are incarcerated, women and men, who have been through substance use programs, cognitive-based programs, dialectical behavior therapy programs, parenting programs, education, and more. These individuals struggle beyond their comfort zone to seek support within their recovery. Some individuals feel so uncomfortable to participate in programming that they may be of help in their recovery because of the stigmatizing remarks. Not being able to trust anyone, not feeling safe enough to share personal things that others later use against them. I hope that you will take in consideration how the stigmatizing language used negatively impacts others. We are supposed to encourage and uplift others, not tear them down. I am testifying to LD 1588, resolved to convene the working group to identify and find replacements for certain stigmatizing references throughout the main revised statutes and government publications. I am in favor of my testimony of LD 1588, bill to ensure that the stigmatizing language against others in language that can possibly be put to stop and is not going to tear anyone else down. I care too much about other people. And it hurts me to see them hurt and their low self-esteem being lowered due to surrounding stigmatizing language. I believe that the language can change in person in recovery or residence. Would be benefit others immensely. This language will not change others, not tear others down. I hope that this is taken into consideration. Thank you for taking time and reading. And plus, I'd like to add, I used to be a prisoner, a slave to the system. And guess what? I'm no longer that slave no more. Thank you.
Thank you, Mr. Mercer, for sharing your testimony. Any questions for Mr. Mercer? Seeing none, thank you very much. Next up, I have Tina Neto. Good afternoon.
Good afternoon, Representative Warren and members of the Committee on Criminal Justice and Public Safety. My name is Tina Neto. I am the Executive Director of the Maine Association of Criminal Defense Lawyers, and we want to thank Representative Pluker for bringing forth this important bill. I will highlight that on the second page of my testimony, I have embedded hyperlinks to a few articles that I think would be really illuminating for these issues, and also perhaps give some guidance or ideas for people moving forward with this language amendment. We believe that words matter because they do. Language matters. The words we choose and the language we use signals to the world at large the things and people that we value and those that we do not. Eddie Ellis was convicted of manslaughter when he was 16 years old. He's a formerly incarcerated person, and this is a quote from him. When we are not called mad dogs, animals, predators, offenders, and other derogatory terms, we are referred to as inmates, convicts, prisoners, and felons, all terms devoid of humanness, which identify us as things rather than as people. These terms are accepted as the official language of the media, law enforcement, the prison industrial complex, and public policy agencies. However, they are no longer acceptable for us. We are asking everyone to stop using these negative terms and to simply refer to us as people. People currently or formerly incarcerated, people on parole, people recently released from prison, people in prison, people with criminal convictions, but people. A wholesale examination of our laws and rules and policies to see what kind of language we are using to describe people who are ensnared in our criminal legal system would be an important and humanizing endeavor. The Marshall Project has recently undertaken a project themselves to rehumanize language and reporting on criminal legal issues, such as not using the word inmate. And it's a worthy undertaking that Maine lawmakers and journalists who I have been pushing both behind the scenes and publicly to do so would do well to emulate. MACDL would be happy to assist in any working group on this issue to ensure that Maine's values are reflected in the language of our laws. Thank you very much and happy to answer questions.
Thank you, Ms. Neto. We have the first question for you from Representative Pluker.
Thank you for being here, Ms. Neto. I'm on your testimony here, and it doesn't look like the hyperlinks translated into online if you wanted to try to get them to us in another fashion.
I will certainly do that. Thank you very much.
Thank you.
Seeing no more questions, thank you very much for your testimony.
Thank you.
Next up, I have Winifred Tate and then Mickey Rice. Good afternoon.
Good afternoon. Thank you so much for the opportunity to be here. My name is Winifred Tate. I'm director of the Maine Drug Policy Lab at Colby College, and I'm here to testify in support. But my testimony, I am in support of LD 1588, but today I'm here to read the testimony of Wendy Smith, who is currently incarcerated and wanted to share her thoughts. She's an organizer with MeRAP. I am writing, and so these are her words. I'm writing in support of LD 1588 and the importance of changing the stigmatizing language to those incarcerated and suffering with substance use disorder. As a woman in long-term recovery from substance use disorder and currently incarcerated, I can witness the harm that is caused when confronted with that language. When being referred to as a drug addict, criminal, or inmate, among other things, it eventually begins to wear on self-worth, and eventually we believe these things. Once believing these things about ourselves, we create inner stigmas. It deters our effort to thrive and become more than that. After all, if others believe that about us, it must be true, right? Wrong. When we are made to feel less than human because of a disease or a mistake we have made, it makes true recovery impossible to achieve. The hardest thing to overcome are the views that we have on ourselves. We lose our purpose, our confidence, and most of all, our self-worth. It raises the question, why strive to be a better person when others will always look at me like I'm just a drug addict or an inmate? End result, you believe that you can never be more than that. It leaves a feeling of hopelessness and isolation. Although most of the staff here at Southern Maine's Women's Reentry Center refer to us as residents and treat us as we are, human, there are still a few that refer to us as inmates and drug addicts. That's a dehumanizing feeling. And it brings up the criminal addictive mindset of negative thinking patterns. Luckily for me, I'm at a place in my recovery that I can turn those thoughts around and correct their language about who I am. That's not the case for all the women here, though. I consistently see women struggle with their self-worth, causing disciplinary actions within the unit. Sometimes it only takes one person to speak to someone struggling like they are worth more than just being an addict or an inmate to turn those thoughts around and make recovery possible. It's said to us every day that we are here to rehabilitate. In order to help this process be successful, we need to let go of the negative language that is used and bring out the positive. We need to show people through language that they are somebody and that they have supports that believe in them. Change is possible. Let's make it happen. It could possibly save a life. Those are the words of Wendy Smith, who wanted to speak today in support of LD 1588.
Thank you for bringing her voice here today. Any questions? Seeing none, thank you.
Thank you for the opportunity.
Next up, we have Mickey Rice and then David Getchell.
Hello, good afternoon. Me again. Senator DeChambeau, Representative Warren, esteemed members of the Criminal Justice and Public Safety Committee. I'm Mickey Rice, and I'm from Freeman Township. I'm here in support of LD 1588. I'm not going to take up the whole 3 minutes of your time. I know words have hurt, and it can do damage as much as has already been done by other people that have already given testimony today. So the only thing that I really want to add is that I think that this is a no-brainer to do this. I went to school in started school in 2012, graduated in 2016 for mental health and human services, and the whole time I was in college, we were taught person-centered language. We were taught that, you know, that words hurt and they can change perceptions and, you know, they can really cause biases. And so, you know, this is long overdue. This is something that should have been done a while ago. The Department of Corrections has already started to do this. You know, so let's just finish the work and get the stigmatizing language out of our government publications. So I urge you to vote ought to pass on LD 1588. Thank you.
Nikki, thank you for your testimony. Any questions? Seeing none, thank you. Next is David Getchell.
Good afternoon, members of the committee. Nice to see you again. Senator DeChambeau, Representative Warren, and distinguished members of the Committee on Criminal Justice and Public Safety. Thank you for allowing me to testify in favor of LD 1588. My name is David Getchell and I live in Gray. And I don't have much to say on this one. I'll probably be under 3 minutes. The preamble at the beginning of this testimony, where I refer to you all as distinguished and address you with the titles which you have earned through your elections, is something I do out of courtesy. It's not something I have to do, but it is something I do because I recognize that the accomplishments this board has made, and I understand that as a member of society who wants to receive respect, I need to give respect. That respect is sorely lacking in our government documents when it comes to people who have entered the carceral system or people who use drugs, and the state needs to fix that, plain and simple. And, you know, I don't know how we can expect people to start dealing with their own stuff when we have taxpayer-funded workers who are referring to people as junkies or inmates or losers. No, I'm sorry. Those are my friends. Those are my neighbors. That's my mom, my brother, my best friend's mom. Like, stop it. Like, again, I'm appealing to your humanity here because that seems to be like what's sorely lacking in some of these conversations. These are people. Just treat them like people. And, you know, they haven't earned these titles. That was said earlier today, and that's just ridiculous. I'm sorry. Just ought to pass. Let's go. Thanks for your time.
Thank you for your testimony. Any questions? Seeing none. Anyone else here to testify in support of LD 1588? Seeing none. Anyone here to testify in opposition to LD 1588? Seeing one. Ms. Black? Good afternoon and welcome.
Hi. I know that Commissioner Liberty is gonna jump on here in a second so he can deliver the testimony himself. It sounds like people have heard the testimony, so I want to just give him a second if the committee is okay with that, Representative.
Of course.
If you want to skip ahead, I think we understand. So I'll leave it up to you all, and I'm certainly happy to provide the testimony, but it's, you know, it's personal to the commissioner, so I know he wanted the opportunity to deliver it himself.
Absolutely. Hang on one second, Anna. I'm sorry, Ms. Black, and let me see. Anyone else here to testify in opposition to LD 1588? Anyone here to testify neither for nor against LD 1588? Okay, so seeing no one, so let's see if he is here. For committee members, since we're going to have one more testifier on this bill before we close the public hearing, anything you need from Jane that you can think of while we're, okay, looks like nothing.
Well, I am happy to deliver it just so that we don't waste the committee's time. And if he is able to jump on while I'm speaking, you know, he can certainly answer questions. I mean, I can certainly answer questions too. I just wanted to give him the opportunity to speak a little bit more personally. But I'm happy to start.
Okay, I mean, it's up to you. I I certainly am happy to give another minute. I want to honor the committee as well. I think our commissioner, deserves a little bit of patience for sure. How close did you think he was?
I think he is just juggling three things, as I know, as all of you are sometimes trying to jump on in between meetings. So he fully intends, he wants very much to be able to speak because, while the department is officially opposed to the bill, I think we can explain why. And I think, as the sponsors already alluded to, open to figuring out some ways to get to an end result that everybody is happy with. Because as has been mentioned, the department's done quite a bit of work, and we'd like to continue doing that work.
Right. Yes. Representative Pickett.
Yes, Madam Chair. Because we don't really know how much longer it might be, and because we still have other bills to go, and it's Friday afternoon, maybe it'd be a good idea to have Ms. Black read the testimony, and hopefully the commissioner will be here in time to answer questions and give the information that she would like to. I think that might work.
Thank you, Representative. All right, I was hoping he was signing on and we were stalling long enough to get him, but go for it. Thank you.
Sure. And if he comes along, please feel free to, bring him over and he can answer questions as you all allow for it. Okay, so thank you. Senator DeChambeau, Representative Warren, other members, distinguished members of the Criminal Justice Public Safety Committee. I am Anna Black, Director of Government Affairs for the Department of Corrections, providing testimony in opposition to LD 1558. And as I mentioned before, we'll talk a little bit further towards the end of the testimony about the reason for opposition. But before I do that, I just want to call attention to this campaign we've officially launched in December of 2020 called the Language Matters campaign. So Language Matters is a department-wide initiative to ensure that we use person-centered language with the goal of destigmatizing incarceration and many of the circumstances associated with it, while also changing a negative narrative and view of those working in corrections who are often stigmatized themselves. We gather that you've noticed that the MDOC staff uses less traditional language these days when referring to those in custody. The shift to person-first language is one we've embarked upon, and it means that we refer now to individuals in facilities as residents. This is in an effort to shift away from stigmatizing language like prisoner or inmate. MDOC's Division of Community Corrections now refers to individuals under their supervision as clients rather than probationers. These changes and others are underway not just in our speech, but in our printed documents as well. We're in the process of making these changes and other language changes to our resident handbook, in our policies, our employee training manuals, and genuinely across all of the documents put forth by the MDOC, including in our public-facing documents. This change is part of our commitment to reducing shame and stigma, which we unofficially launched in 2019 when we partnered with McLean Hospital of Massachusetts on their Deconstructing Stigma campaign. The Deconstructing Stigma campaign seeks to normalize seeking and receiving treatment, whether the challenges be for mental health, substance use, trauma, or other issues. The impetus of the partnership with McLean Hospital was to encourage staff and residents to feel comfortable seeking support for mental health issues and other issues, as we feel like no one should be suffering when there is treatment available. In the corrections profession, as many of you on this committee know, it's imperative that staff don't feel shame to seek support for managing the stressors that come with the impact of this job, its impact on one's personal life as well. We've been very pleased to have so many staff participating in the McLean Hospital Deconstructing Stigma, including the commissioner himself. He's very open about his own struggles and his own need to balance the stress and triggers he's had in his life with the stress and triggers of his current work. And for those of you who haven't clicked on the hyperlinks within his testimony, it's important to do so as his first person story is both moving just as a human, but it's moving for those in our corrections field, because it provides a lot towards reducing stigma. Anyway, we want to applaud Representative Kluker, of course, for bringing forward this important conversation, and applaud the committee for engaging in the conversation about language. Also want to applaud the employees of the Department of Corrections for changing their language, for recognizing the positive impact new language can have within a correctional setting, as it really does make a difference, as many of our staff will testify to. However, the bill as written is an example in our minds as perfect getting in the way of the good. And we would all very much like to have a perfect world, though we don't know that that's attainable. We are, however, willing to do the work to have a good world. So the changes happening within the department, if we've suggested, also within DHHS, within DPS, within DACF, these are all great changes, good changes. As we've mentioned, we're changing our internal documents, and we've had conversations with the other agencies mentioned in this bill. We know that they are working on those changes as well. However, the bill itself would take a group of staff offline from their current work for the very onerous task of identifying when and where certain terms are used in statutes, in rules, in forms, in policies, and in publications of our 4 agencies. That's a process we are certain would take hundreds of hours of staff time. As I mentioned, we have had conversations with DPS, with the ACF, and with DHHS about this bill, and we all agree that instead, it might be good to consider having the reviser of statutes take on the task of revising the language in statutes that the individual departments agree should be changed due to their stigmatizing nature. After the reviser has taken the time to identify that language, of course, a bill could be submitted for those changes. Another bill can be brought forth asking the relevant departments to make the changes consistent with statute. And of course, in our policies, forms, rules, publications. Doing it like this, we think would allow the departments the time to continue the work they've already done internally to make these changes without having to divert staff time from our equally important work day to day and other responsibilities. That concludes the testimony. I don't know if the commissioners come on. If not, I'm happy to field questions. Oh, he is there. Hi.
He is. Thank you.
Sorry,
very
you should have
much.
interrupted me. You could have taken over.
Thank you, Anna, and welcome, Commissioner Liberty.
Thank you, Madam Chair. I would just echo what Anna had to say. We are very pleased to work with the sponsor of this bill, Representative Pluker. This is a very important initiative. We took this upon ourselves in 2020, and getting the language right, and language does matter to us, and we are committed to this. And so I look forward to working with the sponsor of this bill prior to the work session and during the work session, and obtaining we have the same objective here. It's just a methodology, and so we're all in, and we believe this is a good, solid bill.
Thank you, Commissioner. Any questions for Commissioner Liberty or Anna Black? Yes, Senator DeChambeau.
Thank you. Hello, both of you.
Madam Chair.
Yes. Commissioner, I'm going to be asking maybe a couple of questions, and they're like one after another. I would like to know where that came from, that the Department of Corrections in Maine about language change wanted to do that. In that, I'm sure you attend national conferences and what have you. I'd be interested in knowing other states that might do that. The reason for that statement is there are also federal forms that we fill out that still has that nomenclature of prisoner or inmate. I haven't seen convict at all in my career. So that is one part. That's a question. I want to know where that came from federally, New England states, how they're doing. But does this bill, do you think, apply to the jail systems also? Since you observe the jails and the standards, this is not one of the national standards, but it would be kind of silly if we didn't include the jails. If one day you're a prisoner at York County Jail and the next day you are whatever at the Maine State Prison. So could you speak to that, please?
Yes, of course. Great question. Thank you, Madam Chair. This is part of worldwide and national movement to normalize corrections. And for those of us who've been in the industry for a long time, the law enforcement officers in the room and correctional professionals, there's been a significant transformation where we call people convicts. inmates, prisoners, and that language does matter in that if we're truly trying in our industry to identify what exactly brought people into our custody and how can we reduce recidivism and how can we heal those harms and how can we provide the programming that we need for them to be successful when they transition out and reduce recidivism, which to me means reducing the likelihood of future victims. One of the ways is to treat people with respect. And there is some of that going on nationally, but I think you'll find that, we're leading the nation in that work. And you'll be pleased with additional sort of normalization, main model work that we're going to do in this system, which will make us all much safer, I believe. But I'm not quite certain what the numbers are, but I think you'll find we lead the nation in some of this normalization work that we're doing and going to do. I think absolutely, I think that the jails need to be included in this language, although it is difficult for some of us who have been in the industry for a long time. And, I've been in some, we've been using this language for more than a year now. And I'll often get texts or messaging in the Zoom call saying they're not residents, they are inmates, they are, and so it's just all part of the evolution, I think, of professionalism, professionalizing our industry and our society being more compassionate to those that are incarcerated and the challenges that those face.
Thank you, Commissioner. Any other questions for Commissioner Liberty? Senator Searway.
Thank you, Madam Chair. Commissioner, on language and whatever in the books, how do we differentiate, like if they're on probation or they're in jail or they're a trustee? I mean, if you call them all the same, to me, it's very difficult. And that'd be like saying, law enforcement officer, you gotta have them all the same. I mean, how does this work?
Those that are incarcerated, we call residents, and those that have been released and are in our care in a probationary sort of status, we call clients. Those are the terms that we use: residents and clients. And I know that sounds soft to law enforcement officers' ears, and it's a transition, and we're all in transition, but that's what we're currently using: residents and clients.
And for probationers, how do you differentiate?
Yes, Senator. Probationers are called clients. Adult clients and juvenile clients, youth. Yeah.
So if they're on probation, you don't call them inmates, or you don't call them client. I mean, you call them clients, but how do you differentiate if they are a trustee? We'll just say, but yet not on probation.
Yes, Senator. So those individuals that are incarcerated in our care, in custody, they're called residents. Individuals that are on probation and in our care are called are called clients.
Thank you.
I recognize, Senator, this is a transition.
Any other questions? Thank you both for being here.
Thank you.
I'll now close the public hearing on LD 1588 and open the public hearing on LD 1593, which is an act to provide pathways to rehabilitation, re-entry, and reintegration. And Deb, we should have Representative Rachel Talbot Ross with us. Yes, Senator DeChambeau.
Yeah, I wanted to ask if I may have missed something. It says concept draft. I've been looking for an amendment or update. Do we have that? We've got nothing on this at all. Did we, if I missed it, that's my fault, but do you know?
could we hear from the sponsor? I haven't done my homework and looked even at all the testimony yet. So could we hear from the sponsor and see what her answer is?
Yes, yeah, we were, while waiting, that's why I asked that question.
Oh,
Go
yeah,
ahead.
sorry. I haven't had a chance to catch up, so I haven't looked in the files yet. Representative Talbot Ross, welcome.
Well, thank you very, very much. I think we'll get to answer the question of Madam Chair during the testimony, and I'm certainly open to questions. So good afternoon, Senator DeChambeau, Representative Warren, distinguished members of the Joint Standing Committee on Criminal Justice and Public Safety. My name is Rachel Talbot Ross. I represent House District 40, which is part of Portland, and serve as Assistant House Majority Leader. I want to thank you for the opportunity to present LD 1593, an act to provide pathways to rehabilitation, reentry, and reintegration. The Supervised Community Confinement Program, or SCCP, is incredibly important to reentry and the transition of residents from correctional institutions back into their communities. Slowly readapting to life beyond the walls of imprisonment is a much needed step towards success in non-recidivism. SCCP is a system of accountability, first and foremost, and supervision that allows individuals to use the skills they learned through complete programs while incarcerated to phase back into society through a system that gradually gives more freedom and autonomy. This is opposed to complete freedom upon release, which can be very overwhelming after residing within an institution for long periods. SCCP requires work, education, and/or treatment to be maintained in order to continue. This is perhaps the most compelling reason to extend the eligibility period and ensure that more incarcerated people are transitioned to SCCP. So this bill, as the Senator rightfully pointed out, came to you as a concept draft. And what I would like to do is to present to you a solution to the reentry and rehabilitation through the SCCP program. So again, SCCP requires work and education on our treatment to be maintained in order to continue. This is perhaps the most compelling reason to extend the eligibility period, which is what I'm proposing, and to ensure that more incarcerated people are transitioned to the program. None of these activities are mandatory while incarcerated, and all of them are the top factors in lowering recidivism. SCCP promotes rehabilitation and success because it creates accountability on both ends for the offenders to maintain work, education, and treatment, and for the Department of Corrections to make those opportunities available beyond the walls and fences of confinement. So as members of this committee well know, lowering rates of recidivism means safer communities. Ultimately, it also saves taxpayers' dollars. Extending the eligibility window for SCCP offers a more meaningful transition into communities. The current process is just too short to really phase offenders back into society. Reintegrating over a longer period and learning to cope with freedom slowly is much more effective than being thrown from isolation into freedom and having little to no help with the process. Returning members of this committee will recall that we worked on SCCP during the 129th legislature. We were able to reach an agreement and advance a bill through most of the legislative process, all while earning strong bipartisan support in both the House and the Senate. However, like so much of our work, that bill did not ultimately become law due to the early adjournment in 2020. So I'd like to use LD 1593 to bring that work forward and build upon it. I've had many conversations with residents as well as with the Department of Corrections leading up to today. I want to thank both the department and residents for the extraordinary efforts to collaborate and find consensus. It has been humbling and inspiring to work alongside them in this process. So this group that has been working together pulled together a draft amendment for you, which we are still finalizing for your consideration. And we are confident that we will have the language for your review in advance of the work session. I will go into a little bit of detail of what we think it might include. The amendment addressed several components around which we are still working to reach consensus, as I said. But what's really, really great about this work is that we're very close to an agreement that we think will satisfy all and bring this program into a place that really will truly incentivize rehabilitation. So like the intention of this bill from the 129th, I will talk to you about an amendment that will help us extend the time in which a resident of a correctional facility is eligible for SCCP. Currently, as you probably know, that eligibility is you would have to serve 2/3 of your time and be within 18 months of release. Last session, we were able to bring that up to 24 months of release. This amendment that we will bring forward will recognize that time frame. We'd like to move it from 18 months to 24 months. And as you also probably know, currently the Department of Corrections through the Commissioner can add an additional 6 months to that time frame so that we will present a bill that will go from 18 months to 30 months from the end of their sentence, or in the case of a split sentence, the unspecified portion of that time. Unsuspended portion of that time. I'm sorry if this is so confusing. New components of this bill will clarify eligibility and the determination and application process, while allowing sufficient latitude for the department to determine the administrative details. We are also seeking to add a data tracking component. So the committee should know that we are already planning to meet on Monday to finalize the details of the amendment, and we'll provide that to the committee as soon as possible. Again, this bill is to bring forward the work that we did, that you all did on SCCP. As you know, that is one of the only pathways in which individuals can be credited with the success of their rehabilitation and working with the department, be released back into our communities as fully whole human beings. So I want to thank you for your time, and I can answer any questions at all.
Thank you. I apologize. Thank you, Representative Talbot Ross and Senator DeChambeau.
Thank you. And welcome, Rachel Talbot Ross, Representative Rachel Talbot Ross. That's a mouthful right now. Representative, you mentioned 129th bill a number of times. Do you have the number of that bill, of the 129th, please?
Of all the things I wrote down, I did not write down the old bill number.
Okay.
I think I won't even.
Okay, that's something I'm going to be asking of our policy.
Yeah, I can find it while we're still talking.
Okay. Yeah, it's unfortunate that I didn't even know it was about SCCP, or else I would have been more prepared. And frankly, I'm not prepared to ask any further questions. So thank you.
Any other questions for Representative Talbot Ross? Seeing none, thank you, Representative. And we're going to now see, are there other legislators here to testify on LD 1593? Seeing none, we'll start taking testimony for those in favor of LD 15.
Representative Perry is here.
Oh, excuse me. Welcome, Representative Joe Perry.
Well, thank you. Thank you, Madam Chair. It's a pleasure to be here. I've never testified in front of this committee before.
I know. Welcome.
Well, thank you. Senator DeChambeau, Representative Warren, members of the committee, it's a pleasure to be here. I contacted Representative Talbot Ross this morning because I was curious about this bill. And I just wanted to take this opportunity to tell the committee a quick story about a friend of mine, Mackenzie. She's probably not quite 40 years old now. Her father's a friend of mine. Mackenzie struggled with drugs since probably her late teens until her last incarceration, which she's had a few of them, building up to about a 7-year sentence. This past year, she's been scared to death of the COVID virus. She has poor circulation. In her hands is a story in a newspaper about her getting the industry part of the prison together to make face masks at the start of the pandemic. And in the picture of her, you can see her hands are kind of red and swollen from poor circulation, which, as we know, is a terrible precondition to have COVID. So she's been scared to death about serving. So I had contacted both the executive branch and the department to tell of Mackenzie's story and to keep people like her in mind when considering COVID policy. And I can tell you that the Anna Black, who was on earlier, I think that's who I spoke to at the department, and she was fantastic and helpful, gave me a lot of great advice. But the long and short of it is basically you've got to be down to 18 months before you can get out on some sort of pre-release. And so Mackenzie's down to about 2 years. If this committee finds a way forward on this bill and they were support enough to pass it as an emergency, that would likely help Mackenzie. If not, by the time it became law, she'd likely be down to her 18 months, but it would certainly help others. My friend Mackenzie has a loving, supportive family. She's got a place to live. She's very close to a degree from Hudson College, and wants to put this life of drugs and incarceration behind her. So I just wanted to tell you the story of my friend, who would make a great recovered citizen. I'm convinced, with a little help from us and the opportunity. She's close now, but I wanted to just share Mackenzie's story with you folks so you know a bit about her and the opportunities that maybe, you could allow for her.
Representative Perry, thank you so much for sharing Mackenzie's story here with us today. Any questions of Representative
Thank you,
Perry?
Madam Chair.
Seeing no questions, any other legislators here to testify on LD 1593? Seeing none, we're now going to take testimony in support of the proposal. And I see we've got a few folks here that Deb will bring over. First up, we have Attorney Nedow.
Good afternoon again, and thank you, Representative Warren. My name is Tina Nato, and I'm still the Executive Director of the Maine Association of Criminal Defense Lawyers. And we are testifying, as always, I think, with Representative Talbot Ross's bills in full support of this bill. Unfortunately, like I think the rest of the committee, we have not seen all the language, but I do remember long conversations last session about the impacts that basically shortening the time by which people could qualify for the community program, how that would impact people so that they could re-enter the community. I wish it would have been passed last session because I think more people would have been out of prison rather than in prison during this pandemic. Very few people were released by the prisons during the pandemic. So thank you again to Representative Talbot Ross. We look forward to looking at the precise language, and we thank you for your advocacy in making sure that all incarcerated and formerly incarcerated people are supported, respected, and treated with both love and compassion. So thank you.
Thank you. Any questions? Seeing none. Welcome, Peter Lehman.
Good afternoon.
Good afternoon.
Senator DeChambeau, Representative Warren, distinguished members of the committee. My name is Peter Lehman. I live in Thomaston. I'm a formerly incarcerated citizen and a person in long-term recovery. I'm testifying on behalf of the Maine Prisoner Advocacy Coalition, whose goal is to promote restorative practices in order to increase public safety and the health of our community. The bill's title is apt. It's about reentry and preventing recidivism. SCCP was created by the legislature in 1991 to, quote, save money, reduce prison overcrowding, and help minimum security inmates find employment and transition back into mainstream life. The program up to this point has been very modest. In 2018, only Only 4.8% of releases were to SCCP. You on this committee are well aware that almost all residents of our corrections institutions are released to our communities, and you're also acutely aware of the enormous costs of unsuccessful reentry. Recidivism creates more victims and costs us lots of money. Most directly, SCCP can be an important halfway house experience for those reentering the community, combining structure with important supports. SCCP should also be a strong incentive for incarcerated women and men to pursue programs that increase their social and emotional capital for successful reentry. That hasn't worked. It hasn't worked because of cynicism about the program among residents and because of lack of staff support and guidance. A carrot doesn't work if you don't know it exists or don't believe it's real. This bill attempts to address these issues. It calls for more explicit criteria, transparency, and an oversight board that's really aimed at instilling confidence, legitimacy, and support for the program among residents. The bill also calls for early support and guidance for residents beginning early in their incarceration, helping and encouraging their investment in increasing their social and emotional capital. Hopefully, this will make SCCP a viable and motivating goal. Hopefully, this is a result we all fervently hope will be another successful component in the ongoing quest to improve successful reentry and decrease recidivism. We strongly urge you to vote ought to pass. Thanks for your attention and support. And of course, I'll be happy to try to answer questions. Thank you.
Thank you, Mr. Lehman. A real pro. You finished at just the perfect time. Questions for Mr. Lehman?
I'm getting better at it, but mostly it's accidental.
Seeing no questions. Thank you for your testimony. Anyone else here to testify in support of LD 1593? Seeing none. Anyone here to?
Sorry about that. There are people signed up to testify.
Thank you.
Bringing 3 people over.
Thank you, Deb. Good afternoon, Colleen Donlin. Let's start with you.
Great, thank you. Good afternoon, Senator DeChambeau, Representative Warren, and distinguished members of the Committee on Criminal Justice and Public Safety. My name is Colleen Donlin. I live in Portland. Today I'm going to read testimony on behalf of Wendy Smith, a resident at the Southern Maine Women's Reentry Center. My name is Wendy Smith, and I am currently incarcerated at the Southern Maine Women's Reentry Center in Windham, where I'm serving a 5.5-year sentence. I am writing in full support of LD 1593. As you all may or may not know, supervised community confinement is the only form of reentry we have in the state of Maine. For many of us, we will be released with no probation after our sentence is complete. That is a scary feeling. A lot changes in the world at a rapid pace, especially when you have been inside the prison walls for an extended period. Many of us long-timers get denied for reasons such as community sentiment, history of probation, or victim's impact. At no point does what we have done to rehabilitate while inside play a factor in the decision for approval or denial. If we get denied, which we usually do at the maximum allotted time by the facility, there is no written reason giving us areas that need to be improved in order to meet the qualifications. That is super frustrating. The way the good time is dispersed, we are eligible at 18 months at our current release date. This date shifts every month, allowing for errors, which we see a lot of. This also means that if by some miracle we get approved at the maximum time, our time to reintegrate successfully is only around 14 months. Usually we are told by the facility that that is too much time and to try again at around 12 months, leaving us with 9 months to establish healthy routines, form the positive supports and connections that we need to live a healthy, successful life upon release from the program. If we move the time allotment up to 24 months and change the way the good time is dispersed, this will allow enough time to form this healthy lifestyle that we need and develop a normal, natural routine that will be comfortable after the program ends. After all, we still will be finishing our sentence just in the community at home with our supports and loved ones, learning to live again while having the structure and accountability of being monitored closely by a probation officer. I know for me, there is no more that I can do inside this facility but time. I have earned over 100 certificates, some nationally recognized. I'm finishing up my college degree. I established a nonprofit organization well inside to assist the women that are incarcerated with pursuing higher education, relieving some of the financial barriers that we often face, and I have gotten involved with every outside organization that the facility would allow to the fullest extent. I focused on my recovery and rehabilitation, making that my first priority, basically using the Reentry Center for what it was designed to do, rehabilitate. Now I am a sitting duck surrounded with the negativity in this harmful environment, trying to find ways to continue my journey until my eligibility comes for the SCCP program, which I have been told multiple different dates due to the way good time is calculated. If this bill is passed, I will be eligible immediately, as will other wonderful women that have worked just as hard as I have to become who they are today. The facility would have to honor the laws put in place, letting go of their own biased opinions on what is too long for time for people to be on the SCCP program and being forced to look at the data that shows that one is ready for the next step in their journey. I'm asking you today to please help us continue our path to rehabilitation, reentry, and reintegration by implementing this bill into law. It is life-changing for us that are inside these walls, waiting to put our positive change into our communities, reconnect with our families, and prove ourselves worthy of a successful future. Thank you, Wendy Smith.
Thank you very much for bringing that testimony to us. Any questions? Seeing none, Colleen, thank you. Next, we have Anthony Lombardi and Julie Brown.
Thanks, Representative Warren, Senator DeChambeau. Once again, my name is Anthony Lombardi. I'm a legal fellow at GLBTQ Legal Advocates and Defenders, New England's leading legal advocacy organization for the rights of LGBTQ people. I'm also a lobbyist associated with Mary Bonato. She lives in Portland. And so I'm speaking on behalf of GLAAD as well as Equality Maine in support of LD 1593. And, I'll give back the time because I know that it's been a very long day for you. I would just point to our written testimony where we provide some data and statistics about recidivism rates and programs that work. And suggestions. Some of them include, data collection and analysis between interagencies, as Representative Talbot Ross has mentioned. So really, it's just important for us that we showed up to show our support, and we thank you so much for bringing this to the committee.
Thank you very much for your testimony. Any questions? Seeing none, thank you. Next up, we have Julie Brown. Welcome.
I think I unmuted myself. So thank you, Representative Warren and the committee for this opportunity. I'm actually honored today to read the following letter that was written by my stepson, Brandon Brown, who is currently incarcerated in the Boulder Correctional Facility. I am writing this letter today to voice my support for LD 1593, a bill which aims to make long-needed improvements to the ways that the state of Maine reenters prisoners into society after confinement. As it currently stands, the supervised community confinement program is literally the only way that prisoners may enter back into society under a structured process of supervision in our state. The value of an adequate system of reentry cannot be understated. Public safety depends on it. Ending cycles of racism, violence, and harm depend on it. And without the changes that this bill is proposing, we will continue to release people back into society who are grossly underprepared for freedom. Our state is in desperate need for legislation that lends both direction and clarity to uniform the process where inmates become eligible for SCCP. Additionally, it is imperative to transition this legislation towards one that aligns evidence-based approaches and best practices into the criteria for the SCCP eligibility. Using evidence and data around a prisoner's rehabilitative efforts to make educated decisions about their reentry is a demand we need to make of the Department of Corrections. The current SCCP legislation is inadequate in achieving the goals I'm speaking of. The program is being used to transfer a large percentage of short-term prisoners into the community based on factors that are irrelevant in measuring the amount of change and rehabilitation they have engaged in. This is not the best interest of our community. There is common misconceptions about obligation of justice. Many people think that punishment is a way to secure justice for victims of crime. The truth is, the most significant obligation of justice is to ensure that harms are not repeated, that those who break the social contract learn from the mistakes they have made, and grow to accept the inevitable consequences of those mistakes as a process of becoming better, of doing better. Although punishment is a part of this process, it alone cannot invoke humans to change, but serves to only create new resentments and convince offenders that they are the true victims. Please do not accept this misguided version of justice. Pass this bill to give prisoners a reason to change and the chance to obtain the tools needed to re-enter the world as people who are ready to contribute to the communities they once harmed. Our communities depend on it, our families need it, and the victims that we claim to fight for deserve true justice, not just a symbol of it. The vote against this bill will be to stand idly by while the opiate epidemic rages on, while recidivism hovers well above 60%, and while men and women are released from prison with little or no supervision and the lack of hope for the future. Thank you for your time and consideration, Brandon S. Brown.
Wonderful. Thank you very much for sharing Brandon's testimony with us today. Any questions? Seeing none, thank you again.
Welcome.
Others here to testify in support of LD 1593?
Seeing no further hands, Madam Chair.
Thank you, Deb. Those here to testify in opposition of LD 1593? Anyone here to testify neither for nor against LD 1593?
I'm bringing Anna Black over.
Thank you, Deb. Hello again.
Hello again. Hi. I'm sorry, I didn't hear if you said I should just go ahead and get started. So I will assume.
Welcome. Yes, please. Thank you.
Yeah, thank you. Thank you again for having me, Senator DeChambeau and Representative Warren and other distinguished members of the Criminal Justice and Public Safety Committee. I am Anna Black, Director of Government Affairs for the MDOC, and I'm providing testimony neither for nor against this bill. As you've heard, the Maine Department of Corrections has been working closely with Assistant Majority Leader Talbot Ross and as well with residents of our correctional facilities on this bill. Collectively and in good faith, we are in the process of working through revisions, and we firmly believe that we'll have an agreed upon amendment of the bill in time for work session, which I believe is scheduled for next week. So we appreciate the efforts that have gone into the drafting of the language, specifically by the residents of the facility and by the representative, the sponsor herself, for helping to make sure that that action takes place. We recognize that that's a challenge and a lot of work has gone into it. So we thank her and we thank the residents very much for their work on this. The collaborative work being done on this bill outside of the committee is representative of all parties' desires to move beyond the current practice. I think that's the important piece, that we recognize that change needs to happen and we are at the table ready to work on that. And that's all I have. So happy to take any questions. Otherwise, I think you'll hear a lot more at the work session.
Great. Thank you very much. Any questions for Ms. Black? Seeing none. Thank you. Anyone else here to testify neither for nor against LD 1593? Seeing none. Anyone have requests of Jane for the work session before we close this public hearing? Oh, and the sponsor did send me the bill number, Senator DeChambeau, 1756.
Thank you.
You're welcome.
You asked the question if we had anything we wanted to have our policy analysts do. This is a little unusual. I just listened to testimony in support of SCCP in this bill. when I don't believe any members here knew that it was SCCP. I feel like I'm behind the 8 ball in this, in being able to answer any questions. SCCP, especially the way it is currently written, I still believe, I haven't looked it up, that prior to being released from the facility, there is a notification to the DA, to the victims, and to the neighbors. They may have changed some of that. I'm not sure. I don't know if your bill is going to address that. But I didn't hear from any victims. I didn't hear from any DAs or any neighbors of people. I am not opposed at all to SCCP. I think both you and Representative Warren were in the room last year with that other bill that I highly supported it, thought it needed more work, and would still support it. But I mean, we have to look at this. Sounds like the testimony was somewhat prepared, one-sided, and the people I look at are the victims, the DA, and they have a vested interest in this. And we didn't hear any pros or cons. And there are some DAs who truly support this and some who've had bad occasions dealing with it. So that's unfortunate at this late game, time in the game, I should say. So I would ask Jane there's just so many DAs, if you could send this bill to the DAs and ask if they wish to join us or send us some testimony we could at least read or attend the work session. Thank you.
Any other requests from committee members? Seeing none, I'll close the public hearing on LD 1593 and thank the representative for bringing it to us. And then I'll open the public hearing for LD 1674, an act to improve access to medical care for and expand the rights of adult clients of state correctional facilities. And this is Representative Talbot Ross.
You're lucky. You get me a couple more times today.
We're happy to have you here, Representative.
I thank you very much. And I will say that for LD 1674, we are also amending this bill. I do believe that you have the language for it. And I will read my testimony. Good afternoon, Senator DeChambeau, Representative Warren, and distinguished members of the Joint Standing Committee on Criminal Justice and Public Safety. I am Rachel Talbot Ross, representing House District 40 in Portland, and serve as Assistant House Majority Leader. Thank you for the opportunity to present 1674, an act to improve access to medical care for and expand the rights of adult clients in state correctional facilities. This bill is a product of a great deal of work with residents in Maine's correctional facilities to address concerns regarding the access they have to medical care. It's an issue I believe you spent part of this session talking about at length. It is based on the basic premise that residents should have the opportunity for input when it comes to appropriate, adequate medical care. It also seeks to codify several protections for residents to that end. I know you've also just previously had a discussion about language. What's important to understand at the heart of this bill is to understand that residents in our correctional facilities are also patients and clients and deserve access and a voice in their own medical care. We have had many conversations with residents, both male and female, as well as the Department of Corrections, who you may hear from later, leading up to today. I want to thank both the department and the residents for the extraordinary efforts to collaborate and find consensus. What is particularly challenging, as you probably can imagine, during COVID is to be able to meet and communicate with residents on a regular basis. And I want to acknowledge and appreciate Representative Bill Pluker, who spent countless weeks in communication on Zooms with residents of all several facilities to try to address not only the medical care concerns, but other concerns with the department, and I want to thank him for his work on that. The group that I'm talking about is working to finalize a draft amendment for your consideration, and we are confident we will have language for you to review immediately. The amendments address several components around which we're trying to reach consensus. The good thing about this work and the work of the previous bill is that we are trying to come with consensus, and we are very, very close in doing so. So I'd like to walk you through what an amendment will look like. First, LD 1674 in its current state, you'll notice, establishes resident healthcare committees. The amendment will do away with these healthcare committees and instead will require the chief administrative officer, which we all know is the warden, requires the chief administrative officer, the warden, to seek input from the residents as opposed to putting together a resident healthcare committee. So it's to seek input from residents of the facility on at least a quarterly basis, that hasn't changed, relating to the adequacy of the medical care and mental health services being provided, and suggestions for the development, expansion, and improvement of those services. This could take the form, for example, of a subcommittee of resident advisory councils that are currently in place in each of our facilities. Although the amendment that we'll put forth does not prescribe that. The amendment will also require documentation of the input of these efforts, and it's my hope that in the department will include all of that input from residents in their annual reports to this committee. So once again, the current bill established resident healthcare committees. What we will bring forward to you is an amendment that does not establish those committees, but allows the warden and the facility the discretion to bring residents together to talk about medical and healthcare needs. That's the first component of the change to this bill. The second change to the bill is we will require the department to adopt policies delineating between the searches of a client's cell or their living space and the physical property and searches of on a client. In other words, the original bill asked for the department to go through a rule changing process to delineate when you are searching a cell or a living space and you are searching a person's body cavity. We agree on this point, and the department has agreed to adopt some policies that will make for that delineation. The other thing we are talking about is addressing opportunities for residents to be able to address a couple of things. The first is there is, and I think you've heard of this earlier this session, the cost barrier for residents trying to access their medical records and their medical results. Currently, the department charges 25 cents per page for such documentation. We are hoping that the department will work with us to ensure that no one has to pay for a copy of their medical results. In other words, if you go get a blood test, you would have to pay 25 cents to learn those results of that blood test. We're hoping that the department will agree with us that that is a cost barrier for some residents. We're also hoping that the department will work with us on the issues around privacy and how best to protect residents who, again, are patients in their privacy when they go off-site to medical appointments. And we're hoping that the transportation of a resident to a medical appointment can be gender appropriate when possible, and that the medical appointment between the resident and their doctor can be held in privacy, again, to the extent that security and other kinds of considerations have been made. So with that, I will just close and say the bill before you that was printed, we will amend. So to give the department the opportunity to work with residents by each facility on medical and healthcare concerns, and then hopefully establish the appropriate corrections officers and privacy of medical services into law. So I can take any questions that you'd like.
Thank you, Representative Talbot Ross. questions? I have Representative Pickett.
Yes, thank you, Madam Chair. Thank you, Representative Talbot Ross. I'm a little concerned with the part where it says the bill provides the client with the right to be transported and accompanied to medical and mental health service providers by corrections officers of their client's gender or of an appropriate gender. I know that there may be some correctional facilities, maybe state correctional facilities that have the opportunity to do that. But have you had that conversation with the Department of Corrections in regards to that, of whether that's going to create an issue for them? Because we're just talking about transporting from one place to another. And the second part of that is I wonder if you talked about the possible concern of when they're having the services provided to them, of them being without the presence of the corrections officer. Now, I understand there's some things that, especially if it was a female resident and you had a male corrections officer and they were going to do some kind of a procedure or something or exam, that I understand that part. But have you talked with them about the possibility of the actual security? Because they are a resident, and that corrections officer is in charge of their security. And when you're out of sight and stuff, there's that thing. You have a responsibility, and I'm sure these correction officers take that responsibility very seriously. So I wonder if you've had that conversation with the Department of Corrections and worked through that.
Well, thank you, Representative, for those two questions, because you nailed it. Those are the two parts of the original bill that we're still working on. And I will say, Representative Pickett, Section 5, number 10, appropriate corrections officers, in all likelihood, that will come out of the bill for reasons around workforce, really. We've heard from the department that they will take every possible measure to align the gender of the resident with a corrections officer. But because of workforce challenges, it's really not something that we can mandate. And so I thank you for pointing that out, because that in all likelihood will be coming out of the bill through the amendment. We had talked about it a number of ways. We thought about writing in to the extent possible, but then it's just not possible given some of the challenges around workforce that you well know of. So Section 510 will come out through the amendment. To Section 6, number 11, around privacy of medical services, this is really, we're still talking about it for all the reasons you just mentioned. But it was really one of the places that the women, particularly at the Southern Reentry Center, Women's Reentry Center, really would hope that we could give a lot of thought to. And that is because of what you just mentioned. Unfortunately, this is not a criticism of the department, but you could be, as a female, you could be in a medical appointment trying to get a pap smear, and there is a male officer in that room. As you can imagine, that is an incredible invasion of privacy. And I've heard through the residents that some of the information gleaned during that private interaction between the doctor and the resident has not been kept confidential by correction officers. And so that information at a very intimate private level can then be shared throughout a facility when that should be the ultimate private relationship between a doctor and a resident and a patient. So we are still at odds on this, Representative, because we've got to get it right. Residents are transported to these appointments in shackles, as you know, 5-point shackles. There are security concerns, certainly. And doctors can't be the ones deciding on whether the security officer should remain in the appointment or not. That's up to the Department of Corrections. So it's a sticking point, Representative, and we're going to have more conversation on it. Again, I thank you for calling it out. That one, we'd love your help. I'll say it that way. If anybody has any help with this, we'd love it. Welcome.
Thank you.
Senator DeChambeau.
Yes, thank you. Two things. One, instead of that committee, that resident healthcare committee, and you said your amendment will talk about more that the chief administrative officer, and you use the term warden. I'm just gonna put a bug in your ear about this. There are two places that don't have wardens. That's BCF, Bolduc, and the Southern Maine Reentry. And I would ask that it would be the chief administrative officer or director of that facility. We've had these discussions before. The warden at the Maine Correctional Center is responsible for the one down the hill also, although they have a director. But the director is the one that's really closest to the issues of women issues. So you can consider that or not, but it's one of those things you don't want it to let it go by and said I should have. So the other thing I'm concerned about, because this went into effect just about when I was ready to leave, so I'm not familiar with it. But when you talk about 25 cents a page for their medical file or $5 for their prescription, do you know if that's money that goes into the general fund of the Department of Correction, or is because it involves the medical staff, you know, ordering the prescriptions or printing out the medical file? I'm wondering if that's a task of the medical department, therefore it translates that it's the contract provider that gets that money. Where does that, who decided I need 25 cents a page, and where does that money go? And who decided inmates have to pay $5 for their prescription, and where does that go? So I don't know the answers to that.
Thank you, Senator. To your first point about the language in the bill requiring the chief administrative officer, or the warden, that language was provided to us by Anna Black, who I think is going to be testifying on this bill. You can ask her why the department chose to use the CAO in this language. It was not the language that I had. We definitely took it directly from the department. So I'm sure Ms. Black will be able to answer the question, although I think you make a great point and have no problems with changing the language, as you have rightfully pointed out. To your second point, again, Anna Black will be here to answer that technical question about where that money goes and who decided on the cost. All I can tell you, Senator, and I appreciate you bringing this up, is it is a barrier for many of our inmates and residents. And one of the pieces of this bill that won't change is the department agrees that indigent residents should not be billed for these costs. As you all know, once an indigent resident is released, that bill follows them. And so I think that they'll be able to talk about that aspect of it as well. But I thank the senator for bringing it up. We're wondering why 25 cents a copy as well, when it costs maybe about 2 cents to make a copy. The one area, Senator, I'll just mention to you real quickly that I do agree with the department on, and that is if some residents may have medical files that are 75 pages, 100 pages long, and so cost would be an issue for the department to provide that completely free. If a resident asks to have their medical record copied 3 or 4 times a year, that could be a burden to the department. So that is an area that you can talk to Ms. Black about, but we are cognizant that it might have a fiscal cost to the department.
Just to follow up what you just said, you do know that even if they had those copies, that is not something they can bring into their housing unit. It has to be mailed out. Okay, I think, thank you.
Thank you, Senator DeChambeau. Any other questions for Representative Talbot Ross? Seeing none, thank you, Representative, for bringing this bill forward. Any legislators or co-sponsors here to testify? Seeing none, I'll now call for proponents of this bill. Please raise your hand and we'll bring you in. Good afternoon, Jan.
Good
Welcome.
afternoon. Senator DeChambeau, Representative Warren, and honorable members of the Criminal Justice and Public Safety Committee. My name is Jan Collins, and I'm Assistant Director for the Maine Prisoner Advocacy Coalition. I am here today to speak in favor of 1674, an act to improve access to medical care for and expand the rights of adult clients of state correctional facilities. And I have to admit, I'm sorry to hear that the amendment about the committees has been made. I have some comments on why I think that's it would be better to have them. LD 1674 places in statute several procedures that are considered best practice in medical facilities. And the first one is the committees. The bill establishes did establish residential health care committees in all adult correctional facilities. These health care committees will be able to advocate for preventive health practices that will benefit all residents. Health insurance companies across the country have for years encouraged subscribers to make healthy choices and have been the vehicle for encouragement, education, and rewards. Healthcare in corrections has until now operated under a model in which healthcare is something that is done to the resident, not something that the resident participates in. These committees would also give residents the skills needed to be their own best healthcare advocates upon release. I'd like to see that amendment changed. Second, the bill exempts those who meet the Department's of Corrections definition of indigent from fees for prescriptions, prosthetic devices, medical and dental services, and provides for free copies of medical records and test results to inmates. This change is in keeping with the department's own policy of prohibiting inmates from incurring debt, and it allows inmates access to the information needed to make good decisions about their own health care and healthy choices. And I just want to note that inmates, even those that work, and there's only about 25% that have paying jobs, may get paid as little as 5 cents an hour. And to have 5 hours of work for one piece of paper seems like an exorbitant cost. Third, I, as well as members of the public, have cringed and read stories about male corrections officers accompanying female inmates to gynecological exams and even into the delivery room, and at times making crude comments during the procedure. It should be without question that female corrections officers should be the first choice to accompany women to exams. Lastly, the bill requires the DOC to delineate in policy between searches of property and body cavity searches and to ensure that the process for each is trauma-informed and gender responsive. All of these updates are common sense approaches that will improve healthcare for all and reduce unnecessary trauma for inmates and corrections officers alike. Thank you for your support.
Thank you, Jan Collins. Any questions? Seeing none, thank you very much for your testimony.
And thank you.
Anyone else here to testify in support of LD 1670? Excuse me. Tina Netta, welcome.
Thank you, Representative Warren, and good afternoon again, everyone. MACDL is testifying in support of LD 1674, and thank you again to Representative Talbot Ross for bringing forth this bill. When a person is sentenced by a court to serve time in prison, that person is remanded to the care and custody of the Department of Corrections. While a person is in custody, we must do all that we can to ensure that they receive the best care that we can provide. It is both our moral obligation and constitutional duty as a state to do so. MACDL members worry a lot about our clients, especially our incarcerated clients who are or who may become ill. We support any and all efforts to improve our clients' access to quality and appropriate medical services. We also support prohibiting the charging of any fee against our clients for any medical care or services or copies of their own medical records. Our clients should also be entitled to privacy when they are examined by or consulting with their medical providers. Corrections officers should only be present if the medical service provider deems it necessary. Requiring that transportation for our clients to and from medical appointments or providers by gender-appropriate staff is also terribly important. Stories I've heard from clients regarding strip searches is enough to make my skin crawl. We must do better for our clients in state custody, a disproportionate number of whom have suffered unspeakable physical and sexual trauma in their lives. Safety inside prison walls is important. So too is the inherent dignity of each person who is ordered to the care and custody of corrections staff. Thank you very much. Happy to take questions to the extent I'm able to answer them.
Thank you, Ms. Neto. Questions? Seeing none, thank you.
Thank you.
Anyone else here to testify in support of LD 1674? Seeing none, anyone here to testify in opposition to LD 1674? Seeing none, anyone here to testify neither for nor against LD 1674?
Hi again. Hi.
Hello again. Welcome.
Thank you. Thanks for having me back. Senator DeChambeau and Representative Warren and other distinguished members of the Criminal Justice Committee. I'm Ann Black, Director of Government Affairs for the Maine Department of Corrections, providing testimony neither for nor against LD 1674. I will be very brief since you guys are winding down and there isn't much new I can provide. I will certainly say, however, that we are working closely with the sponsor and with residents of the facility and other stakeholders on this bill. As the sponsor mentioned, we have agreed to a number of revisions and we plan to continue to work those. In our testimony, I did outline some of the revisions that the sponsor mentioned. I think all of the revisions that the sponsor mentioned, plus a few others. So it's in there as testimony if you want to take a look at it. I'm happy to answer questions and also happy to bring with us to the work session more subject matter experts as necessary, as related to the bill. So I will stop with that.
Thank you. Any questions for Ms. Black? Seeing none, thank you very much. Anyone else here to testify neither for nor against LD 1674? Seeing none, before I close the public hearing on the bill, does anybody need anything specifically from Jane for the work session? Seeing no hands, I'll close the public hearing on LD 1674. And I'll open the public hearing on LD 1675, an act to amend certain provisions of Maine's drug laws, with Representative Talbot Ross. Welcome back, Representative. Oops, you're on mute.
Thank you very, very much. I've appreciated the opportunity to hang out with all of you guys this afternoon. And I will say I very much appreciate the patience and the flexibility of the committee thus far. So Senator DeChambeau, Representative Warren, and distinguished members of the Joint Standing Committee on Criminal Justice and Public Safety, I am Rachel Talbot Ross, represent House District 40 in Portland and serve as the Assistant House Majority Leader. Thank you for the opportunity to present LD 1675, an act to amend certain provisions of Maine drug laws. So LD 1675 is actually a fairly simple bill. It recognizes that relieving the government of its burden of proof has not helped us to stop overdose deaths. It is a bill that seeks balance. Yes, The government has a legitimate interest in arresting people for drug trafficking, but the government has to prove trafficking occurred. It is wholly inappropriate for the government to create legal loopholes and use it to saddle people who are not selling drugs with felony drug trafficking charges. It is also a bill that seeks to correct the errors of the 1980s and the 1990s when lawmakers across the country and here in Maine punished crack cocaine more severely than powder cocaine. It was a misguided effort to punish poor people, and particularly African Americans, so that they wouldn't use drugs. As we now know, criminal punishment just worsens conditions in these communities. In 39 other states, the government must have evidence that a person intended to sell or distribute drugs before they can lock someone up for drug trafficking. They must have evidence. The few states that don't require intent to get a conviction all have much higher threshold amounts than Maine. Right now, under our laws, a person can be convicted of drug trafficking for having on them a mixture weighing 2 grams that contains any amount of heroin or fentanyl, even if there is no evidence that the person intended to sell or distribute those drugs. I must repeat that. The law allows a conviction for drug trafficking if a person possesses a small amount of drugs and does not intend to sell those drugs. An increasing amount of street drugs are laced with fentanyl, as you know, meaning more people are subject to a felony drug trafficking conviction that can send them to prison for 10 years just for having a small quantity of drugs on them. I have spoken with people in recovery who say that 2 grams, which is referenced in the bill, is a small amount when we're talking about someone with an opioid use disorder. It is what many people who have substance use disorder can consume before lunch in a 4 or 5 hour period. The folks I talked to were not trafficking drugs. They were stuck in a cycle they found almost impossible to get out. You have been talking to these folks, many folks, all session long, and know that many were houseless and were arrested over and over again in a revolving door that led to misery and despair rather than recovery and better health. Among people who use drugs who are already vulnerable, this law is most likely to affect those with the fewest protections. People without money to pay attorneys or other legal experts, women, and people of color, especially African Americans. Felony drug trafficking arrests of women have risen 25% over the past decade in our state, and over half of our new women's admissions to prisons in recent years have been for drug crimes. Many of the women that I have worked with at the Maine Correctional Center are there for drug trafficking, but they are also themselves victims of abusive relationships, poverty, and substance use disorder. And of course, there is the issue of race. We must talk about that. Black people make up 1.6% of Maine's population, but account for 21% of Class A and 15% of Class B drug arrests. So 1.6 is the population, 21% for Class A, 15% for Class B drug arrests. The numbers are severely unbalanced, even accounting for arrests for people from out of the state. Our trafficking laws are not keeping us safe, but they do seem to disproportionately harm those with the least capital. So one thing that unites us as legislators is our desire to do the right thing by our constituents. And each of us has too many constituents who have lived with substance use disorder. In order to help these constituents get their lives back on track, they need access to employment opportunities, safe housing, and healthcare. They do not need to be threatened with felony drug trafficking charges that can derail their future housing, employment, and even educational opportunities. If drug trafficking is happening, the government can use the evidence it finds to prosecute and get convictions. If drug trafficking is not happening, Let's not needlessly harm people with deeply stigmatizing criminal convictions that hamper the ability to get their lives back on track. I'd be glad to talk to you about the specifics of this bill. There are a number of people who are here today that have put a lot of work into this. I know you've been talking about this all session, so I welcome the opportunity to continue to talk to you. I am open to working with this committee in trying to address over 500 people last year lost their lives in this state to drug overdoses. I know you've been working on it hard. We must do something. Arresting people out of this problem is not the answer. I know you all understand that. So I look forward to working with you to try to bring something forward this session on this issue. Thank you all very, very much.
Thank you, Representative Talbot Ross. And I see we have our first question from Representative Costain.
Thank you, Madam Chair. I have two questions, ma'am. Thank you, Representative Ross, for being here. My first question is, and I don't know if you can answer this, is there any medical reason whatsoever that a person on the street should have fentanyl?
Thank you, Representative. I am not a medical professional, and I would not try to propose any answer to that question other than one of compassion. And I would say, likewise, there's no medical reason why people consume alcohol. There's no medical reason why a person would smoke tobacco. There's no medical reason for a lot of substances that society has deemed acceptable for consumption and has not criminalized.
Follow up, ma'am.
Yes, please.
So we all know, I mean, we've heard it. I've been on this committee 3 years now. We all hear and have heard fentanyl kills people every day. It's probably the most dangerous drug we have out there at this point. There should be no reason whatsoever that fentanyl's on the street. Do you agree with that?
Representative, thank you for the question. I do agree about the dangers of this. I know the precious lives that it has taken. What this bill does is it does not decriminalize fentanyl. It doesn't decriminalize heroin. It doesn't do any of those things. And I really hope that you understand what the bill does. This bill is taking out of the definitions of trafficking and furnishing the weight of drugs that amount to personal use. We embedded in our definitions in Title 17A are weights that make it a proxy between the possession of that weight and trafficking and furnishing. What this bill does is we merely take that weight out of the definition because the mere possession of these drugs doesn't equal the trafficking and selling and production of the drug. So I just want to make sure you understand what we're doing. In 39 other states, they've made this case that the personal possession of what one would consume in a day, that weight alone does not indicate that they're trying to traffic or sell or produce that drug. It means they're personally consuming it. So I'm really want to make sure you understand, I'm not in favor of decriminalizing a lot of drugs. I mean, we can debate that. I know you've heard from a number of different bills this session that actually looked at the appropriate response to drug use. And that's what I'm committed to, is looking at the appropriate public health, public safety response to drug use, and to make sure that we put our dollars into treatment and harm reduction services. But it is not, I hope you would agree, that the government should prove the intent for trafficking and furnishing, and not just use the mere presence of a drug to lock someone up for up to 30 years for a drug felony charge.
Yeah, thank you. probably won't agree with you, as you probably know that. Fentanyl is deadly, and any amount of fentanyl, I don't care if you get a gram, okay, should be a felony charge. So I don't care if it's for your own use or what it is. I can't agree with that. So my other question, if I may.
Yes, Representative, please.
So your statistics on, you said 1.6 persons of color in the state of Maine, 21%, I believe, was Class A crime, 15% was Class B crime. Do you have any statistics that said that those people were actually residents of Maine, or are they coming from Maine and other states, and that percentage of color is for both? Do you have any, did you see what I'm trying to get at? It's the people that are, I've heard many times the 1.6 and the 21%. Today, I've the 15% something new. I didn't realize the Class B crime was 15%. But what I'm asking, I guess, is, are those Maine residents, or are they Maine residents and other state residents?
Yeah, I thank you for the question, Representative. The Council of State Governments, who I think you all know from the past 2 years, was working with this committee, members of this committee, and the public and other stakeholders. That those data sets come from their work. What they were able to conclude is that even when you account for those who come from out of the state, we are still profiling and targeting people of color with drug arrest. So the 1.6% is the state demographic of those who identify as Black African American, and the percentage of drug convictions in Class A and Class B represent the totality of people here in the state.
Okay, thank you. So I have to, again, respectfully disagree with you on that, because I don't believe police officers in the state are targeting people of color or anything. They're targeting drug users and drug sellers and traffickers. So thank you.
Yeah, and the only thing I would add, Representative, is that there is no evidence that Black and African American population have any more criminogenic behavior or any greater drug use than their white counterparts. And so there has to be something that accounts for that disproportionate number of arrests and convictions with these felony drug charges.
Any other questions for Representative Talbot Ross? Representative Costain, I'm going to encourage you to ask your question about fentanyl to future testifiers, because it's what I hear about out on the street is there isn't really any drugs out there that doesn't have fentanyl in it. So I want us to get that information, because I think that might change your thoughts around what we're talking about, is that fentanyl is everywhere and in everything. And I think we heard that from Roy McKinney the other day, excuse me. So let's keep that question front and center, because I think it's an important one, and I appreciate you asking it. Any other questions for Representative Talbot Ross? Seeing none, I'm now going to ask for legislators that are here or co-sponsors. I see Representative Hickman is here. And I'll scan the list. Welcome. I said representative. I meant my senator, Senator Hickman. Welcome.
Whoa, wow, a storm is like going through here at this very moment. So excuse me. Good afternoon, Senator DeShambo, Representative Warren, and distinguished colleagues of the Joint Standing Committee on Criminal Justice and Public Safety. Storm or not, it's a glorious, magnificent Friday afternoon. The baby goats are growing like weeds. The garlic is up to my knees, and y'all have been talking about language for most of the morning, and that makes this poet very happy. I am Senator Craig Hickman. I represent Senate District 14. 11 towns in southern Kennebec County, including my hometown of Winthrop and Madam Chair's town of Hallowell. I Zoom before you today as the lead co-sponsor in support of LD 1675, an act to amend certain provisions of Maine's drug laws. In the words of inimitable Nobel laureate, the late great Toni Morrison, the first African-American woman to receive a Nobel Prize, further contextualized by the writer Maria Popova in her blog, Brain Pickings, quote, language can never pin down slavery, genocide, war, nor should it yearn for the arrogance to be able to do so. Its force, its felicity, is in its reach toward the ineffable. Be it grand or slender, burrowing, blasting, or refusing to sanctify, whether it laughs out loud or is a cry without an alphabet, the choice word, the chosen silence, the unmolested language surges toward knowledge, not its destruction. In a sentiment that calls to mind James Baldwin's memorable meditation on language and life, quote, it is experience which shapes a language, and it is language which controls an experience, end quote. To that, Toni Morrison adds, quote, word work is sublime. Because it is generative, it makes meaning that secures our difference, our human difference, the way in which we are like no other life. We die. That may be the meaning of life, but we do language. That may be the measure of our lives, end quote. So what, Madam Chairs and members of this committee, you ask, does this erudite literary analysis have to do with this bill? Well, never mind that both Toni Morrison and James Baldwin, my favorite American writers, thinkers, and artists, worshiped language like religion. Baldwin even wrote a book in 1979 entitled, If Black English Isn't a Language, Then Tell Me What Is. Besides all of that, language is the law. The law is the language that governs us. To wit, the English language is our stock in trade. It is the currency of our laws. It is the medium of our public discourse. We do language. It is, for better or worse, our lingua franca. This bill, LD 1675, would restore integrity, honesty, and clarity to our drug laws. The bill will curb a government that has gotten too comfortable playing fast and loose with the English language. A government that redefines ordinary words to strip freedom from ordinary people. LD 1675 would do two simple things, as you've already heard. It would give the words furnish and traffic their dictionary definitions. It beggars belief that under current law, the mere possession of 2 grams of heroin or fentanyl is legal evidence that a person is trafficking or furnishing these things. Let me say that again. To possess, to hold, to have something under the language of the laws of our state is to traffic that thing, is to furnish that thing. Think about that. Our laws have given an ordinary word, traffic, an extraordinary meaning, an untenable meaning. Ask any Mainer on the street, in your congregation, or at your town meeting. Does the word possession mean the same as the word distribution? Is the word possess really no different from the word sell? What do you think they would say? I believe we all know. They would say no, those words don't mean the same thing. And they might be as baffled as I was when I discovered this perversion of language in the Maine Revised Statutes. In George Orwell's 1984, we see the dangers of these types of perversions. That precinct novel is set in a fictional dystopian country named Oceania. There is one political party in Oceania, and it is called the Party with a capital P. The party has a ministry of truth, which decides what is true and what is false. Citizens of Oceania know only what the party wants them to know. The party slogan is, war is peace, freedom is slavery, ignorance is strength. For some of the members of our own republic, but increasingly for all of us, as far as drugs are concerned, war is peace, freedom is slavery, ignorance is strength. The failed drug war initially waged against Black people and Black communities It was waged by Republicans. It was waged by Democrats. The party with a capital P that prosecuted the drug war for all intents and purposes was our very own party with a capital P. It is this failed, disastrous, and heinous war waged by a government on its own people that we owe the perversion of the English language in our statutory scheme, a perversion this bill seeks to reverse. Yes, the drug war initially threatened the freedom and dignity of Black people and Black communities across the nation, but now it threatens all of us. As we've heard, fentanyl's everywhere. The devastating pandemic took the lives of hundreds of Mainers last year, but the drug overdose crisis took more. That is because the government has been criminalizing people for harming themselves, for committing crimes without victims. One method of this criminalization is to give meaning to words that would shock and befuddle any and every ordinary person. Government will continue to run amok unless we are vigilant, and here government has run amok. If, as the Nobel laureate told us, language can never pin down slavery, genocide, war, then we must not allow the government to turn the language we use every day into chains that imprison the people. You possess, therefore you traffic. You possess, therefore you furnish. Everybody knows that's not true. This committee today or in the future, near future, has the power to stop that perversion. This bill will rein in a government that has grown too comfortable twisting the English language to shackle the people. We do language. So let's do this language right for the sake of our liberties, for the sake of our freedoms, which I know we all hold dear. I urge you to restore integrity to the language of our drug laws and vote unanimously ought to pass on LD 1675, no amendments necessary. And if I may, Madam Chair, I want to talk a little bit about fentanyl. To Representative Costain's point, should fentanyl be on the street? Probably not, but it is. Some of you know, 3 summers ago, I was burned near death in a terrible farm accident. 30% of my body was burned from head to toe. In the ambulance on the way to Maine Medical, where I was then eventually life flighted to Portland, and I'm screaming in pain because I wouldn't wish being burned on my worst enemy. I asked the technician in the ambulance what she was about to put in my arm in order to help me deal with my pain. And she said fentanyl. And I said, oh, wait a minute, no, I don't want that. She said this is the real reason for fentanyl. This is what fentanyl is for. It is a pain reliever, Representative Costain, and it's used in hospitals on burn victims. And I didn't want it because I knew how addictive it might be, could be, for someone like me. And I said, I don't want it. She gave it to me anyway. Now think about that. So I get life flighted to Portland, and then in order to try to save me from infection, they have to rip off all of my skin. About the most painful thing, again, that I would ever wish on a person. There is no amount, I couldn't give you a scale for that. And so they asked me if I wanted more fentanyl to deal with the pain. And I said, I don't even know if it's working. I'm still in pain. You gave me some, it must wear off in 5 seconds. They kept pumping fentanyl into my arm and I kept saying, I don't want it. So finally, this very kind nurse came into the hospital room and he said to me, all right, we will stop giving you fentanyl, but we have to tell you that you're going to feel more pain than you ever felt. And I said, I don't care. Just rip the skin off of me and leave the fentanyl alone. And so I just want to say that if I had become addicted to fentanyl after that experience, trying to save my life, and then sought it out on the street, and then had it in my possession, if I was pulled over, I wouldn't be sitting in front of you here today as a state senator for Senate District 14. I'm happy to take any further questions if the committee has them.
Thank you, Senator Hickman. Any questions for the senator? I will say that I've spent a decade now of my life working on drug policy, and I've never heard it spoken about so beautifully. So thank you for that. Any other legislators here to speak on LD 1675? Seeing none, I'm now asking for testimony in support of LD 1675. Good afternoon, Peter Lehman.
Good afternoon. Long day. Senator DeChambeau, Representative Warren, distinguished members of the committee. My name's Peter Lehman. I live in Thomaston. I'm a formerly incarcerated citizen and a person in long-term recovery. Testifying on behalf of the Maine Prisoner Advocacy Coalition, whose goal is to promote restorative practices in order to increase public safety and the health of our community. As you probably know, it's a crime in Maine to sell liquor without a license. Alcohol is the most dangerous drug in Maine, so this is a serious offense. How much beer, wine, or liquor would you have to have for us to assume that you were illegally trafficking alcohol? Think about it. What if you filled your car with alcohol and with bottles of alcohol and compounded your offense by transporting it from New Hampshire to Maine? Would that be enough? Or what about if you filled a trailer? Or how about if you filled your basement or garage with cases of liquor? Should we send an officer to give you a citation or haul you to jail? How much would you have to possess for us to infer that you are committing the criminal act of selling alcohol, this dangerous drug? That's a question I'm asking you. Is there any amount? And my answer is no. I don't know about you, but my answer is no. I'd want to see some other evidence of selling, like posters or flyers you circulated in the neighborhood, or the sign out in front of your house, or observing sales. You already know what I'm getting at. No amount by itself would be sufficient. We would want the actual elements of the crime pled and proven. That's all that's being asked, as we do with the proposed change in this trafficking statute. As it stands, the trafficking statute is a dream creation of a lazy prosecutor or attorney general who wanted to run up her own body count of convictions and to give the illusion that they were doing something about the drug problem. This is a tool of lazy prosecutors. There's no evidence that this old trafficking statute ever successfully reduced drug use or solved any drug problem. But there's abundant evidence that this trafficking statute cost us a lot of money, paying for policing and imprisoning traffickers for obscene amounts of time, and compounding those costs as a result of the crack scare that made it even easier to convict and give enhanced sentences to users of cocaine base. Again, with no evidence, absolutely no evidence of successfully reducing drug trafficking and drug use. Please support 1675 to increase justice, save money, and save our language, as Senator Hickman has so eloquently pointed out. Thank you.
Thank you, Peter. Any questions from the committee? Seeing none, thank you for your testimony. Next, we'll go to Tina Nedow.
Thank you, Representative Warren, and thank you, Representative Talbot Ross, for this important bill. MACTL submitted written testimony as authored by Matthew Morgan. That is available. I wanted to touch on a couple points, however. The first is something I think we can all agree on. I reviewed the very short testimony submitted by the Maine Prosecutors Association, who agree that the sentencing disparity between powder and crack cocaine is archaic and should no longer be used. I think we can all agree on that. There's no good reason based in logic and sense why that disparity should continue to exist, and we should seriously consider getting rid of it. And I hope you all decide to do that. When it comes to furnishing and trafficking based on possession, I think Representative Costain said something that even a gram of fentanyl should be a felony. Well, it is. 0.2 grams of fentanyl possession is a felony under our current law. And that's not just fentanyl, that's any substance containing fentanyl. So even minuscule amounts of fentanyl, if found in a substance that weighs more than 0.2 grams, which is a fifth of a paperclip weight, is a felony possession charge. There is no need to charge possession of minuscule personal use amounts of drugs as trafficking or furnishing. That is a very heavy bludgeon that is put over the heads of criminal defendants to encourage them to plead guilty to something lower just to avoid a trafficking conviction. It's a tool that is unnecessary. Reading the prosecutor's testimony again, I'm confused. They said, in this day and age when so many people are dying, we can't reduce the penalty for possession and raise it to trafficking. We can't do that. What I don't understand, which I'll never understand, where have our laws gotten us as far as preventing deaths? The current laws have done nothing. So for them to hang on to those old laws with both hands for dear life and say we need them is ridiculous. It flies in the face of what we all know. These are unnecessary felonies. They can charge them as possession. They do charge them as possession. But charging them as trafficking and furnishing, trafficking means something different. You see that on somebody's criminal history. You're seeing something more than just somebody who was in active use at the time. You're seeing someone who is a predator. And that's not who these people are that these laws target. So it's high time that we fix them. I'd be happy to take questions.
Thank you, Ms. Neto. The first question comes from Representative Morales.
Thank you, Madam Chair. Thank you, Attorney Neto. I was wondering if you could help us just by explaining what kind of evidence can be used to prove intent to traffic in court.
Great, thank you for the question. Intent to traffic could be things like many baggies of drugs, even many baggies empty of drugs, a large amount of cash, evidence of a hand-to-hand transaction, for example. Even one can elevate it to trafficking, no matter how minuscule the amount of drug. But there's a lot of evidence of trafficking that can be ascertained by an investigation or by other circumstances apart from just the mere possession. And
Thank
it's
you.
done all the time.
Sorry about that. I have to keep this muted because the landscapers are here and my dogs are going crazy. I have Representative Costain and Senator Searway.
Thank you, Madam Chair. Ms. Neto, so back to your comment about myself. I guess the real question here is it really the possession of the drug, or is the real issue here the lack of rehab and rehab centers and places for people to get help? I think, go ahead, answer that question, I guess, first.
I'm going to try to. So I think the ultimate issue for anyone who's struggling with substance use is recovery and treatment. Whether you charge them with their felony or misdemeanor,
that's right.
That's not going to be the thing that turns them around. I think my point in addressing your earlier comment is that we already have felony level possession for minuscule amounts of any substance that contains any amount of fentanyl. So you're concerned that people are getting off perhaps too easily in possessing fentanyl. While I understand that might be the perception, the actual law is even extremely small amounts can be prosecuted as felonies, and they are prosecuted as felonies.
I follow up, ma'am.
Yes, please.
Yeah, so yes, I agree. I agree we need enforcement, and I am not for changing that type of any law to lower the charge or anything to do with that. But we all know the real issue here, and we've talked about in this committee 3 years now that I've been here, 8 years that Mrs. Representative Warren's been here, is the lack of help, rehab centers, and those type of things, treatment. I mean, that's really what the issue is. I mean, the two go hand in hand. So we're trying to do one part criminally, okay, but we haven't done anything with the other part of it or the other side of it, or very, very little. So the issue is treatment and rehab. That's what we haven't focused on. Do you feel that's true?
I would agree with that, Representative Costa, and I think there's a good reason for that. Because we still pool our resources in the criminal response, we're never going to have the appropriate resources to deal with these issues from a public health perspective. That's the problem.
Thank you.
Next up, I have Senator Searway.
Thank you, Madam Chair. Attorney Neto, I appreciate you coming. I have a question, and I heard, language is important, and I was listening to the presenter of the sponsor of this bill, and I want to know if a judge actually finds a person guilty with lack of evidence and the use of color or race, or their wealth is all factors in making a charge and making it stick to arrest, because this was brought up and I hear it all the time, and I've never heard a judge bring those things up. Usually it's, you have to have evidence, and it doesn't matter what person you are, and it doesn't matter your wealth. So what's your thought on that?
Well, I think we're starting at the end when we should be starting at the beginning, where criminal charges initiated, as Senator Searway, knows very well as an officer, is by arresting someone and charging them. And yes, people of color, Black people, and poor people are disproportionately targeted by law enforcement, and they're caught up in the system at disproportionate rates. Because of that, their cases are brought to district attorneys who decide whether and which charges to bring, which under the law, they can bring trafficking and furnishing, again, even with these very small amounts. And then ultimately, if somebody is found guilty, either at trial or if they plead guilty, a judge will sentence them on the charge for which they pled guilty. And it could be, based on the level of charge, something like furnishing or trafficking under the current law. So I'm not quite sure what
the question is, are these factors that I just mentioned, are those used in the court of law? Because it seems like you have to have evidence in order to prove a case. They don't use color in a case, and they don't use wealth in a case. Is that true?
Are the judges going to say on the record, well, this Black person is going to get double the sentence, or this person who's poor is going to get double the sentence? No. We're talking about implicit bias. We're talking about systemic racism. We're talking about disproportionate impact. So that's not evidence that's presented in a court of law. That's the person as the person is. What the evidence is, and this is why it's so easy, is all a prosecutor has to prove beyond a reasonable doubt for furnishing and trafficking is possession of a small amount of drug. That's it. Possession.
Possession, and also doesn't it have to, in this furnishing and trafficking, you have to show evidence of that happening as well. And I mean, you can have possession. Most cases, even in small amounts, get dropped or get deferred dispositions or bail, and they get the treatment, and then they get forgiven on their cases in most cases. And then now, and unless it's a serious offense and it keeps happening, then eventually they do finally charge them. But it doesn't seem like that's even being mentioned, that these cases get dropped or whatever.
Well, I don't know where you're getting your statistics from, Senator Searway, but I would be very hesitant to say that most cases get dropped or resolved in a way that's favorable to defendants. Most cases are resolved by plea agreement, meaning somebody pleads to something. Are there other ways to resolve cases? Yes, but as far as saying most or all these cases, I don't think that's true. It's definitely not my experience in my decade plus as a defense attorney.
Well, I've sat in courts and I've heard deferred disposition more times than I can count. And so I think that there are a lot of, but anyway.
I don't know where the statistics are, Senator. If you can provide me data, I'd be happy to review it.
Thank you.
Representative Pickett.
Thank you, Madam Chair. Thank you, Ms. Nettle. I think one of the reasons why we don't get to some real, how do I want to put this? I think when we keep putting in all of the things about disproportionate convictions against people of color and all of these things in, and racial bias and systemic racism and all this stuff, I really don't think that's something that really is conducive of trying to get to the bottom of what we're trying to do here. I think we got to take a look at this from an angle of everybody that gets charged with these crimes, regardless of the color of their skin, their ethnicity, their religious beliefs, whatever the case may be. Because when we get into those other little pigeonholes, then we turn around because, I mean, I may not agree with you on one part, you may not agree with me on another part, but it doesn't mean that maybe some of what you're saying is right and some of what I'm saying is right. But the bottom line is we have to come up with something where we can work together. So my question to you is this. We know that if there's any type of fentanyl in anything that's being carried on the street with somebody, regardless of who they are, what or the color of their skin or anything, there really is no purpose for that fentanyl to be with them at all. Because it's for medical reasons, okay? In my opinion, there's no reason for anything to be being carried on the street with them. Okay, and that's my opinion. Because fentanyl is a killer. Fentanyl is one of the biggest reasons why we have the overdose, because people are taking a drug thinking they're taking something and they're taking a drug that is laced with this stuff. So that's one thing. So when you get somebody comes into your office and they come in to hire you as their attorney, do you actively, and I assume you do, but I just want to get this question out there. I assume that for the best interest of your client, you're going to work in whatever way you can to try to get a successful resolve to their case. So are you able to do, finding friction, or are you able to find, is the district attorneys that are handling these cases, are they willing to work with defense attorneys from your perspective to try to come up with something that if someone really is addicted and they really are in a bad situation, to try to work with you to get some help for those people as part of their sentencing? I think that's where we have to start there, because I agree, we can't arrest our way through this. I understand that, I agree with that. But we can't just throw the laws out either. We have to have a balance here. And we have to take, and if we're going to shift into something else other than having a sentence hanging over someone's head to get them into help, then we have to have these other things in place so we can start using them. And that's what we're trying to do with other bills to try to get that accomplished. But right now, when you're handling a case under present law right now, I assume you do everything you possibly can to try to get a good resolve, including getting them into treatment if you possibly can. Is that correct?
Okay, so I'm hearing about 10 different questions. I'm
Sorry,
gonna
I
go
didn't
back.
mean to.
So it was just a lot, and I understood you had a lot to get out. But going back to the discussion of racism in our drug laws, you don't have to agree with me or the data or Representative Talbot-Ross or Senator Hickman that our laws around drugs are racist in order to actually look at them and say, do they make sense? Do these two laws make sense? Does basic possession of certain drugs alone create furnishing or trafficking? Let's take race out of it. Let's just look at those two laws as they are written and as they can be prosecuted. Does it make sense? Do we need them? Is it helpful? And the answer to all of those, from my perspective, is no. Absolutely not. And regarding clients who come into my office facing charges like felony possession for the possession of 0.2 grams of something that might contain some fentanyl, or facing a trafficking charge because they have 2 grams of something that might contain fentanyl or heroin. Those are big charges. That changes people's lives. I wish more people could come into my office when they're facing those charges, but let's be real, a lot of those people are stuck in jail, right? So we're already facing a problem there. Yes, we have some conversations with prosecutors. We might get to some points of agreement, but the truth of the matter is, when you give tools to prosecutors, they can use them. So maybe I can get a great deal for a client and get a reduced charge or some treatment and a deferred, like Senator Seaway was talking about. But prosecutors aren't forced into that. They don't have to do that. And with the law the current way it's written, it's very easy for them to prove beyond a reasonable doubt trafficking or furnishing with just basic possession. So they're not forced to be nice. They're not forced to help people get help. They can do what they want. They don't need that tool. We should take it away from them.
Follow up, Madam Chair.
You may certainly have a follow-up. I will remind you, we are on the second testifier and we've been a long time. So I'm happy to stay here, but I just want to remind you that we are on the second testifier. Representative, please go ahead.
Thank you. And I think Ms. Neto, I think that you have then now boiled this down to where we need to be. You're exactly right. We have to take a look and put all this other stuff out, the racist, bias, racism, and all of this stuff out of the side, and look at exactly what the bill deals with the possession and whether that's furnishing or whether it's trafficking. And I agree with you with that. But I just think the other stuff in there just complicates the issue, and it sometimes puts people at different sides of an issue that they don't have to be on the different side, because we all want to work the issue and come to a resolve that's going to be good for everybody. And as far as tools go, we can give prosecutors tools, but we can also, through the law, give defense attorneys tools, and they're going to use them to their best interest. So that happens. So I would just ask you this: if we can get to a point where we have the possession part and it gets removed out of there as far as by weight, the weight of whatever a person has. We know one person might have their daily use might be this, and another one might be that. We all know that. We're not, and it's hard to measure that. But if we get that put aside, then would you agree that that is a good starting point to try to really get to the bottom of what we need to take care of?
I think this bill does exactly that, Representative Pickett. It takes away just possession, cranking it up to furnishing and trafficking. And then the other part, like I said, even the prosecutors agree. No more sentencing disparity for crack and powder cocaine. I think that makes a lot of sense too. So what you're saying, I 100% agree with, and that's what this bill will do.
Thank you very much.
You're welcome.
I hesitate to ask any more questions for Attorney Neto. Seeing none, thank you.
I get paid hourly, Charlotte. That's why, Representative Warren, that's why I can talk a lot,
Thank you. Thank you for being here. There were great questions and I appreciate it. So next up, we have Carrie Morissette and then Mickey Rice, and then Megan Sway. Good afternoon.
Hi, everybody. My name is Carrie Morissette, and I am the Executive Director of the Church of Safe Injection. I am voting in support of this bill today from my personal lived experience in this exact matter. Although now I am a member of the harm reduction and recovery community, and I do live a abstinence-based recovery life. I am a person in recovery, and I am a 28-time felon, and most of those felonies are for possession, but a bunch of them are for possession with the intent to distribute and trafficking charges. I know I can speak for myself and other people in active using that the profiling that goes on by the police and like the systematic oppression that comes along with like being unhoused or having substance use disorder or being a sex worker is like instant profiling. I do agree that this bill could be like a really good start to something amazing. Do you think the details could be fine-tuned? I know that moving 2 grams, which I also don't agree with. I think that, you know, the weight of fentanyl should be the same as weight for any other drug. But I do believe that putting it into the presumption category, you know, it is a start. But I also believe that, you know, law enforcement, unfortunately, are given the power to take advantage of people with substance abuse disorder. I cannot tell you how many times I was arrested for possession with the intent to distribute, and being that I was in active using, they told me, oh, just plead guilty and we'll let you out of jail. And because I was in the midst of my suffering, I would sign whatever paper they needed me to sign just so I could get out of jail. I mean, it's not fair and it's not perfect. And I do think like these need to be worked on, but I also think that like this is like the beginning of an olive branch. I do know that like along with this bill, I do feel like that there would be something that would need to hold law enforcement officers accountable for this. I mean, you can't find somebody with their personal use and decide that you want to, you know, charge them with trafficking just because there's 3 people in their tent in Deering Oaks using, and they want to assume that they got it for this person. I do believe that if it's moved into the presumption category, if the police are held accountable, they can do something about it. And I just lastly want to say to Representative Costain, who said that he feels that incarceration is like the right way to go with this. In my experience, most people that are overdosing from opiates is because they've been sober for a while or because they've been incarcerated and they get out and they no longer have this tolerance. So just because we're throwing people in jail does not make their mental obsession for substances stop. So if we keep throwing them in jail, it's only, we're just going to keep losing people. It's not going to change anything. Thank you.
Carrie, thank you for your testimony. Representative Costain.
Thank you, ma'am, for coming today to testify. Just to set the record, I don't think we should be throwing people in jail. I think my comment was, I think we should spend more time on rehab instead of doing that. Thank you.
Thank you, Representative. Ms. Morissette, because you're an expert, I want to ask you these questions. You do the work, so you're actually somebody that's saving lives. We're going to hear later from a district attorney probably about their only way to save lives is this. You actually are saving lives by doing the work that you do with the Church of Safe Injection, and so thank you. Also, you understand more about what's happening out on the ground, I should say. And so can you help? I think that, you know, when we have bills in front of this committee dealing with drug policy, we have a Maine Drug Enforcement Agency Director McKinney will come in and say the word fentanyl probably 73 times, right? It's very scary. We get told all about the size of what you need and how it'll instantly kill. So it's like, it's this very scary thing. And we all know that it's a very scary thing. And we also know that we heard the story of Senator Hickman and why fentanyl is used. Out on the street, is there really any supply that doesn't have fentanyl in it right now?
That's a great question. We have had 5 overdoses this week from fentanyl-laced pressed Xanax bars bought off the dark web. We are constantly handing out fentanyl test strips, and we constantly collect data on that. And it's gotten to the point where like we've tested marijuana and found fentanyl. Everything has fentanyl in it. And I want to back up to I can't remember exactly who said it, but they were asking what is the medical reason to carry fentanyl or to carry these drugs. I mean, and as somebody that not only is in this field, but as somebody that has lived through substance abuse disorder in the past, like substance abuse disorder that's a medical reason. Like you guys might not identify it as a reason, but most substance abuse disorder stems from mental illness and trauma base. So these people are self-medicating to numb themselves from like messed up stuff that's happened in their lives. And like it might not be medically recognized, but that's a medical reason. And it's just unfortunately illegal. And I do agree that like, there's a lot of bills in session right now that is going to be great. And I do agree that like more treatment is needed, but I also agree with Representative Pickett, who sorry, not Representative Pickett. Who said it? I'm sorry. The Senator Hickman said that like it's unfortunate, but it is on the street. Like it shouldn't be there, but it is. And unfortunately, there's nothing we can do to like evaporate all the fentanyl off the face of the earth. But like the only thing that we can do is like try to approach the situation with compassion and like try to make sure that people are as safe as they possibly can be.
Thank you. Thank you for that. Any questions for Carrie Morissette? Seeing none, I'm going to go to Mickey Rice and then Megan Sway.
Hello again. So thank you to all the members of the committee for hearing my testimony in support of LD 1675. So when listening to the public hearing recently for another drug reform bill, someone that was opposing the bill at the time had said that possession in Maine is not treated as a felony, and that prosecutors have the discretion on what to charge with. My question is, why should it be left up to discretion? Why should someone have to pay a steeper price just because they have a certain amount of a drug on them? There's many reasons why somebody might have a certain amount of a drug on them, and it shouldn't be the sole reason that a police officer is able to charge them with trafficking. Let's not joke here. It's not like we don't have possession charges. It doesn't get rid of the possession charges. If someone possesses a drug, they should be charged with possession. If they are trafficking a drug, they should be charged with trafficking. And there's ways to find out if to charge people with trafficking. It's called evidence. And I just wanted to also, I'm like going way off from my written testimony, but I also want to let you know, as you know, I have been in recovery. I also graduated with a bachelor's degree. If I had been arrested and charged with a felony, I wouldn't have my bachelor's degree right now because I wouldn't have qualified for the grants to get my bachelor's degree. If I had been charged with a felony, there's a lot of jobs in the social work field that you can't get with a felony record. You know, and so I keep hearing the same thing in these hearings when it comes to drug reform, is that we can't take away the police's tools that they have. They have other tools to use, and we shouldn't be criminalizing people while we're waiting to get all of the services that we need. We're never going to be, perfect for social work and mental health in the state of Maine. And so criminalizing people in the meantime isn't helping. And then I just wanted to say one more thing. And, being clear that I'm in recovery, it could lose me future jobs. But I'm in a methadone clinic right now, and I've talked to people that, to counselors there. And I've been told straight up by at least 3 counselors there that anytime, that 99% of the time when they test somebody and it comes back for fentanyl, they talk to the person and the person didn't realize they were using fentanyl. They're got, heroin, and, we're thought that they got heroin and we're told it was fentanyl. A lot of people don't go out with the mindset of, oh, I'm going to go get some fentanyl. Like, that's not how it is. Representative Warren is 100% correct in that. So I thank you for listening to my testimony today. And I really hope that you guys that you guys and gals take a hard look at this bill and really consider it, because all it's doing is asking you not to criminalize somebody for trafficking when they're not trafficking. Thank you.
Thank you very much for your testimony. Any questions for Mickey Rice? Seeing none, thank you for being here. Next, we have Megan Sway. Hello.
Hello. Senator DeChambeau, Representative Warren, distinguished members of the Criminal Justice and Public Safety Committee, good afternoon. My name is Megan Sway and I'm Policy Director for the ACLU of Maine. I wrote really long testimony, but I'm going to try to keep this fairly brief because I know you all have had a long day. I wanted to get back to the goals of this legislation because, as Representative Pickett mentioned, we want to make progress, and that's what you all have been working towards all session. And I think this bill provides a powerful way for us to do that. We've heard throughout this session and today that most drugs on the street have fentanyl in them. We have heard that the way that our drug laws are written, if you have 2 grams of a substance that has any amount of heroin or fentanyl, you are guilty of drug trafficking. And we have heard that people use much more than that in a day. And so what we have is this law that is not actually targeted at what the legislature is trying to do. And I think the efforts in this bill were, let's do what we want to do, which is provide pathways to recovery and help for folks who are ready to take them. And let's take away barriers that are there that we put in place in good faith because we wanted to stop people from trafficking drugs, but that are so overly applied that that anyone walking down the street, not anyone, but many people walking down the street could be caught with this law, even though they're not trafficking. I think folks before me and after me will talk about the different reasons why people use drugs or why they will have 2 grams on them. But the other thing that we should think about is what are we asking of the government when it takes away someone's liberty? And I think that's the ACLU's lane here. Usually when you have a crime, the state has to prove every element of that crime. With trafficking, we've made it different, but it's not all trafficking, it's just heroin and fentanyl. And we've said, okay, government, you don't have to do what you have to do in almost every other crime in the code, which you guys have your verticals, they're very big books. Like with hundreds and thousands of other crimes in Maine, you have to prove intent. You have to have this element. In an effort to go after trafficking, we have let the government out of that thing that we require in every other case, almost every other case. This is wrong. It doesn't have to be this way. And what you have heard is that people are getting caught up with felony drug trafficking charges, even when they're not trafficking. This bill provides one way to deal with that, and I urge you to support it. Thank you.
Thank you, Attorney Sway. Questions? Seeing none. Thank you.
Thank you all. I hope you have a great weekend.
Thank you. You too. Next up, we have Winifred Tate.
Thank you. My name is Winifred Tate. I'm the director of the Main Drug Policy Lab at Colby College, a resident of Waterville, and I'm here to testify in favor of LD 1675. I will be posting my written testimony, which reiterates many of the points that have been said here today already, but I just want to highlight a couple of the key points. The first is that 2 grams is a tremendously, obscenely small amount. It's less than an ounce. It's 0.0041 pounds. And to consider that evidence of trafficking is frankly, on the face of it, absurd. And I also want to emphasize that I have talked to directly many people through my work on the impact of drug policy incarceration who have been charged with trafficking because of their high levels of personal use. And I want to share one story, the words directly from a woman who shared her story with me and wanted it to be brought to the policymakers' attention. And she said, I had a 10 gram a day habit of heroin. I ended up getting busted for aggravated trafficking, but it wasn't even true. I did tell them that, but because of the amount, it didn't matter. They, meaning law enforcement and prosecutors, have a hard time believing that people would do that amount of drugs. But I mean, when you've been doing dope every day for 7 years, it progressively gets worse. It's not like you get better. You don't start doing less, you just do more. I was feeling sick. I was trying to stop. I was in a really bad place. I looked at my lawyer and I looked at my sleeves and I said, come on, dude, it's personal use. It's obvious I'm strung out. I was 102 pounds. I was in bad shape, but they still wanted to charge me with trafficking. I also want to echo Carrie's point that there is a medical reason, as she said, for people to use fentanyl, and it's called substance use disorder, which we all now agree is a public health crisis and a medical disease. People buying on the street to self-medicate do not know what's in their drugs because they are illegal and unregulated. Fentanyl is a terribly addictive substance, but it is not out of the realm of other drugs that we see. And if you look at the overdose death statistics, they come from polysubstance use for people who are immediately released from incarceration. And I think that the real work of this bill is demystifying this notion that any amount of possession or small amounts of possession is the same as trafficking, because that's just not what's happening in Maine. I wanted to end inspired by Representative Hickman with a Maya Angelou quote: do the best you can until you know better. Then when you know better, do better. I think Maine knows better, and it's time to do better with our drug laws.
Thank you, Professor Tate, for that. And thank you for ending with Maya Angelou, one of my absolute favorites. Questions for Professor Tate? Thank you very much for being here. Next up, I have David Getchell. Welcome again. Thank you for hanging out with us today.
Good afternoon, Senator DeChambeau, Representative Warren, and distinguished members of the committee. It has been a long day, but I'm thankful that you guys have been here listening to all of these important bills and this important testimony. Once again, I'm going to pivot a little bit from what I had planned, because there's something that I brought up when we talked about LD 967 that I feel like needs to be brought up again, and that's called the iron law of prohibition. There's multiple articles that have been written on this phenomenon that I'd be happy to share with members of the committee if they'd like to see this. But the gist of this iron law of prohibition is the more we criminalize a substance, the more potent that substance becomes, because it's easier for traffickers and for people who use that substance to conceal that substance. So we've seen it in history with alcohol, with prohibition. The most preferred substance was beer and wine, but when we outlawed that, it became rum and moonshine. And then we had people getting methanol poisoning and going blind and dying. It happened again with cocaine. We used to have cocaine in Coca-Cola. It was a very small amount and people could get their Coca fix through Coca-Cola. But then we made Coca-Cola illegal. So then we saw powder cocaine, and then we saw crack cocaine. And now we're seeing it again with opiates. Housewives in the in the 19th century and early 20th century could walk into a pharmacy and buy little tins of heroin that they could use. We outlawed that, and then we forced people to go to a black market. And so what happened was little amounts that people use to get through the day become more and more pure. And now we have people dying from fentanyl overdoses because they're taking substances and they don't realize that fentanyl is in it. And we've heard testimony from that already today. And this is a direct problem from criminalizing the substances. And so what we need to do is take a step back from criminalizing these substances. And with this bill in particular that we're talking about, getting rid of trafficking as a way to punish someone when what they're really doing is dealing with their health condition. And I'm going to keep hammering it because it is a health condition. Substance use disorder is a health condition. If you need to take drugs to get through the day, you need to take drugs to get through the day. I mean, I know people who literally are like, Davey, if I didn't take drugs, I would probably jump off the Casco Bay Bridge. You know, drugs are what keep me from offing myself. Like, that's something that people have told me. Like, so we just need to recognize that these people are suffering and they have humanity that we need to recognize. And so stepping back from criminalizing, and Representative Pickett, you hit on it. We need to help these people. We need to get them into treatment. We need to get them into services that help them deal with the problems underlying these conditions. And in order to do that, we need to take funding away from prosecution, from criminalizing, from incarcerating people. We can take that money and we can give it to other things. So please, ought to pass. Any questions? Hit me with them.
Thank you, Mr. Getchell. Any questions from the committee? Seeing none, thank you. Thank you for hanging out with us today.
Y'all have a great weekend.
You too. I'm still looking for folks that are here to testify in support of LD 1675. And if you're here to testify in support, please raise your hand. Oh, I see Joseph Kubetz. Welcome, Joseph. Thank you for being here.
Yeah, thank you all for being here. This is a privilege to join all of you. I've got to follow Representative Pluker and Rachel Talbot Ross and Senator Hickman, who you called my senator. I'm from Portland, but after hearing him, I would consider him my senator. So
You
thank you all
can't
for
take
being
him,
here.
so don't even try.
Want to invite you, I know you've been sitting all day to stand and stretch or wiggle around if you need to. Know that we call sitting itself is the new smoking. So feel free to stretch if you need to as I offer my testimony. I think that's also a segue into sitting as the new smoking. We view smoking as a public health issue. We don't lock people up for smoking a cigarette because we know it's addictive. We know people get caught in a trap. And we view it as a public health issue. And we've come around on that. I'm a person in recovery myself, and I know it's because I've had a lot of support and help that I've been able to turn things around. I want to jump right to something that's been mentioned a couple times, and I want to use this metaphor. If we criminalized snow, in the state of Maine, we've got a lot of snow, and if we criminalized snow, but made sunshine perfectly legal, obviously we would have an issue with that in the state of Maine, and we wouldn't like it. And I think that's an apt metaphor for the cocaine crack distinction, that it is a fact, and this is well researched. I just encourage people to look at this a little bit, that crack tends to be in inner cities and cocaine tends to be in suburbs, very much so. And obviously there's a racial disparity there, and it's something we need to fix. So if I'm someone who lives in the suburbs in where there's more cocaine, I only get a very small amount of a sentence. Obviously that's not right compared to someone who just happens to live in an inner city, who happens to be Black, and they get a far greater sentence. Also want to note, we're a country, the US has amazing poets. We have amazing universities, lead the world in science and technology. And the other thing that we lead the world in is locking people up in cages. You drive by a prison and it really hits you. We're locking people up in cages. Over 600 for every 100,000 residents, and that's the most in the world. So insanity is doing something over and over again and expecting the same outcome. So I think we really need to do something different. Maya Angelou said, you may beat me down with your bitter, twisted lies, but like dust, still I rise. And I've been able to rise up, I think, because I've been given second chances and I didn't get convicted of crimes, even though I should have been. And I was able to recover. So I was able to rise. And I think we need to give our fellow Mainers who are struggling with a public health addiction, just like smoking cigarettes, a chance to rise back up.
Thank you very much for being here and delivering your testimony. Questions from the committee? Seeing none, thank you again and congratulations on your recovery, and thank you for sharing that with us.
Thanks for letting me be here.
Next up, we have Michael Mosley and then Adam Zuckerman.
Hello, and thank you. I'd like to say good afternoon to the members of the Criminal Justice and Public Safety Committee. I'm going to take a different tack here. 27 years ago, a top Nixon official, the domestic policy chief, John Ehrlichman, made a public statement. And that public statement was this: we knew we couldn't make it illegal to be either against the war or Black. But by getting the public to associate the hippies with marijuana and Blacks with heroin, and then criminalizing both heavily, we could disrupt those communities. We could arrest their leaders, raid their homes, break up their meetings, and vilify them night after night on the evening news. Did we know we were lying about the drugs? Of course we did. So as much as people don't like to hear it, if the reasoning for a policy is illegitimate, then so is the policy. If the reasoning for a policy is racist, then so is the policy, but so are the tactics used to promote that policy. See, we've used the war on drugs to proliferate the worst and most brutal aspects of the war on drugs. I'm talking about harsh and rigid sentencing that makes no sense, as people have spoken to, no-knock raids, militarized police. All of these things are a justification that 60 years ago, someone made for political purposes to target hippies and Black folk. And yet we still pretend like the entire system that came about from these decisions is somehow legitimate and justified. But it's not. It hasn't been. It never has been. And you can look around and ask yourself, what was the purpose of these policies? And if the purpose of these policies was to disrupt communities, does it look like our communities are disrupted? Sure does to me. Does it look like we've lost leaders? Sure does to me. Does it look like we have been vilified night after night on the news? It looks so to me. And if you want an example of people associating heroin directly to Black people, look no further than our previous governor, who made the national news for doing so. It's a system that is self-perpetuating, and the only way that you stop it from self-perpetuating is to remove yourself from it. And it's about time that we did that. So I am asking you to vote ought to pass for that reason.
Thank you for your testimony. Any questions for Michael Mosley? Seeing none, thank you for being here. Next up, we have Adam Zuckerman. Welcome.
Oh, thank you for having me. Just unmuted myself. Senator DeChambeau, Representative Warren, and honorable members of the Joint Standing Committee on Criminal Justice and Public Safety. My name is Adam Zuckerman, and I'm the lobbyist for the Maine People's Alliance. Our 32,000 members stretch from Kittery to Fort Kent. We are committed to creating a state of Maine where everyone has what they need, everyone contributes what they can, and no one is left behind. I am here today to testify in favor of LD 1675, Assistant Majority Leader Talbot Ross's act to amend certain provisions of the Maine drug laws. Maine's felony drug trafficking law has been derailing lives for minor drug possession for years, imposing serious prison time and burdening people with lifelong criminal records. Our drug trafficking law is out of step with most other states in the nation. It has created significant racial disparities and has harmed Mainers with substance use disorders for far too long. Our punitive drug laws trap people with substance use disorder and punish them with long prison sentences and a lifelong criminal record. Every year, Mainers are locked up for drug trafficking felonies simply because they struggle with the disease. That's because, unlike the vast majority of states in our nation, prosecutors do not need to prove intent to distribute. That means that all over our state, Mainers are locked away for drug trafficking for possessing extremely small amounts for their own personal use. I can only imagine what the reaction would be if we did the same thing with other laws. Imagine if when you purchased a firearm, you were charged with attempted murder. Yes, there's no evidence you had any intent to commit murder, but you possessed it. The same is true with our drug trafficking laws. They undermine one of the most basic principles of our judicial system: innocent until proven guilty. There is no presumption of innocence for people who struggle with substance use disorder. That prevents them from accessing housing, getting a job, getting student loans, making it nearly impossible for them to overcome their disease. Our felony drug trafficking law has been enforced in a racially disparate manner, disproportionately impacting Black people. As we heard before, Black individuals represent less than 2% of Maine's population, yet account for 21% of Class A arrests and 15% of Class B arrests. I have some more statistics here, but I won't go over those because we've heard them all already. Basically, this means that certain laws say that a person has to have 3.5 times as much powder cocaine on them as crack cocaine for the same penalty to apply. It's one of the most blatant forms of discrimination, a modern day 3/5 compromise written into our drug laws. This bill is not just about drug laws, it's about who we are as a state. Do we want to continue to treat people who struggle with a disease like El Chapo, locking them away for years? Do we want to continue to deliberately target Black people? Do we want to continue to subvert the presumption of innocence, one of the most basic tenets of our justice system? Or do we want to live up to the promise and treat our fellow Mainers equally and compassionately? I know that we can, and I believe that we will. You have the power to vote ought to pass on LD 1675. Thank you. I'd be glad to answer any questions that you may have.
Thank you for your testimony, Adam. Any questions from the committee? Seeing none, thank you very much. Anyone else here to testify in support of LD 1675? Please raise your hand. Seeing none. Those here to testify in opposition to LD 1675, and I'll start with DA Lynch. Welcome.
Good afternoon.
First of all, I just wanted to say hi. So Senator DeShamble, Representative Warren, and I hate to call out Representative Talbot Ross, but I've also missed seeing you. I spent a lot of time with you. So first of all, it's just great to see you. My
you as well.
What I had planned to do today was to read the testimony on behalf of the Maine Prosecutors Association, which you have in front of you. Attorney Neto was kind enough to repeat that testimony, and I've sat and I've listened to this, and so I think I'm going to just spend a short amount of time. You have the testimony responding to it. First of all, we're all on the same page, and we all have the same goals. And this is not a situation of us versus them. And I wasn't planning on doing this, but I'm going to tell you why I ran for office, because I think it's important that you at least know who I am. And it's a little bit difficult for me not to be emotional about this. I had to identify the body of a friend's child. This child had been in my car. He had gone to school with my children, played baseball. And Sean Yankowski, and I think many of you are familiar with the stories of the Yankowskis. They were friends of mine. I knew these two children. They lost 2 children in 9 months. And I say children, they were in their 20s, but all of us as parents know that. That was the sole reason. That was my motivator to run for office, because I wanted to affect something at a policy level. Some of you also know my backstory. I came to law late. So I practiced as a social worker, was a case manager for a lot of years in Boston. Like Ms. Neto, I also work to defend people. I care very much about my clients. But I ran for this office, and why I'm in this office, just so that you know that I'm not a tool. I'm not somebody that's interested in a jail count. And I couldn't agree more that we're not going to prosecute our way out of this situation. And again, I'm sorry if my voice is shaking, but the weight of these 2 boys I carry with me all the time, as I do other people. Very small amounts of fentanyl kill people. And for whatever reason, we have decided that mentally ill people, the problems of drug addiction are landing squarely in criminal justice. And what we're asking for you on this bill is not to work with you on it, but to preserve our ability to send people who have this charge to a diversion. I run a drug court. I put a lot of prosecutorial resources into my drug court to divert it. I run the only prosecutorial diversion program for people who have drugs to keep them from having that. I am so happy to be in a room with people that are so passionate about this issue, but I wanted to make sure that you knew who I was and that I'm rowing in the same direction.
Thank you, DA Lynch, for your testimony. Questions from the committee? Representative Pluker.
Thank you, Madam Chair. I'm just thinking about we're rowing in the same direction, which is great. We're looking to try to keep people alive, which is clearly the intent. And so are you thinking that when you're able to prosecute people for the small amount of drugs and put them in jail, that we're headed in the right direction?
So somebody who gets prosecuted, I'm sorry. All right, I'm on mute. So somebody who has a possession charge typically is facing a $400 fine. A $400 fine isn't stopping anybody from using drugs. Very often what we do, and again, I wanted to correct something else. Police may arrest somebody on a charge. The district attorney is the person who evaluates it and makes the charging decision. And very often we can use that. We have a very robust diversion program. We utilize drug court up here. And, if I could ask for something, we need more money for services like that. I created with the community up here, nobody pays for it, with the Bangor Area Recovery Network, a diversion program where I put people who have, drug charges or theft convictions, because we see a lot of thefts that are connected with drug use. So we're very concerned about using those. But if somebody has a possession charge and they get a $400 fine,
there's no motivation for them to do that. And are things perfect right now? No. What we're asking is that you not take a tool out of our toolbox that we can, you know, a lot of times people aren't really super willing to go to treatment. And sometimes having this Damocles sword over their head can get them there. Is it perfect? Would we like people to get it in the meantime? Yes. I was on call a couple of weeks ago. We had 4 overdose deaths, two double fatals. And I was on the phone the last 3.5 hours of this young man's life while law enforcement was in there. What's happening on the street is devastating. I take this very personally. And what we're asking, and I use every tool, everything that I have available, and that is including, you go get help. And, you know, if you do that, I'll reduce this, I'll dismiss it. Go into drug court, have some intensive services. Even you may not be ready, but this Damocles sword is hanging over your head and it may force people to do it. And that's what we're asking, is not to have a tool taken out of our toolbox. I just want to communicate that. I am now really speaking for myself, but, you know, I meet with the district attorneys. We are all in this together. We want to see, these numbers are just devastating.
A follow-up, Madam Chair?
Yes, please.
So you're feeling that while the $400 charge doesn't stop people from using drugs, a felony charge is more likely to stop them from using drugs. And if that is true, why are we continuing to see so many people die on a regular basis, just like you're saying? It seems counterintuitive that putting more pressure on people who are suffering from substance use disorder would make them less likely to use.
All right, I'm going to give you an example. So if you're charged with a theft or a drug possession here in Penobscot County and you don't have any other record, I really want to preserve your record. I don't want you to have a theft conviction, because I know that is going to derail housing for you, getting a loan, maybe getting a car loan, housing. There are a lot of collateral consequences. So I give you a choice when you come in. I say, you can plead not guilty on this. You come to my diversion program, which is 3 hours, and I do it over at the Bangor Area Recovery Network. So I force you to cross the threshold to the Bangor Area Recovery Network. If you're not familiar with that, it's one of my favorite programs. So, and then they come, they get, we teach them how to use Narcan. Everybody who attends the program can leave there with 2 doses of Narcan. We tell them about recovery coaching, domestic violence. We tell them, we have a program that comes in to tell them how to get a job. PCHC comes in, tells them about medication-assisted treatment. Health Equity Alliance comes in, talks about services to the LGBT community, which is very underserved, particularly if you have a substance abuse issue, and case management. So I force you to come in and get that. Now, I'm leading you to water. You may not drink it, but 1, I've made you an information ambassador, and 2, you leave there knowing where to go to get help. So some people will take that up, some people won't. And so on a felony charge, sometimes we do the very same thing. We say, we're going to defer your disposition. You're going to plead to this. And then we're going to give you a program where you go get treatment. You're going to work with Maine pretrial services. We're going to set you up with intensive outpatient services. And, you know, at the end of that, we may reduce that just to a fine case, but the Damocles sword, the thing that sometimes we're using is, this is the consequence for it. Is it a perfect system? Is it clinical? But 1, we're lacking resources, and this is a difficult disease to fight. And I agree with you, it's a disease.
So, Madam Chair?
Yes, please.
Can I follow up one last time? So,
Yes.
so you're saying it's a disease which needs a felony charge in order to get treatment. Is that your feeling?
When you've come into the criminal justice system, and this is a misdemeanor, you could go with a fine. So there's a minimum mandatory $400 fine. I invite you to sit in courtrooms all across Maine. People walk out with that. They're not getting treatment for that. They're not changing. There's no, you know, enhancement if you have 4 or 5 of these. And the result is people are dying. What the felony charge allows us to do in many cases is divert people into drug court, get people into treatment, because again, they've got this possibility that they may get a felony if they don't fulfill the terms of the deferred disposition. So it's a tool in our toolbox. That's what I'm trying to express. And I'm sorry if I'm doing it poorly.
Thank you very much. I appreciate it.
Representative Morales.
Thank you, Madam Chair. Thank you, DA Lynch. Can you guys hear me okay? Okay. Yeah, I think I hear what you're saying, DA Lynch, and I appreciate that we have the same goals, to have less people die, to have less people suffer. And I'm going back to the language issue that Senator Hickman brought up and was talking to us about. And I know you probably appreciate it too as a lawyer. We want our tools to be very clear, our legal tools. And it sounds like, from your perspective, you're using a legal tool not necessarily for the reason it was written and for the intent of it, but to get people into treatment. And so, we can disagree about whether that works and whether, that's best practices, but I'm really questioning, why we would allow that legally when it's actually not the intent. We're trying to use it to get people into treatment. We're not using it because we think people are trafficking. We're using it because we know that they need help. And that's where I'm sort of sitting with this. And the second piece that I'm struck with is I'm also wondering, how do you follow up with folks who are charged with felony trafficking? And, for example, I'd love to know from our different DAs, and this is a question I think for Jane for work session, how many charges from our different DAs offices do we have of felony trafficking? And how many folks do we even know survive? And do we follow down the line with what happens to them after they have that conviction, maybe a plea deal? So I guess some comments on that. I'm sorry, they're not super direct questions.
No, so if I look at your proposal, you're asking about to get rid of the grams, and then if it's packaged in 90 or more individual bags. So I think there was a question to you earlier regarding the bags, but according to the bill I've seen, you're also striking 90 or more individual bags. So the weight. Now, I wasn't here when they were doing this. I understand other people were, and there was a lot of information about how they came up with the 2 grams. And I don't pretend to be, and I don't want to represent that I was an expert, and I certainly have not had the opportunity. And that may be something that you look into. What the science was what was the thinking of your brother and sister legislators when that came in? And somebody smarter and who's been here much longer will do that. I'm not saying that this is perfect, but what I am saying is, at this point, we are desperate to use every available tool for whatever reason. And I think, Senator Warren, you and I have talked about this too, because we're women of a certain age that, a lot of stuff that was dealt with in the mental health world is now really landing in criminal justice. I spend more time doing social work today than I ever did when I was a social worker, trying to address this intersection of substance use, mentally ill, chronic homelessness with the criminal justice system. We spent a lot of time doing it. And I guess all I'm urging and what I would be saying is, don't take this tool away. And again, I think there's somebody following up from me, so I don't want to spoil his. I think we've discussed with some other compromises within our group. We continue to. I'm not saying a blanket on this. Again, we're in this together. It's like the pandemic, and this was the pandemic before the pandemic, and we certainly, things have not made it easier. I would suggest to you that the amount of deaths is consistent across the country, the rise in that, in part due to the pandemic. So I wouldn't say that our efforts are wasted on it. What I do want to make sure that you understand, and that you understand from me, is how passionate I am about this issue, and again, it's difficult for me not to have a catch in my voice. how personal this issue is to me regarding the deaths, regarding the treatments. It is ripping every town apart. It's ripping Maine apart, one family at a time and one community at a time.
Thank you, DA Lynch.
Thank you. Could I have one quick, well, I'll
Yes.
just say thank you and no follow-up. Thank you so much.
You're welcome to a follow-up, Representative Morales. You want me to come back to you?
No, it's more of a comment. So this is a hearing. Thank you.
Thank you for that. DA Lynch, I thank you. And I want to say that I understand the emotion. And I'll say right from the very beginning, the emotion that I get is pure rage because I've lost family members. My oldest friend in the world is gone. He bought cocaine on his birthday. He didn't know it had fentanyl in it and he died alone. So mine doesn't come across as sadness. It comes across as really, I am very angry. Rage might be the right term. So I was there when we came up with the 2 grams. It was my first session. We were working on drug sentencing reform. The Attorney General at the time was on the opposite side of myself and at that point, Senator Dion. And when the bill was going a certain way, we were in the back room in the clerk's office negotiating where the 2 grams what that level would be. It is not based on science. It was a negotiation by 3 people in the clerk of the House office. So that's the first thing. I was there. The second thing is I'm really interested in getting at the work session some of your evidence about the fact that you all save lives by forcing treatment. And I ask that question for a couple of reasons. One, we're losing 11 people will die this week in Maine. 11 people will die this week in Maine. I actually am a social worker. I know a little bit about what helps change behavior. Force doesn't ever change behavior. So I'd love to hear some of the evidence that backs what you all see as if we hold a felony charge, we can force someone to get help. And I'm going to ask for that for the work session. My third question is, I don't understand how this bill has anything to do with drug court. I don't understand how using, you're talking about taking away a tool. How is charging someone with trafficking who isn't actually trafficking a tool? And how does it have anything to do with drug court? If you know somebody is suffering from substance use disorder, why wouldn't you offer them the help? Why do you need the tool of a trafficking charge? Could you answer that question for me?
Yes, so the criteria for drug court has to be, are not misdemeanors. You have to be, in order to qualify for drug court, it has to be high risk, high need. And so the misdemeanor charges are not charges that are typically seen in drug court. I developed a program to deal with the other end of, so we have high risk and high needs over here for drug court. So those are usually where our felonies land. In the middle, many of the district attorneys will utilize on a felony charge a deferred disposition. So people that aren't qualified for drug court have a deferred disposition. And for those of you, and I'm sorry, I'm sure a lot of you people understand it, but I'll just review it. What you do is you come in, you plead to the felony, and then the disposition of the case is deferred. So it might be deferred for a year. During that time, there may be certain conditions that you have to comply with. No use or possession, go into inpatient drug treatment, do substance abuse treatment to the satisfaction of the supervising agency, and at times that's Maine pretrial services. There are cases where we can take the felony charge, if they've never been on probation before, reduce it to a misdemeanor, and then they're qualified for probation. So we can put them on probation with those terms so that people can use them. We've got a supervising agency to do that. We can do that with a felony and reduce it. That's another tool that we use with people who are charged with felonies in this case. And then finally, they don't get there without first having started, and very often it's these misdemeanor charges of possession or theft or sometimes just criminal mischief. And those are the cases. They come in, many people come into a program, and it's the only one offered in the state, my diversion program. I agree with you that the barn has inspired me. So the barn says, you just get them to cross the door. They don't have to be, you know, ready for treatment or everything. You just get them here and we'll take it from there, Ms. Lynch. So it's why I run the program at the barn. So at the very least, if you didn't listen for those 3 hours, you at least leave knowing where the Bangor Area Recovery Network is, so that when you are ready to get to treatment, you know where it is.
I'd love to see the stats for the work session on the diversion that you're doing. And you don't have to answer now. I'm going to be asking for that. You're muted. I'm asking for that specifically for the work session. I'd love to see the stats of these classes and what kind of diversion you're doing, because I still don't understand why, if the barn is asking you to bring people over, why don't you just bring them over?
Well,
why don't we just help people?
I am, but I tell people, because I'm in court and I bring, we used to have, before COVID, we'd have Health Equity Alliance in, offering people services. I certainly give them the pamphlets, but somebody walks out of court with a $400 fine, and I've given them information from the barn, they don't go there. On the 25th of this month, I know 17 people are going to be at the barn because I have almost 100% response rate for people that I added to. I wanted to get back because I am a little bit of a data person. So I was collecting statistics, but I had the same in-person program I was running. Then COVID hit. So now my new statistics are, I'm offering it by Zoom. So I'm having a hard time comparing apples and oranges. And then finally, I'm the only one doing the statistics. So all I can look at is, I invited you to this program. You didn't have a charge 3 months out, 6 months out, 8 months out. But the two programs don't look exactly the same way because we're doing Zoom. So I'll do my best, but it doesn't look like that. And I will be out for the next 2 weeks, but I'll work with Ms. Maloney to get you that. But
thank you,
Representative Warren. It gets back to the point. Drug treatment, mental health treatment, diversion programs, they do cost money. I don't have a statistician. I'm running my program. It's like stone soup, where everybody in the community came and put a little bit in. So I'm so thrilled that I can do that on a shoestring budget. But programs like the barn, programs like getting Narcan out. I've recently just spoken to the main prosecutors in Gordon Smith about distributing Narcan at arraignments, because who needs that more than somebody coming in and being charged on a misdemeanor charge of drug possession? So it's a radical idea. Not sure everybody's on board with it, but again, it's just something else I want to tell you about how passionate I am about this and trying to think outside of the box with it. I'm using every tool available.
Thank you. Thanks for telling me about that. I just one last comment and then I want to pass it on, but just a comment that Narcan is still a radical idea makes me really worried about our criminal justice system when 11 people are dying a week. But thank you.
No, I'm talking about distributing it in the court.
I heard exactly what you said.
Okay, all right.
Yeah,
So,
I mean, it's a pretty stark comment on what's happening. If we know people are dying and still distributing something that saves them in our court is a radical idea, that's a very interesting comment on our criminal legal system and whether it's meant to save lives or punish people. I'm gonna go.
I hope you'll support that initiative of mine.
I totally support saving lives all day long. Representative Morales and then Representative Pickett.
Yes, thank you. I have a question about specifically about this bill and about requiring prosecutors to prove trafficking, and whether the reason why you oppose it, from what I'm hearing from you, I think is because then you can't use that plea deal to get folks into treatment. Is that correct? That'll be more difficult to prove, take more time, cost more money, take more effort, so you won't be able to get folks into treatment. Is that why you're opposing having to prove trafficking?
That's one of the issues. You also have taken out, so again, it's not just the weight, but when you look at the bill, you're also taking out the packaging. It also, you're also sort of confusing the issue. So you can have one person carrying the drugs, one person carrying the cash, and somebody else with the phone and the ledger as well. So it's, it makes the prosecution, very difficult. Safety is an issue. Keeping them, keeping the drugs out of here is important. And there's a great book, Narconomics. There's a whole economy around this as well. And I think if the message is it's easier to, have these large amount of drugs on you, we don't, and remember, juveniles are subject to this too. Do we really want to say it's okay for possession charge for juveniles to have this? And again, it's a teeny tiny bit of fentanyl, that can kill somebody.
Representative Pickett.
Yes, thank you, Madam Chair. Thank you, DA Lynch. I just wanted to thank you for bringing your testimony to us and for giving us another way that you thinking outside the box and with your heart being in trying to want to help to save lives and help people. It may not be agreeable to everybody that that's the best way to do it, but I applaud you for it because at least you're thinking outside the box and trying to do something. Talk is cheap until you can actually start doing something. And you are taking it upon, you've taken it upon yourself to try to do that with connecting with this program. And I thank you for that. And I would just say that, and I would ask you this, that when you get, my question would be, when you get someone come into your office on a possession, and let's just say under present law, without this law, you get somebody come into your office under possession and they have 2 grams of heroin or they have that and they are charged with either trafficking or furnishing, or I guess trafficking would be what that would be at that point under present law. Do you, as a district attorney, when you look at that case, do you look at it just that they had 2 grams to trafficking, or do you look at it and look into the investigation which proceeds after the charge and everything, all the reports and stuff, to make a determination as to whether that person is really somebody who's trafficking or just somebody who had this amount on them and got caught with it, and then make a determination of how you're going to proceed with that?
Yes. So all those things come into account. So one, we're going to look at a criminal history. 2, people that are charged with felonies get appointed fabulous attorneys like Ms. Netto all the time, who is going to come and negotiate that case with me. Now, she's going to come and negotiate a case if she's up here with people who are very, like-minded and want to find it out. We're going to have a conference with a judge on that case. And again, our judges up here, I'm very beneficial to be at a place where, the judges care very much. Our judges live in this community as well. We're here. We know these people. And they are people. They're our sons, they're our daughters. So you're going to have a lot of input into that. And I would tell you, my district attorneys certainly hear it loud and clear for me about, what policies I've established, what my priorities are here in this office. So if there's a way to divert them into treatment, to get them treatment, that is certainly preferable. I couldn't agree with Senator Warren more. They're not going to get treatment in there. I think it'd be very helpful for this committee, to hear from people who have been through drug court, to hear what that experience was like in terms of stopping it. Because some people just get into drug court because they're going to serve less time And then despite themselves, they find themselves getting into treatment and getting better and stopping using drugs. So I'm sorry, I've lost my train of thought. So we do consider all those circumstances. I read very compassionate police reports as well when police are, trying to get them information, where a summons is also served with, a ride to a local facility or information about the barn or where to go to get medication-assisted treatment. Very happy. Bangor Police Department has a mental health, social worker embedded with them that often goes to these calls. So we try to get them treatment at the same time. We do pre-charging diversion with the HEAL program from Health Equity Alliance. So sometimes we never even see the people.
And thank you. And I would agree very much. We're all here in this committee. I think we all want the same thing, and we only can learn if we listen. And we have to listen to everybody who has a stake in the issue. And I appreciate for what you brought to the committee today, man. Thank you.
No, and I appreciate everybody's passion on here. I really do. This is really important, difficult work.
Thank you, DA Lynch. Any more questions for DA Lynch? Seeing none, thank you very much for being here.
Have a great weekend, everybody. It's
You too.
Been a long day for all of you.
It's been a long week. Anyone else here to testify in opposition to LD 1675? Seeing none. Anyone here to testify neither for nor against LD 1675? Good afternoon again, Mr. Hall.
Hi, thanks for having me. And I spoke earlier on LD 1478, which is a concurrent bill requesting a different type of decriminalization. I will attempt to be very brief to respect your time because frankly, your attention at this hour is amazing. To me, in isolation, calling possession, and trafficking, it feels like it makes sense. And especially having heard Representative Warren describe that the levels were really never based on anything. Since you're not actually providing any new behavioral health services, I do want to just ask that as you're considering various bills asking you to reduce or remove consequences of all sorts of things currently classified as crimes of a certain consequence, please just keep the larger context, consider when is actually the right time and right combination of new allowances. I have to say I admire the hack that DA Lynch found to help people despite a flawed system. Maybe it's worth considering what you can change that actually connects people to help in an intended way. In my unexpert opinion, it would be better to focus on fixing root causes before enabling unfortunate outcomes. Thanks.
Thank you, Mr. Hall. Any questions for Mr. Hall? Seeing none, thank you for sticking around and giving us testimony. Welcome, Attorney General Fry. Good afternoon.
Good afternoon, Representative Warren, Senator DeChambeau, members of the Criminal Justice and Public Safety Committee. I'm neither for nor against because I am supporting some of this. I have some opposition to some of this, and I do have an alternative to propose that I think addresses some of the problems that exist with the way trafficking and furnishing are addressed here in Maine. So first, I want to be clear that I support the proposal to treat cocaine the same as cocaine in the form of cocaine base. I'm unaware of any legitimate reason for this disparate treatment in the first place, so I encourage the committee to vote ought to pass on sections 3 to 5 of this legislation. Second, I am opposed to the complete removal of the ability to charge trafficking and furnishing of either heroin or fentanyl based on a specific weight or a packaged amount. What I'd propose in the alternative is simply moving that language from trafficking removing it as a per se definition of trafficking and putting it with other amounts of drugs and other packaging amounts that's found underneath presumptive inference definitions in the unlawful trafficking and unlawful furnishing statutes. So as we've talked about today, presently the state, if it has evidence of a specific weight or an amount of packaging, the state doesn't have to prove the intent of that possession. And that does operate in a very significant, harsh way on defendants. As it's written, the defendant cannot produce evidence at a trial that the possession of that amount was for possession or non-trafficking purposes. They have to depend on the prosecutor in those cases, and that doesn't always work. There is value in defining a specific weight or amount of packaging. It ensures that there's a level prosecution of these offenses across the state. It also is a tool that is used in prosecuting trafficking and furnishing of these drugs. But the more appropriate place for this to be really is in the permissible inferences statute. So under 17A MRS 1103 paragraph 3 and under 17A MRS 1106 paragraph 3, that's where you have other drugs that are not heroin, that are not fentanyl. That's where they are located. That is where there's a presumptive inference as to how you treat those drugs. To the extent that from a policy perspective, there is value in having that tool available, I'd suggest that the committee look at moving the language over there, taking it out of the statute as it's proposed in this legislation. I do want to express my appreciation to Representative Talbot Ross. She reached out to me in my office, and I appreciated her talking with me about what she was trying to do with this bill and hearing me out on what we were thinking. And I appreciate the committee's attention this afternoon. Certainly happy to answer any questions. Thank you.
Thank you, Attorney General Fry. Questions from the committee? Representative Morales.
Yes, thank you, Madam Chair. Thank you, Attorney General Fry. So I think what I'm hearing you say is that you do want to remove the strict liability, that just having this amount is per se trafficking, and that you want to move it over into a section where the prosecutor has to prove intent, but that there is a permissible inference there. And is that right? And then I have another question.
That is correct, because that permissible inference covers, large amount of marijuana, cocaine, methamphetamine, an amount of pills that are not heroin or not fentanyl. So it really, let's treat it like we treat all other drugs. That statute exists. Let's remove that per se application. That is my suggestion. Yes.
Okay, great. I like that a lot. And then follow up in terms of, are you suggesting that we move the entire section as it is, including the 2 grams, over, because the amounts in the permissible inference section are high, 14 grams of meth, and things like that. Do you think the 2 grams gives a permissible inference of trafficking based on what we know now from our public health experts and we know from our recovery folks about what people are using for personal use? Or are you willing to talk more about raising that amount?
I want to talk more about raising that amount. That is something, and hopefully I'm not speaking out of school, Representative Talbot Ross, when we met about this, that is one of the areas that we talked about, that, if there is agreement that this is better placed in the permissible inferences, a conversation does need to happen about what those levels are. I don't know that I'm in the best position to represent what that number should be, but I recognize that those numbers probably are not representative in the same way that 14 grams of cocaine, for example, creates a permissible inference. So that is a welcome to that invitation to have that conversation.
That's great. Thank you so much.
Senator DeChambeau.
Yes, thank you. I guess what I'm about to say, because the past 2.5 hours, I've been listening intently. First of all, I want to begin by thanking Mary Ann Lynch. I just could follow her so easily. What the AG Fry, what AG Fry just mentioned, his two recommendations. And I guess by telling you this, I'm showing off that I really paid attention to his testimony. So I would ask Senator Sailway to write this down. The two areas he supported are lines 25 to 28, and that's on page 160 of Vertigo. And then the second area he supports is line 34 to 38. That's page 166. And that one, interestingly enough, has to do with the use of a firearm. So I like something like this. I guess I'm saying, AG Fry, that I appreciate you didn't dump the whole thing, you didn't approve the whole thing, but you zeroed in on a couple of areas that I found palatable anyway. So thank you very much.
Senator Searway. Oops, you're muted, Senator.
Yeah. Thank you, Madam Chair. Attorney General Fry, I see where you do change some things on 3 and section 5. I think that the question is, and if it's not gonna, I'm just kind of concerned about when you start taking amounts of harmful drugs like this and you take it out, but apparently you're moving it when you're taking it out. Is that my understanding?
That's correct. It's moving it to where all of the other non-heroin, non-fentanyl drugs are spelled out as to how you prove trafficking. So if the state is able to show a certain weight or a certain packaged amount, that would be a permissible inference that the jury or the judge could accept to find that the person trafficked in those drugs. But it operates differently because it's not just proof positive that it's that way. A defendant would be able to provide evidence that says, well, no, that's not what it is. And frankly, a fairer result would occur, because if the focus is at getting at trafficking and there's evidence that that really wasn't trafficking, it is important that that evidence be presented before the fact finder. So it's keeping in the ability for the state to use a specified weight and a packaged amount. It just doesn't operate as a bludgeon like is presently the case underneath the trafficking and furnishing statutes.
Because I'm just concerned. I know many officers are concerned about this too, because once you start taking even small amounts, if they're trying to buy, sell, or trade or whatever, and you get trafficking and you got the evidence, then lots of times you can get them help, or you can get that person to help you get the big problem. And if you take the little problem out of the picture, then you can't get the big problem. And so that's a concern. So I just want to make sure we don't lose that capability. You know what I'm saying?
I do, and to the extent that it might provide some assurance, the proposal, I suppose, that I'm coming forward with, it doesn't remove heroin and fentanyl. It moves it to a place where every other drug is located for purposes of defining what evidence is needed to prove trafficking. The trafficking statute otherwise remains untouched. So if somebody is selling, if somebody is trading, if somebody is, if there's the other evidence that was described earlier by another person testifying, it's not changing the ability when that behavior is clearly trafficking to charge the person, whether it be heroin, fentanyl, or some other drug, right?
But it's taking cocaine out. It's crossing it out on section 3 and 5.
Senator Searway, we'll have a
I just-
chance to work out all of the details. This is a time for
Yeah.
clarifying questions.
Well, that's what I'm trying to clarify. I'm trying to clarify it before it comes to a session. I just want to make sure that that's not taken out. That's all.
Okay, I was not hearing you ask a question. Could you ask the specific question, Senator?
Sure. It on section 3 and 5, it does cross out cocaine, and it crosses it out cocaine on section 5 as well. So when you said heroin and fentanyl and not including cocaine, does that mean that's taking that out?
So I think I understand the question, Senator. So sections 3, 4, and 5 are simply removing the different treatment of what is chemically the same thing, right? So cocaine and cocaine in the form of cocaine base is the same drug. So by crossing that out, it's not removing the ability for the state to address that behavior. It's just removing a distinction that has no legal meaning. It's cocaine. And so it's not removing that drug, it's just treating it the way chemically it should be treated.
All right, thank you.
Thank you, Attorney General Fry. I have two last questions for you. Senator Searway just referenced that law enforcement officers are really concerned about this. And you've been now at 3 hearings we've had this year around drug sentencing reform. We had a bill, LD 994, to decriminalize syringes. We have 967, and now we have this bill, and you've been at all hearings. Have you noticed that not a single law enforcement officer has shown up to oppose any of these bills?
Well, I don't know if you include Roy McKinney as a law enforcement
Okay,
officer.
let's count.
But correct, it is correct that other than Roy McKinney, I have not seen anybody who would be considered a law enforcement officer show up in opposition.
Because what our law enforcement officers are asking us is for help. Because what they have to do is actually watch this continual cycle of incarceration. And that's why they're not here. And they weren't here on 994, and they weren't here on 967. So I just wanted to correct the record. Law enforcement are not opposed to this. They're not here. My second question for you, AG Fry, is when you talk about negotiating numbers from 2 grams to something else, could I ask that we listen to the experts who are the doctors who actually treat the people in Maine who are suffering from substance use disorder? Can we do that right this time? Does that make sense to you, what I'm asking you?
It does make sense. And I will be open to, we've talked a lot about data. I think I've paid close attention to the different presentations that have been made last year and this year. I think I've been very candid with those that have engaged with me on this, that I need some help differentiating anecdote from what has been tracked. I think I also was very clear last year, and if given the opportunity, I guess I'm taking it, I want to be clear this year. I suggested that increasing the amount was appropriate of what that threshold was. In fact, if you look back at my 1492 testimony, I said somewhere between the 0.5 gram and the 3.5 that was talked about, I want to have that conversation. So I will pay attention to the data, and that's what I would benefit from. So I guess that the answer is yes, I will pay attention to the data.
Thank you so much for that. Representative Pickett.
Yes, thank you, Madam Chair. Thank you, AG Fry, for being here this afternoon. I want to first of all thank you for digging into this bill and coming up with some, I think, real good suggestions on the bill for us to take a look at to see what we can craft out of this. And secondly, I would ask you this question, something that Representative Warren just spoke about, and I don't know, you may or may not have an opinion on this, but I'll ask it anyways. Do you think it's possible that the law enforcement officers haven't been flooding into these bills here, dealing with amounts of trafficking, furnishing, and all of this stuff, because of the fact they know that the Director McKinney, who deals with this stuff each and every day out there through all kinds of law enforcement officers throughout the state that are working in his department, that they are looking to him and looking for him to go and bring and have the conversation rather than flooding in here for us. Do you think that's possible?
Well, I don't know what law enforcement wants to have communicated. They're not showing up to oppose. They're not showing up to support. They're not showing up to say neither for nor against. So I don't have the same level of confidence in reading into what law enforcement wants, since they're not saying anything about what it is they want with these three bills. At the same time, I do, in the few conversations that I have had, I do think that there is a range of support that may exist in law enforcement to be doing things differently. And I hope that they hear about this and are motivated to send their representatives that I know they have, because they do come out to these different hearings, that they send out their representatives to articulate exactly what it is they think should happen, because they are the ones who are responding and who are being asked to do something. And it would be nice to hear from them directly as to what they want.
And if nothing else, with that answer, if nothing else, at least we've put it out there on mic that if we can't suppose that you are thinking something, we need to know that you're thinking so. So where the call has been made now, would you agree that now it's up to them to answer the call if indeed they have an opinion?
Well, I'm going to answer with maybe a non-answer. I mean, there are a few calls that I'm going to make, because I do think that input is important. And certainly if there's support for these measures, I want to hear it, because that certainly will be impactful to me. But I think, yes, I certainly think this is a public hearing. People know that law enforcement have beliefs that we're interested in.
And I think the support there is for all of us, because I think we all want the same thing. Everybody here, we do want the same thing. And again, I appreciate what you've done with the bill. I appreciate the bill sponsor for bringing the bill. And I hope we can, when it's all said and done, we can come out with something that we're all going to be able to get behind. Thank you.
Any other questions for Attorney General Fry? Seeing none, thank you very much for being here. I'm going to ask one more call for anyone here to testify neither for nor against LD 1675. Seeing no hands, before I close the public hearing, I'm going to ask committee members, is there anything you need from the analyst before the work session for this bill? Seeing no hands, we'll close the public hearing on LD 1675. Thank you, Representative Talbot Ross, for bringing this to us. Thank you, Senator Hickman, for sticking with us. And thank you, committee members, for a very amazing week. You've all put in so much time. Before we end, I want to do two super quick things, I promise. A couple members missed our unanimous ought not to pass vote today. We thought if we could get you on record, you wouldn't have to be chased down by Deb. So let me have Deb do that.
We voted ought not to pass unanimously on LD 1351 after going after suspending the rules and going to the work session. So I need a vote from Senator DeChambeau.
That one, I sent you an email. Yes. Is that the one that had 9 yeses?
Yes. Now it has
yes.
10.
Yep.
Representative Lookner.
Vote yes.
Thank you. And Representative Reckitt. You're on mute.
Muted.
Yes. Thank you. Now we have 12 yeses.
Yes, great. Thank you. Anything from you, Madam Chair, before we end?
Could I ask a question? Is that the only one that I missed?
I believe so. That was the
Okay.
first one.
Yeah, it was
Okay.
the only vote we took today.
All right, thank you.
Okay,
The
the
rest
rest
was
of
in
public
public
hearing.
hearings.
No, I just want to say, I know this is a Friday night, it's 4:35. And I applaud all of you who have stayed the whole day listening to this. I'm not an expert of the court system or drug laws. That's not my forte. But I stayed to learn more. And I again thank all of you for staying here today, including our poor policy analysts and our clerk for listening to all of this and having to bite their lower lip. So thank you very much.
Thank you, Senator. Thanks everyone for all your.
Good job, Representative Warren. I must say that. Thank you.
Thank you. Thanks everyone for your great work this whole week. It's been quite a week. So we're back at it Monday morning at 9 a.m. I hope you all have a wonderful weekend. See you later.
Hi, everyone. Have a good weekend. Thank you so much, Madam Chairs.
Thank you. Thank you, Jane. Thank you, Deb.